Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft. You're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft. You're charged with especially aggravated kidnapping. You're also charged.
Hello?
Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
Procedural matters, and unfortunately you have not.
Is not
You will bring jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict. Boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy.
Remember in the beginning, when we started 110 years ago?
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addicts live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican police, verbal slushing.
Is that correct?
I didn't ask you to interrupt me.
That's literally not true.
Oh, for Trump's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. A little bit of a rough morning today.
Banished from the state of Georgia.
No thanks, maybe later. There we go.
Hello?
And lots of things not working here. That's all right. Launch GUI. No, dismissed. Quit. How about that? Let's do quit. Quit's usually a good option when there's a problem. All right, welcome back. Thank you, sample user. I'm not sure who was first in chat today. But Kim R. Oh, there you go. Red Pen saves me. Kim R. won the internet today. Congratulations, Kim. You are the internet winner. Walker says, I keep hearing a male voice say hello. Is that a soundbite? Am I glitching? That's because people keep posting exclamation point hello like this, Kim. That's what causes it. Yes.
Hello?
Like that.
Procedural matters, and unfortunately you have not.
Hello?
That hello. That is a soundbite. Having issues with
Hello?
the intro. Yes, I lost.
Matters, and unfortunately you have not.
Okay. I lost the intro actually this morning. A couple things happened. I got up early this morning, was working on an edit for Top Mark Media, which is finally uploading, and finally got it to render. It took forever, and it was tying up one of the computers I needed for the live stream. So I'm like, I'll just let it hurry and render. And then I'm like, I need to upload it, and it took forever to upload. And it finally uploaded, and I was like 7-8 minutes late already, and then I didn't focus, and I just completely missed the intro. And so yeah, that's the problem. We fixed it though. There's no backups. Yeah, there's no backups. Barbara Russell was first. Barb Russell was first. Barb, were you first this morning? Red says it was Kim R. I was there. Red is the arbiter of truth. All right. Yeah. If you came in late, sometimes it won't load. It won't load the earlier comments before you, so it might look like you were first, but you just missed the earlier comments. Kim says it was me twice. I won first and second. There's no crying in baseball. All right. Welcome. I have been debating about whether we want to do the stream today with what we have. Okay. The Alaska Trail is so bad. It is so bad. The audio is just terrible. We're going to keep covering it on Top Rank Media, which is it's actually set up ready to go today for when they go live later today. We can probably cover the opening statements because those you can hear. But we might have to either just skip days on the trial, which is probably the best bet because there's body cam and interview stuff that we'll just have to get a summary somewhere else on. You're at pass. You're annoyed by it. Yeah, let's just skip it. Yeah, frustrating. Really frustrating. Because what's frustrating is there are people up there, there are crews up there who can do this perfectly. Law and Crime's up there. They've got equipment. They're in the courtroom, and they could do a fantastic job filming and recording this trial. And the judge, in his infinite wisdom, retains all authority and power and is screwing it over. Just, it's terrible. Let's see. Will we be covering the trial of the man that shot the judge when it gets a trial date set? That's the Kentucky one. Dragon, I think we are going to watch the Kentucky sheriff trial if it goes to trial. There's also some mental health issues at play. Sometimes that prevents it from really going to trial properly. If you say there's no crying in baseball to a 9-year-old boy after he strikes out, sometimes he cries harder, so I've learned. That's when you take him out of the ball game. I come here daily for the express purpose of being frustrated, Craters. I'm glad I can help. Carolina Hurricanes won the Stanley Cup against Vegas Golden Knights. Thank you very much. I saw my Twitter feed has exploded with video of the Carolina Hurricanes hoisting the largest non-participation trophy I've ever seen. It's pretty good. We have some birthdays to celebrate. Let's do that. Now that we've gifted the internet semi-appropriately. Selena, let me go back and see if I can get your milestone in just a minute. Let's do the birthday stuff because they've been waiting a long time. It's almost not their birthday. That's how long they've been waiting. We're closer to the next birthdays than this one. So, all right, wherever you are, if it's legal and you're able, stand up, take a breath, shoulders back, project your voice to the back of the room, and blend your voice with your neighbor and warm up with me if you will. La 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 la. All right, here we go. Happy birthday to Kelsey, John Amara, Kathy, Olivia, Kevin, Poppy's daughter, Lily. Happy birthday to you. Happy birthday to you. Happy birthday, dear Kelsey, John Amara, Kathy, Olivia, Kevin, and Lily. Happy birthday to you. Kelsey, John Amara, Kathy, Olivia, Kevin, and Poppy's daughter, Lily. Happy birthday. You realize there are many wonderful days, but today is your special day. Privilege, pleasure, the honor, the joy, that is ours. Hopefully you can turn that joy back to you, make your day just a little more special. And begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. Woo! Happy birthday. Did I miss something? If I missed something, it's because my brain... I had pancakes this morning as well. I had a double stack. So I had 3 small ones and 2 gigantic pancakes. And the only way to eat them, of course, is with butter. Not margarine. Please don't ruin them with margarine. But butter. So hot off the grill, extra butter, just melted, and then layer them one by one, build them. You put one down, then syrup. One down, then syrup. You don't put syrup under the base layer. However, that's how the heathens eat it. You do pancake syrup, and repeat until you're done putting pancakes on. You don't do syrup, pancake, syrup, because then you're just eating syrup with a side of pancakes. Anyway, and I got a mosquito that bit me on the side of the leg, and it itches, and I've been scratching it, and it makes it hurt more. So that's not good. Drum solo for the big finish here. Please pass the butter, yes. No milk, Dunkin'? No, but a glass of milk is appropriate. Happy birthday to you. Happy birthday, dear Carl. Happy birthday to you. Carl just snuck in there? Where was Carl? Carl got stuck on the back burner. I didn't realize you were talking about the birthdays. Oh, there it was. Buffer, add Carl. It was clear. You told me, and then Carl added, add Carl to birthdays. Carl, add Carl. I swear I was even looking at chat this whole time. This entire time I was looking at chat. Britt, the judge won't allow us to do Florida via Pinot. The judge has very, very strict rules, and although we could probably get away with it, that's not the way we run the channel here. So while court's in session, which might only be for another day or two, we're not going to live stream it. Now, if we choose to, after they're done, after there's a verdict, we could go back and do a rewatch with all the spoilers, which we normally don't like, but I've decided not to be the one that gets cameras kicked out. Yeah. All right. Can everyone put my dad's stepmom without some prayer? Stepmom's rushed to the hospital. We are some Mormon not doing well. Oh, true crime. For sure. For sure. And I think you should be on that list too, not just your dad and stepmom. All right. How was your weekend, everybody? How was, you know what? I realized something over the weekend. I grew up. I knew we were poor growing up, right? But I didn't know how poor. Like, I don't recall. The only time you went to the store to buy clothing was shoes. Because I had older brothers, and that's where clothes came from, was from the older brothers. But the only time you went to the store to buy clothing was shoes. And I think the thing that showed how poor we were, I remember when we got to upgrade our home lunches, like our sack lunches, from just being wrapped in plastic, like cling film. It wasn't Saran Wrap. Saran Wrap was the brand name. To getting the little baggie that you could flip the top over. And when I saw people that had those little Ziploc bags, that just blew my mind. What a waste of precious resources to have a Ziploc bag. Nowadays, we have a drawer stocked with all the different sizes of Ziploc bags, from, freezer, sandwich, gallon, you name it. We have Ziploc bags for everything. And but growing up, it was, you put your sandwich in the middle of the plastic and you just piled all the plastic around, and then you tried to dig it out later. Anyway, good old memories. By the way, it's the month of kids going to camps for us. So we've got one going this week. We have one going to Goodwill. Such a treat back then. Oh yeah, that was fantastic. I've got school photos of my older sister, cousin, and me in the same dress because clothes came from those two. Yeah, that's the problem. You go back, all us kids look the same as kids, right? Except for me, I had blonde hair for some reason when I was a little kid. But aside from that, you try to say, oh yeah, that's definitely me in the picture because I remember that shirt. And all my brothers are like, nope, I wore it first. It's the one that it looked like Ernie, from Sesame Street with all the stripes on it, the different color stripes and the collar. Like it was like summer play shirt, collar and everything. Ziploc for the rich. Yeah, not a sponsor. Not a sponsor. You can't hide that YouTube money. We got the good bags. We got the good bags. Mother used to wash all the bags and reuse them. Oh man. 2-gallon bags are best for carrying crochet projects. They make a 2-gallon? See, now, well, that sounds amazing. All right. That was Bert. Okay, I wore Bert's shirt. Like, it wasn't obviously the Sesame Street brand. That would have been too expensive, but I'm jealous. I'm looking for the 2-gallon bag now. All right. So here's the question. Do you want to hear the Alaska openings, just the openings, the 2 arguments? And then we can skip some days, and if the sound gets better when we stop watching videos, we can pick it up again, or we could just bail on it and go somewhere else. Because the opening, the audio is tolerable. I mean, it's good. The only thing we can't hear is when they watch body cam footage or interrogation video. That we can't see or hear anything. No, just bail. We got lots of no's. Okay. Here's what I can tell you. We're going to keep following the Alaska trial because we are in pool media on that, in the media pool on that. We're going to keep following that on Top Mark Media. But we'll skip and watch something else today. By the way, oh my goodness, I'm not sure when this happened. I did see on Twitter, and the mods were talking about it this morning. Judge Boyd got in trouble. So she got in trouble again over YouTube. I'm not sure if this is a new version of trouble, because this is not the first time. But yeah, I think it just took a while to work through the system. But does anyone have the Judge Boyd document? We can do a quick read on that. It's not a long one, I don't think. We'll see what the court's mad about. Courts need an audio guy. Every court needs an audio guy. The best part, though, is if you do it right initially, if you can hire the audio guy when you're setting up your sound system, you don't need him every day. Just once in a while. Brown-eyed wife, attorney for 29 months. OG says Sloth Life here celebrating must be too much, as I had a heart attack yesterday. Oh no, I'm in the hospital now. Introduce everyone to YouTube and RA for the best covered. Home tomorrow, hopefully. Sloth Life. First of all, you changed your name to Brown-eyed Wifey, which now we've made the connection. But don't have any heart attacks. That is not recommended, and you definitely did not ask permission. I didn't grant it, so I don't know why you would be doing something like that without permission. I never grant that. So please hurry and get better, and we'll see what we can do support that way. Please get better and get home. Selena K, attorney level for 38 months. OG. Wow, I've experienced a lot in the 38 months I've been here. Love my RA family. Yes, Selena, it's been amazing. 38 months is incredible. Guess who else hits 38 today? Tile Toys, Phil. I'm hosting a media pool party. That's sleeves not provided. You have to bring your own sleeves. That's going to be amazing. It's amazing. Don't pee in the media pool, people. Just don't pee in the media pool. That's my advice for the day. Plus, they have that chemical in where if they do, it changes color around you. Everyone's going to know if you pee in the media pool. All right. Let's see. No, exactly. I know. I actually feel okay. I just want to get home, get off the monitors. 6 p.m. I'm still okay. Oh, good. Do get better. Don't pee in any pool. It's probably better advice, Lois. Thank you for that. I was just thinking about myself there when I said the media pool, because that's the one I swim in. But Lois, let's follow Lois's advice for today instead. Don't pee in any pool. Lindsay LeBerg. Best day ever. First day of my staycation. Staycations are great. Underrated, for sure. Underrated. We're almost... This could be crazy. I've got 5 kids at home right now. 2 of them may be gone about the same time. One had a birthday over the weekend, by the way. Crazy. Another driver-aged child in the family. One's gone this week, and then I've got one that's going to be gone for almost a month because he has 3 camps and a family trip. First family trip. We're sort of nervous sending him off, on the plane by himself. But I think he'll do fine. Let's see. Staycation. Cheryl, member for 28 months. OG. Lindsay, you're also an OG. So happy to be here. Positive vibes to all. Thank you, Cheryl. Thank you for that. Uncivil Laws present. Kurt, good to have you here. Welcome. We're going to find somebody who's done bad things, and we're going to talk about it in just a minute. Yeah. What were you thinking? I love how everyone chides Sloth Life for having a heart attack. Don't do that, Sloth Life. Don't do that. 5 kids at home. How old? I'm very old. I'm approaching the half a century mark rapidly. Blackbird Ear, member for 24 months, OG, on the jury, says, what? My count is off, RA. Here since before Brooks. Love you all. Yeah, the count sometimes goes off, and it's, catch up is really hard to do, but we know, we know you're an OG. Cass, a member for 32 months, another OG. Always great to be here. Thanks, RA and all. Thank you. I saw, while we're on the topic, before we jump to court, let me actually get rid of Alaska. I don't need them anymore. Alaska's gone. Judge Webster.
Or not court securities, probate.
Hang on. Judge Webster's up with Mr. Aguirre. I saw a YouTube channel the other day that was it was amazing. It was actually this morning. It was amazing. I don't remember what it was called, but let me give you the gist of it. There are some channels, like my own, where we try to protect our kids from the channel. We don't let them be shown a whole lot. We don't release a lot of information about their names and ages and what they're doing and all that. We try to keep that a little closer, protected. And that's one way of parenting. And then there are these other channels where they monetize their children. And I'm not saying it's a bad thing, right? It's a parental choice, and done with the right amount of thought and protection, it can be great. But there's this little girl's channel where she rescues plants, and she knows everything about plants. She knows when it needs water or iron, or when it's minerals, or where it's root bound, or if it's getting too much sun or not enough sun. She's like a plant person, and she's young. I'd put her probably less, maybe 10 is the age I'd put her at. And so she goes to these stores and finds the worst, dilapidated plant in the garden section. The one that was on the sale counter for a long time and never got watered, even because it was on sale, because it was dying, and now it looks like it's completely dead. And she, I need to read her post. Okay, hang on. I missed a pool party joke. Anyway, she rescues plants, and she brings them back to life. Greeners peed in the gene pool. Okay, that's what we didn't need. I'm looking for it. Where is yes, Kurt, I see that. Yes, she got slapped by the Court of Appeals. Red, I'm looking for your joke. But not that one. Congrats. That's not it. Jump into the media pool party with my bikini on. All right. That's new and different, Red. No, I don't. If you're in the media pool, swimsuits are not optional. I'm just saying, they're not optional on the media pool. Lindsay LeBerg, thank you very much. And Brad, by the way, 41 months, OG. I found it. It just took a lot to find it. Let's see. We've also got a couple others here that came in. Cat Grow, member for 18 months. We're going to call it OG. I think you've been here a little bit longer than 18. Blackbird Ear, yes. Since before Brooks, we got you there. Cass, we got you as well. 32 months. Congratulations. How old are the kids? Not you. The oldest is like 20, mid-20s, and the youngest is preteen. Auntie Ree, member for 13 months. Thanks for the great community and entertainment. Looking forward to the next 13. Thank you. It's going to be great. Red, I went back and found it, Red. I did find it. Oh, and we've got mod chat happening. You found the doc. You guys are amazing. Okay, we're going to do a doc. A quick read through first. It's just a couple pages. Let's send it over there. Need to plug that in. Come on, computer, do your thing. Let's see, Beach Life Saltaire member for 35 months. 35 months. OG. One more month to go and you get a new color courthouse. Beach Life, that's going to be great. Lois came in with a super chat there as well. Lois, thank you very much for your generosity. Red is in bikini. Need to read her post. Yeah, we're not taking pictures today, by the way. No pictures in the media pool. Don't ask me about any of my plants. Oh, that's what I was talking about before I got distracted by a bikini joke. This girl, she rescues plants. So she found a plant. I don't know what it was, like some sort of flowering viney plant, and it was it grows on these sticks in the pot, but the whole thing's dead. Like leaves are just falling off. There's like 5 leaves that are still green. And it's normally $30. The plant was $30, and it's on sale for $10. And she takes it up to the check stand, and she's like, can I get a discount on this since the plant's almost completely dead? And they say, yes, how about you get it for $2? And she's like, yeah, that'd be awesome. So she buys it for $2, and she's going to take it home. That's her latest video. So I assume she's going to try to bring it back to life. But her dad's filming her, and I think her dad's, he's monetized this, but she's smart. She can like carry on the conversation for the little video, knows what to talk about, doesn't have to be like, she's not like repeating the words that her parents whisper in her ear to try to make it seem like she knows what she's doing. She actually knows, and she's pretty smart. But anyway, I was watching that, and I found a little video where she's complaining, and I complain occasionally, right? You know what's really hard about YouTube is this and this and this. Well, she's complaining. She's like, you know what's really hard about rescuing plants? And she goes on this little, I don't know, diatribe. She goes on this little complaint run where she talks about how some stores will refuse to sell her a plant because they're worried that she's going to like complain and get a refund, or put it on social media like, look what quality of plants this store sells or something. And so they'll take it, won't let her buy it, and they'll throw it away. And she was so mad that they're just throwing away a plant that she could nurse back to life. That's her biggest challenge in life. But she has over 100,000 subscribers, which is just amazing. And she's doing great. She's, I'm sure, paid for college by now. Winnaboo, member for 28 months, always here, always lurking. OG, thank you very much, Winnaboo. It's an orchid. It wasn't an orchid. It had something like a Vil sort of name in it, like a villain. Brown-eyed wife, thank you for the 5 gifted memberships. That's super generous. You need to just get healthy, get back home, and get back to doing the things you like. Stop having heart attacks. Not an orchid. Must have been something else. You saw that video this morning too? She hit the algorithm. How do I join the Discord group? You ask right here, Kiki's Garden. By the way, somebody else with a garden. I know I'm old. All my plants are alive, and I can't smoke any of them. Yes, Bougainvillea. I think this is it. Via. I think it's like a via. Something like that. Let me see if I can find her channel now that we've teased it a little bit. All this time I'm trying to get the judge's document to populate properly, which it doesn't want to do. Let's send it via, let's just copy and paste. It is not liking it. Oh, there it is. I pulled it up. Got it. Got it. Okay. Bring this up here. Okay, we'll share her channel here in just a bit, because I'm going to find it. Adeline's Plant Rescue. Here we go. First, I'm going to subscribe. She only has 2,500 subscribers on YouTube. But let's share, copy link. Okay, this is the link to the girl who rescues plants. She's worth a follow, even if most of her videos are just shorts. It's just her positivity and her excitement for when a plant like starts growing and sprouting, and she's like, "It's growing. I know it's growing. My aloe vera is growing because I counted how many spikes it had. And now there are more and stuff." It's really good. My husband and I own an interior scaping business. Interior. Like, do you make hills and valleys and stuff? Like for indoor golf courses? Or is it? Tell me more. Anyway, let's see. I think if there's plenty of crap out there on the internet, right? There's junk and vile, you name it. The internet has that in spades. And when there's something that's just awesome and you can share without any concern about, oh no, what if somebody saw that I saw that, I pulled up on my feed and they think I like that sort of, this is just something I can share and just like, this is awesome. This will brighten your day, just every single video. So love the farmer overalls. Yeah, she rocks them. All right. Did you hear about the YouTube lady and her son channel where she literally died on the live? Oh no. Oh no. That's terrible. Because covering trials isn't positive. Well, we like to do it for a good reason, but a lot of times it focuses on hard stuff. So I'll share some positivity to offset some of that. Oops. There we go. Love the positive channels. Yeah, you can't go wrong as well, because that helps influence the algorithm, right? So next time YouTube decides to just show you something random, maybe it'll be good. Okay, let's edit. Let's make this a little bit bigger. We have a document to read. And this is about Judge Boyd. So let's go there now. 3, boom. You see that? Okay. We're going to do a little light reading here. Before the State Commission on Judicial Conduct. And by the way, thank you. Who was the mod that got me this? Josh. Josh found it. Thank you. Before the State Commission on Judicial Conduct. Public warning. Honorable Stephanie Boyd, 187th Criminal District Court, San Antonio, Bexar County, Texas. You guys have to understand one thing. Judge Boyd is done. It's over. Her judging days are numbered. At the end of this year will be her last day as a judge, unless she gets nominated or put in some other position. She is done December 31st. She lost her re-election bid to a primary challenger who ran on the very topic of Judge Boyd using YouTube in the courtroom and publicizing court trials that way through YouTube. So she's done, and she has a little bit, I think, and this is just me talking, a little bit of the I don't care anymore attitude about some things. But I do like her still. So here we go. During its meeting on April 8th, 2026, 8th and 9th, so April, May, June, this is 3 months ago, so this is the judicial process. That's the way it works, a little slow. The State Commission on Judicial Conduct concluded a review of the allegations against Honorable Stephanie Boyd, judge of the 187th Criminal District Court in San Antonio, Bexar County, Texas. Judge Boyd was advised by letter of the Commission's concerns and provided a written response. After considering the evidence before it, the Commission entered the following findings and conclusions. This is the results. Findings of fact. At all times relevant hereto, the Honorable Stephanie Boyd was the judge of the 187th Criminal District Court in San Antonio, Bexar County, Texas. So she was the judge. Judge Boyd live streams her court proceedings on its YouTube channel, the court's YouTube channel that was provided by the Office of Court Administration. So this channel is not Judge Boyd's personal monetized account. This is something that the Office of Court Administration provides for her courtroom. On the court's YouTube channel, Judge engaged in extrajudicial activities with viewers, such as hosting a book club, and allowed viewers of the court's YouTube channel to leave comments and messages in real time about proceedings and participants. Now, when she says allowed viewers to leave comments and messages in real time about proceedings and participants, that means she did not delete comments that people put up. I don't believe, this is my personal belief, I don't believe she ever asked people, what do you think should happen to this guy? Or what punishment would be appropriate? But it doesn't look good. During a July 6, 2023 plea hearing in the state of Texas v. Wilberth Villamil, the Villamil hearing, after rejecting a plea agreement submitted by the parties and being informed the defendant, Wilberth Villamil, was withdrawing his plea, the judge improperly injected herself into the plea bargaining process by asking Villamil if Villamil was willing to accept 20 years in prison offered by the court. During this discussion, Judge Boyd remarked that the case against Villamil was a life sentence-worthy case. In her sworn responses to the commission about this matter, Judge Boyd stated she has never reviewed or responded to viewers' comments or messages during proceedings, and that she has never relied upon or considered such comments or messages when performing her judicial duties. Judge Boyd represented to the commission that all her decisions are based solely on the evidence presented and the law, and that she has never been influenced by any outside source when ruling on a case. Judge Boyd confirmed that she participated in a book club with viewers through the court's YouTube channel, but indicated she no longer does so. During an October 28, 2024 probation revocation hearing in state of Texas v. Thomas Henson, the Henson hearing, after explaining to the defendant, Thomas Henson, that he was facing 20 years in prison, Judge Boyd directed the court reporter to go off the record while continuing to live stream and stated, "So it appears that you want to go to prison to be passed around for cigarettes or dessert, because that's what's going to happen to you because you're young, and they will think you're attractive at the prison. And I'm just being real with you, and no matter the commissary money that your parents, grandparents can put on the books for you is going to save you from being passed around at the prison. Do you want to be passed around for ramen noodle? Because that's what's going to happen. And that's what happened at the Bexar County Jail. People would get passed around for dessert. Someone was sentenced in this court for murder, and the first thing he did at Bexar County Jail was to go have sex with somebody. Whether it was consensual or not, that case hasn't been brought to me. And I can tell you right now that your grandparents, your mother, and probably doesn't have enough money to put on your books, so you won't be passed around for ramen noodles, cigarettes, oranges, or whatever at the jail. And it appears to the court that that's what you want to have happen to you, doing all these little crazy little tattoos you got here, trying to be Billy Bad with gang tattoos and everything." In her sworn responses to the commission about this matter, the judge noted the seriousness of the charge that Henson was facing and believed Henson was not taking the charges or the potential probation seriously. Relevant standards and authorities. Canon 2A of the Texas Code of Judicial Conduct provides, in relevant part, a judge shall comply with the law. Canon 3B2 of the Texas Code of Judicial Conduct provides, in relevant part, a judge shall maintain professional competence in the law. Canon 3B4 of the Texas Code of Judicial Conduct provides, in relevant part, a judge shall be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, and others with whom the judge deals in an official capacity. That one might be what they get her on. 3B5 says a judge shall perform judicial duties without bias or prejudice. 3B6, a judge shall not, in the performance of judicial duties by words or conduct, manifest bias or prejudice. 3B10 says a judge shall abstain from public comment about a pending or impending proceedings which may come before a judge's court in a manner which suggests a reasonable person the judge's probable decision in any particular case. Okay, that she might have a problem with as well. And Article 5, Section 1A6A of the Texas Constitution provides in relevant part that a judge shall not engage in willful or persistent conduct that is clearly inconsistent with the proper performance of her judicial duties or cast public discredit upon the judiciary or administration of justice. That might also be an issue with how she describes the jails. Articles 2613A2 of the Texas Code of Criminal Procedure provides in relevant part, prior to accepting the plea of guilty or a plea of nolo contendere, no contest, The court shall admonish the defendant of the fact that the recommendation of the prosecuting attorney as punishment is not binding on the court. She does that. Provided that the court shall inquire as to the existence of a plea bargain agreement between the state and the defendant, and if the agreement exists, the court shall inform the defendant whether it will follow or reject the agreement in open court and before any finding on the plea. Should the court reject the agreement, the defendant shall be permitted to withdraw the defendant's plea of guilty or nolo contendere. And she says that probably 100 times a day. She's like, if you do have a plea, it's not binding on the court. If the court chooses not to follow the plea, you can withdraw. She says that a million times. She's got that memorized. Conclusion. Based upon the record before it and the factual findings recited above, the Texas State Commission on Judicial Conduct has determined that the Honorable Stephanie Boyd, judge of the 187th Criminal District Court in San Antonio Bay, Texas, shall be publicly warned for 1. Failing to comply with nor maintaining professional competence in the law when she inserted herself in the plea bargaining process during the Villamil case. 2. Failing to be patient, dignified, and courteous towards Villamil and Henson. 3. Performing her judicial duties with bias or prejudice and manifesting by words or conduct such bias and prejudice towards Henson during the probation and revocation hearing. And 4, making the public comments through the court's YouTube channel about pending or impending proceedings in a manner which suggests to a reasonable person her probable decision in any particular case. The judge's failures in the foregoing respects constituted willful and persistent conduct that is clearly inconsistent with the proper performance of her judicial duties and cast public discredit on the judiciary or the administration of justice in violation of Canons 2A, 3B, 3B2, 3B4, 3B5, 3B6 of the Texas Code of Judicial Conduct and Article 5, Section 1A, 6A of the Texas Constitution. The Commission has taken this action pursuant to the authority conferred in it in Article 5, Section 1A, 8 of the Texas Constitution, the continuing effort to promote confidence and at high standards for the judiciary. So Judge Boyd got her name on the board, and she got a check mark by it. This is a public warning. This gets published. That's why we have a copy of it. It's forever a black mark. It's a shaming. If she continued doing the things that are listed on here, it may develop into something bigger. But honestly, I don't think there's enough time left in her service as a judge, even if it did continue, for it to be reported up the proper chains of command, addressed there, and then ruled on while she's still in office. So they don't like it, and that's the way it goes. When you look at the whole be respectful to defendants and everything else, there are so many judges that just rip into somebody. I mean, all of our favorites do it. Judge Simpson does, Judge McNally, Judge Clark, I think, has done it. We've got the standing judge. Something, I can't remember his name. Judge Fleischer, for sure. Oakley, there it is. I think she tried to scare him straight, right? To scare somebody into behaving, and it probably went a little too far. Judge Webster would never. Speaking of Judge Webster, let's go there and see what's happening. Mr. Gear is gone already, but let's jump to Judge Webster this morning and get a little court watch in. Ready? Here we go.
Es decir, tenía uno por no contar con registro y el otro por
No
falta de
contendere.
seguro de responsabilidad legal. ¿O acaso fue enmendado? Contesta Joseph Baca que así es, fue enmendado de acuerdo con la información dictaminada el 23 de diciembre del 2025.
Mr. Guerra, how do you plead to count 1, driving without proof of insurance?
Señor Guerra, ¿cómo se declara usted al cargo número 1 por conducir sin comprobante de seguro?
No contestante.
No contestant.
So you're not admitting the charge, but you don't want to deny it and take it to trial either?
Bien, entonces no está admitiendo al cargo ni tampoco negándolo para llevarlo a juicio. ¿Es
No.
correcto?
Sí.
Yes, correct.
Is anyone making you enter this plea today?
¿Alguien lo está forzando a ingresar esta declaración el día de hoy?
No.
No.
You understand that even though you're not admitting this charge, you will still most likely be found guilty and proceed to sentencing today?
¿Entiende usted que aunque no está usted admitiendo la culpabilidad ante el cargo, aún así puede ser encontrado culpable el día de hoy y proceder a su sentencia el día de hoy?
Sí.
Yes.
All right, at this time, are you pleading? I'll strike that. Mr. Baca, you have a factual basis?
Muy bien, señor Vaca, ¿tiene usted los hechos?
Yes, Your Honor.
Sí, su señoría. Por favor, proceda.
Your Honor, if we were to proceed to trial, the state would show.
Hang on. There, Mr. Guerrero, can you get the noise level in the background to stop so that you don't have that distraction?
Bien, antes de continuar, señor Guerra, ¿puede poner por favor evita su micrófono para que no haya tanto ruido por su parte y no haya distracción?
Sí, disculpe.
Yes, I'm sorry.
All right, thank you. Mr. Baca?
Your Honor, if we were to proceed to trial, the state would show the following.
Su señoría, si fuésemos a proceder a juicio, el Estado mostraría lo siguiente.
On December 9th of 2025,
El día 9 de diciembre del 2025,
the defendant was driving a 2019 Chevy Traverse
el acusado estaba conduciendo un Chevy Traverse del 2019
and was stopped by Butler County Sheriff's Department
y fue detenido por el Departamento de Sheriff del Condado de Butler
at a location in Butler County, Kansas,
en una ubicación dentro del Condado de Butler de Kansas.
That location was US 54 at milepost 234.
Esa ubicación fue en la US 54, número de milla puesto 234.
On that day, he was stopped for an expired registration and could not provide proof of insurance on the vehicle.
En ese día fue detenido por un registro vencido y no pudo proporcionar su comprobante de seguro.
All right, I do find the defendant has knowingly and voluntarily entered a plea of no contest to driving without proof of insurance. The state has provided a factual basis. I find the defendant guilty. Recommendations for sentencing.
Muy bien, entonces se está identificando que el acusado, en pleno uso de conocimiento y de manera voluntaria, está ingresando su declaración de no contestante ante el cargo de conducir sin comprobante de seguro. El Estado ha proporcionado las bases de hechos y se le está encontrando al acusado culpable. ¿Cuáles son las recomendaciones para sentencia?
Yes, Your Honor. At this time, state would recommend the mandatory minimum fine $300.
Sí, su señoría, en este momento entonces el Estado está recomendando lo que es la mínima sentencia de multa de $300.
State would also recommend 120 days jail suspended.
El Estado también está recomendando un tiempo de 120 días de cárcel suspendido,
6 months non-reporting probation,
con 6 meses de probatoria sin reportar,
pay court costs, and determine attorney's fees.
hacer pago de costos de corte y determinar también los honorarios de su abogado.
Thank you, Mr. Patterson.
And I may have missed it. Did Mr. Buck recommend 6-month non-reporting probation?
He did.
Then we'd ask court to adopt the recommendations.
Muy bien, muchas gracias. Señor Patterson, ¿tiene una duda? Sí, creo que no lo escuché. El señor Vaca sí recomendó que se hiciera una probatoria sin reportar. Así es. Muy bien, entonces que queden en el expediente las recomendaciones.
Right, Mr. Guerra, your sentence will be 120 days suspended so long as you complete 6 months of non-reporting probation.
Muy bien, señor Guerra, su sentencia quedará de la siguiente manera. Serán 120 días suspendidos de cárcel siempre y cuando usted cumpla los 6 meses de probatoria sin reportar.
Where do you work, sir?
¿Dónde trabaja usted, señor?
Estoy trabajando en Industria Piqué de nuevo ahora.
I'm currently working at PK Industries again now.
What was the name of it again?
¿Cuál es el nombre del lugar otra vez?
Industria Piqué.
PK Industries.
Oh. And what do you get per month at PK Industries?
¿Cuánto gana mensualmente ahí en las industrias PK?
Entre 3.500, 4.000, depende de las horas que se hagan.
Between 3,500 to 400,000, depending on the hours worked.
All right, your fine will be $300, your court costs $108, and you will pay $250 of your attorney fees.
Bien, entonces su multa será de $300, sus costos de corte serán de $108 y deberá pagar los honorarios al abogado por $250.
Okay.
Okay.
Again, your suspended jail sentence is 120 days, but you will not have to serve any of that if you successfully complete this 6-month non-reporting probation.
Nuevamente, tiene también una sentencia de cárcel suspendida por 120 días, pero siempre y cuando no va a tener que servir este tiempo si usted exitosamente logra completar la probatoria de 6 meses sin necesidad de reportar.
Y en los 6 meses que no tengo necesidad de reportar, ¿qué es lo que debo hacer entonces?
So during the 6-month non-reporting probation, what do I need to do then?
But condition number 1, violate no laws for the next 6 months. And condition number 2, pay the total due of $658. How much time do you need to pay $658?
La primera condición de esto es que no debe violar ninguna ley por los próximos 6 meses. La condición número 2 es que tiene usted que pagar el monto total de $658. ¿Cuánto es lo que necesita de tiempo para poderlo liquidar?
Necesitaría un mes, estaría bien.
I would be needing a month, if that would be fine.
We'll give you 30 days to pay. I can give you a little more if you need it.
Le puedo dar 30 días para pagarlo, si necesita un poco más también.
No, 30 días estaría bien.
No,
¿Cómo?
30 days.
¿Y cómo lo debería pagar?
And how would I be paying that?
Call and the clerk of the district court at 316-322-4.
8675309.
Instructions on how and where to pay.
El número telefónico de la Secretaría del Distrito de la Corte es 316-322-4370. Ahí le brindarán las instrucciones de cómo y dónde pagar.
You're muted, sir.
Tiene el micrófono cerrado, señor.
Disculpa, ¿me puede repetir el número?
Sorry, would you mind repeating the number?
316-322-4370.
8675309. Barely got that one.
322-4370.
Okay, we're going to jump to a funny one.
Okay, gracias.
Okay, thank you.
So if you do not want to serve 120 days in jail, make sure you complete your 6 months non-reporting probation with its 2 conditions: violate no law for 6 months and pay $658 within 30 days.
Easiest terms ever.
Muy bien, entonces, si no quiere servir los 120 días de cárcel, tiene que asegurarse de completar la probatoria de 6 meses sin necesidad de reportarse, bajo las 2 condiciones proporcionadas. Una es que no puede violar ninguna ley durante esos 6 meses, y la segunda es que tendrá que pagar el monto de $658 dentro de los próximos 30 días.
All right, we're going to jump from here. Ready? We're going to a SOV sit that happened in a court we've been to, but not for a little while. I haven't been here for a while.
No, todo bien, gracias.
No, everything's fine. Thank you.
Thank
I'm
you.
trying to figure out how. I just had it right before. Oh, okay. Hello.
State your name. Good morning to you.
Good morning.
State your name.
I am Destiny Raven Graves, the beneficiary of the estate name Destiny Raven Graves. I am here on special visitation to address the matters in my abatement. And I am here as a friend of the court, and I stand by God as my witness.
All right. Good morning to you. Today is the date and time set for a pretrial. I'm going to put you in a breakout room with Mr. Berry. He's going to attempt to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial, okay? Join the room.
I'm sorry?
Join the room. Let us know what you want to do when you come out. We'll pass the matter. Let's go back on the record with Mr. Greer. Greer, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Client wishes to waive his rights, Your Honor, to a trial in this matter. I did advise him of his rights.
That's a great look.
He's going to enter a plea to one count to failure to display.
Chester the
and
Cheeto.
all other matters
or
will
Cheeto
be
the
dismissed.
Chester, whatever glasses on. With the
Is that what you want to do, sir?
Yes, Your Honor.
Okay, we're going to fast forward because we're waiting for our defendant to come back out of the sidebar. Oh, here we go. I think that's her, right? Yeah, that is.
What's your first now? Here it is. John, I was like. It's already closed out.
I would wear those glasses while eating Cheetos.
It needs to be dismissed?
Yes.
Okay.
All right, are we ready on Graves?
We are, Judge.
Yes, Your Honor.
Love this back wall. He's got all the pictures.
That Nadia Gilbert, please. Let's go back on the record with Ms. Graves. Ms. Graves, I've given you an opportunity to speak to counsel. Counsel, what does your client want to do?
Your Honor, we're unable to engage.
I am not a client of his. He is very disrespectful. I am not a client of his.
What do you want to do, ma'am? Come on.
I would like to address the matters of my abatement.
I don't know what that means.
Did you get the abatement that I sent? You did.
I have no clue. I have no clue what that means. I have
You
no
don't know
clue
what means again?
I do not know what this stuff means.
Can you elaborate on what you mean by that? You don't know what means exactly.
I'll elaborate on it.
Okay, well, I'm here to address the matters of my abatement. I have it here, right here. I sent it to you also.
Yeah, I have something that you sent to me. It has no basis in law or fact.
What doesn't have basis of law or fact? My abatement?
This is the abatement stuff you're talking about.
Can you elaborate on?
What do you want? I'm not going to sit here and waste people's time or my time. What do you want? You want a trial date? Wait a minute. Don't talk when I'm talking. What do you want? You want a trial date or do you want an offer?
Do I want a trial date or what?
An offer to resolve this stuff today.
I would like to address the matters of my abatement before moving forward. So we can do that.
Go ahead. Go make your record.
Okay, so first I would like to say I am not a citizen of the United States Corporation. Therefore, I am not an employee of the United States. Who is subject to the status regulations defined to the IRS code, which applies only to the contract employees, to the U.S. contract employees. I am a woman. I was created by God with dominion. The creator is subject to the creator and nothing else.
So
is that it, ma'am?
You're not the God of me?
Well, as long as we can address the matters of my abatement.
All right, you've addressed it. You've made your record.
Right. So we're
You can sit there all day. Pass the matter. All right, let's
Okay,
go call the City of Detroit versus Alante Chevelle Green, case number SP19012041.
Okay,
Appearance
so
for the record, please.
let's fast forward.
Oh, that's very.
Let's see how long she sits. Is that her? No, that's not her. Oh, she's back. She's back. Here we go. We just, for once, just have a judge send the police out and pick someone up during the live stream while we're watching. That would be fantastic. Just knock at the door, battering ram.
That should be all of them.
Look at his papers. He's crossed everything off. He doesn't have anything else to do except this one sob sit. He's just stalling. Can you guys remind me between 12 and 12:30 to start the Top Mark Media Alaska Court live stream?
Samantha Lee.
Now he's just cleaning his desk. She's waiting.
May have gotten caught on one of those other ones.
Thanks, Fred. You might have to call my phone directly because I've missed so many comments. Josh says, I've been waiting a week to have a day to show this. He's been saving it up. What happened with Judge Dad and the messy lot guy? Did he get put in jail? Arthur Gaffney may be snoring. Actually, we're not sure what's going on here. Should we be here? I think we're in bed. We're now in bed with the defendant, figuratively speaking. Probably, well, literally speaking, but not like actually. But I don't want to. Well, you should have thought of that before you made the decision to be here, Kurt. Sometimes we go places. Okay, it's taken forever. I'm gonna. Did we not fast forward? It's right here.
May have gotten caught on one of those other ones.
Detroit City Code. Is that 2019 version? Binder? That's an old. They have to have updated their code in the last 6 or 7 years. Okay, so we got backed up again. There was a snoring. We don't want to be back in bed there.
Where's Miss Destiny Graves?
There we go. He's waiting for her to be gone so she can get a bench warrant.
Okay. Can you hear me?
Let's get a jury trial date for this young lady.
Excuse me,
Please.
I do not consent to that, Your Honor. But if you
don't have to. But stop.
Okay.
Stop. No, don't say anything unless I speak to you. You don't have to consent to it. I'm going to give you a trial date, a jury trial date. You bring this stuff up amongst your peers, and let them make a decision on it. Okay?
Can I just say this?
No.
I do have the right to. I have the right to.
Ms. Graves, the judge said no. That means be quiet.
Okay. Jury trial. You said jury trial and what else?
It's a jury trial date. I'm going to set a final pretrial date to make sure that the officers appear on that final pretrial date, which will be the day before the jury trial date. If the officer does not appear on that final pretrial date, we'll dismiss the cases. If the officer does appear on that final pretrial date, we'll move forward with the jury trial.
Okay, so we're not addressing the matters of my abatement.
I've let you make a record of that, ma'am. You mentioned nothing about what the court is supposed to do with this stuff. I told you the court doesn't even know what you're talking about. This doesn't have anything to do with the Michigan court rules, Michigan rules of evidence, or anything. That's what the court follows. If you can't follow that,
due process, I do follow. I follow the court rules because I'm following due process. I have the right to due process.
Right, and we're giving you July 14th. That's your jury trial date, right?
Yes, it is. Yeah.
July 13th is your pretrial. July 14th.
This is your due process, your trial date. July 14th is your jury trial
I'm
date.
asking for due process under the Constitution. That's what I'm asking for.
And that's what you're getting.
No, I'm not. Your Honor, respectfully, I'm not getting that.
All right. Well, then you take it up with the appeals court or whoever you want to take it up with.
Okay. Because this is breach of the Constitution.
If that's what you call it. I don't call it the Constitution. I call it.
You're not allowing me to speak up for myself. You're telling me what I have to do.
Listen, I gave you a chance to speak. I gave you a chance to address your abatement. I told you about the abatement and how the court feels about the abatement.
And that's what I'm trying to do, Your Honor.
Say, you're not going to convince me by any more words, by anything else you have to say. We've been down this road many times with you, okay? So say what you want to say. I'm going to set a pretrial date, and I'll give you this time to say what you need to say, and we'll move on.
Okay, so I'm gonna address my abatement now. Give me 1 second. 1 second. OICD, please. Give me 1 second.
Mama's going to school this
I'm
judge.
going to address the matters of my abatement. And that is, I respectfully demand civilian due process as required under the Constitution and equitable principle on which this nation was founded. All right, I will continue. Before this matter may lawfully proceed, I require clarification as to whether this tribunal recognizes my constitutional rights, including my rights of meaningful due process, my rights to face my accuser, my rights to challenge jurisdiction before any further action is taken. I have been issued citation without any verified complaint made under penalty or perjury by a lawful injured party. A citation issued by an officer without sworn testimony from an injured human being does not meet the constitutional requirement of an accuser. A court of equity will not proceed without proper parties. It should not. Not done. Give me 1 second.
And she went to the weekend seminar and she drank the Kool-Aid.
There is no injured party, no sworn complaint, no damaged property, no affidavit of harm. Therefore, there's no adversarial controversy of court to adjudicate. Accordingly, I petition for abatement until a sworn verified complaint is produced, jurisdiction is established on the record, my constitutional and equitable rights are affirmed in writing, and then we have the equitable basis for my abatement. The maximus of equity.
Oh, she's not done.
Ms. Horn, can you put your appearance on the record?
Yes, Your Honor. Speaker Horn.
Excuse me, Ms. Horn. Ms. Shetta Lockhart, please stop.
Go ahead. Go ahead, Ms. Horn.
Thank you. Tamika Horn on behalf of the City of Detroit.
All right. I'm just putting your appearance on the record because I'm giving Ms. Graves her due process with a jury trial, a right to a trial. Ms. Horn, the jury trial date is going to be July 14th. I expect all people to appear on the final pretrial date of July 13th. All parties appear.
To be clear, Your Honor, the matter to my abatement will not be addressed today.
On July 13th at 8:30. That's going to be the final pretrial date. So make sure your officers are summoned for July 13th and the 14th. I expect them to appear. If they don't appear, we'll dismiss the case.
Okay, thank you, Your Honor. We will be ready to go.
Okay. And
Your Honor, can I ask you a question?
No, you don't ask me questions. You go ahead and finish making your record.
Okay. Okay, Bobby.
Are you done, ma'am?
No, I'm continuing, Your Honor. Maximus of equity. Equity will not suffer a wrong without a remedy. Equity regards substance over form.
Are you just reading? Are you reading?
I am reading because I want to make sure that I have everything, but I would like for you to hear my baby.
Stop. Are you reading this that you filed? Is that what you're doing?
Your Honor, I am reading that.
Okay, so we don't need to go any further. I noted that you have this in the file. I placed this in your file. What ruling do you want me to make on this? What are you asking the court?
I am simply asking the court to address the matters of my abatement before moving forward.
I don't know what you're talking about abatement. I can't address
the abatement that I'm trying to read to you. That's my abatement. I'm asking for due process, a proper due process. That's what I'm asking for.
Proper, not this.
I'm asking for the judge and for the court.
Court feels that it's giving you proper due process.
How do you feel that way if you haven't addressed any matters of my abatement?
Because I don't recognize, I don't understand that stuff. It doesn't have anything. If it's not in the court rules, if you can't cite
the Constitution, Your Honor.
All right, cite the Constitution, cite the section of the Constitution. I'm not going any further with this. That your abatement or whatever that you filed is in the file, the matters
were not.
That is in the file, and I've given you a jury trial date of July 14th at 9 a.m. I've given you a final pretrial date of July 13th at 8:30 a.m. If it's nothing further, Ms. Graves, I wish you the best of luck.
I would like to say something, Your Honor. I'm asking, for the record, I would like to know, will the matters of my abatement be addressed?
They've already been addressed.
And how did you address it? Can you explain it to me?
Like I said, I'm not explaining anything to you.
I'm asking. Right. Okay, so the part of my
Great. This concludes this hearing. Okay, that's all I'm going to say.
So it will not be addressed. My matters will not be addressed.
Have a good day. if that's how you feel. Have a good day. Best of
No,
luck to you.
I don't want to say how I feel. I want the court to tell me what's going on so that I can know how to move forward.
I'm not telling you what's going on. You go to the court rules and do that. Have a good day, Miss Graves. Best of luck to you.
So my matters will not be addressed.
They have been. Have a good day, Miss Graves. Last time I'm going to say it. Best of luck to you. And if you continue on, I'm going to hold you in contempt of court, okay?
Yes, Your Honor.
Yes, right. Best of luck to you. Have a very good rest of your day.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor. You have little baby sob sit there.
Go ahead, Ms. Horn. Back I'm sorry, I just wanted to make you aware of what.
Great, a whole other generation
on the,
being raised
14.
up with this.
Okay, thank you, Your Honor. I appreciate it.
All right.
Oh, that poor child. The poor child. Little baby sob sit. We're cooked. Yeah, this is why we can't have these things. The child is doomed. It's not a child, she's an entity of the estate. Oh, man. The judge is like,
procedural matters, and unfortunately, you have.
Why me? You know what? You know what the worst part about that is? Some poor jury out there is going to get a summons, and they have no idea what's about to hit them. They have no idea. Let's see if we can grab that really quickly. It's going to be on this one. Okay, let me go back to. That's not it. Trying to find it. Just 1 second. I'm on the wrong day. We'll see if we can grab this really quickly. Oh, I was on today. That's why. Hold, please.
To you. Have a very good rest of your day.
Thank you.
Thank you, Your Honor.
All right. Go ahead, Ms. Horn. Back I'm sorry, I just wanted to make.
Got it. All right. So now I should have. Where's that coming in on? Test 1, 2. Hyperdeck's not linked. Okay, I've got it somewhere. Thank you, Your Honor. It might happen. Let me import it before I forget. I know I'm going to forget this. It's on, where are we recording to? Big Deal 1. Okay. We're getting it. We're getting it. Hold tight.
Go.
Thank you, Your Honor.
Okay. We'll trim this down. She seems so pleased with herself that that's the result she got.
Go.
Thank you, Your Honor. Thank you, Your Honor. Thank you, Your Honor. Thank you, Your Honor. Thank you, Your Honor.
Let's trim that down. Audio only. There's thank you. Hey, how's it going? Open that file. It's ready to go. Now we're making the command. I'm doing it all right now, or else it's never going to happen. So. I just know my weaknesses, and that's one of them. All right, let's do. Why have they given me a whole bunch of more gambling? There's a whole bunch more gambling options that just get randomly turned on in chat, and I'm not going to tell you what they are, but chat commands. Copy. Edit. It's going to be called thank you, all one word. Like no spaces. Thank you in one word. Bum, 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 bum. Advanced commands. Audio is going to be delete that, select, choose local audio. Thank you.
Take it on
There we go. Done. Okay, I think I did it. Now, where were we? We were going to watch court, right? Oh, I have to refresh. Alaska. Hang on.
Take it on
You're welcome. You're welcome. All right. Yeah, things did not go quite the way we were expecting today. We thought we were going to go to Alaska for that trial, but the audio was just terrible. And the more I listened, the more I tried to play with it, the worse it got. Buffer.
Hello.
We need a cooldown message for thank you. Let me know what it should be. And I'll make a custom one.
When are we going to break for lunch, Judge?
Not that one. Cooldown message should be... This is a thankless job. That's great. Okay. Done. Done. One and done. All right. That's how easy it is to get a command made. So I don't know why you guys are complaining about not getting them made all the time. But we're there. Let's go down to Florida, shall we? Judge Brantley Clark.
Take it on
You're welcome. Judge Brantley Clark is doing his thing down there.
Step over and speak to probation officer.
I think I'm covering everything. I'll shrink down a little bit. I think he's doing felony appearances this morning.
I believe the state has filed on this charge. We'll waive a formal reading and or plea of not guilty. He's got some other cases with Rusty Shepard.
Okay.
We can just track with those cases.
We know when they're set.
Set July 20th or so. Filing that, but it's still in July.
All right. And they, he hasn't been arraigned on them yet, though, has he? All right, July 20th at 9 o'clock.
Wants to address bond.
Rusty about it. David O'Donnell. I don't believe there's an information in this case yet, Your Honor.
All right. July 20th at 9 o'clock.
I'll see you before that, okay?
Wow, that just
and then I have Stephen Michael Grant.
They got transported all the way here from jail to stand up for 3 seconds and hear a date read at them.
Going to be entering a no contest plea to driving with a suspended license, third or subsequent. That's a third-degree felony. 1 count of possession of marijuana under 20 grams. 1 count of possession of drug paraphernalia.
Sounds like another
dropping
case.
The possession of controlled substance charge. He has a prescription for that. He'll be adjudicated guilty, sentenced to 18 months of probation. His court costs and fines is $1,028.
This is the plea.
To 100 community service hours, pay $20 a month for the cost of supervision. Do a drug and alcohol evaluation, take any counseling as recommended. Zero tolerance for use of controlled substances, random drug tests, must enroll within 30 days. DMV may apply additional penalties. Submit to a DNA sample, forfeit any seized items. And if I didn't announce it, $1,028 in court costs and fines. He's got some county court cases that we're resolving as well, resisting without violence and a driving with suspended license.
The agreement with the state.
Yes, Your Honor.
Oh yeah, the Walton County, and he's got a hold out of Walton County too, so he won't be able to report to probation right away.
Probation.
Yes, sir.
Yes, ma'am. Oh, sir, you state your name.
Stephen Michael Grant.
Grant, you heard the announcement of Mr. Killian, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence when you drugs or alcohol today, which would impair your ability to either enter the agreement or understand any of the terms and conditions of it?
No, sir.
I've been handed a plea waiver consent form. There's the front. On the back of that has a signature of the defendant line. Is that yours?
Yes, sir.
Have you had the opportunity to read that agreement?
Yes, sir.
You had the opportunity to go over your cases with Mr. Killian?
Yes, sir.
Have you had sufficient time to speak with Mr. Killian about your case?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
Do you understand that by entering this plea, you're waiving your right to go to trial?
Yes, sir.
You're waiving your right to require the state prove the allegations against you?
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence?
Yes, sir.
You're waiving your right to present any defenses that you might have to the allegations?
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf?
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which would be your decision to make?
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence?
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Mr. Grant, do you feel the plea is in your best interest?
Yes, sir.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Yes, sir.
I'll accept the stipulation. Find there's a prima facie case, and we'll find that Mr. Grant's plea was freely and voluntarily made after consultation with his attorney. I'm going to accept it. Adjudicated guilty of driving while license suspended or revoked, third or subsequent offense. And he's also adjudicated guilty of possession of marijuana less than 20 and possession of drug paraphernalia. On count one, he's placed on a term of probation not to exceed 18 months. He's ordered to pay fines and cost of $1,028. He must complete 100 hours of community service work at a minimum of 8 hours a month at the direction of his probation officer. His cost of supervision will be $20 a month. Within the next 30 days, he must undergo a drug and alcohol evaluation, follow all recommended counseling, zero tolerance for use of any controlled substance not prescribed by a treating physician. He'll be subject to random UAs at his own expense. Department of Highway Safety Motor Vehicles may apply additional penalties. If he's required to give a DNA sample, he must submit one, forfeit any seized items. He will complete a driving while license suspended or revoked corrective measures course.
This judge also has it memorized.
He sentenced the time he served in the Bay County Jail, given credit for that time. All three counts will run concurrent with each other.
Okay, we're going to pause him for a minute. This is not very exciting. We are going to go to something that is exciting that Greener's found for us, and it's Judge Dad. So let's jump over there.
Thank you for that, Mr. Nykel. Thanks, Ms. Lady Carter. I've got to take Mr. Boyd. Do we have a lawyer for Mr. Boyd that he's talked to yet?
Yes.
Where is he? Who is it?
Gentleman in the back.
Gentleman.
Was it Mr. Gaith? Mr. Gaith, can you hear me?
Yes,
So,
Judge.
hang on.
I'm here for Miss Russell, Judge, on the retained case.
Hang on. I got it.
Wait. Robert Thomas Boyd, 25BA2557. Ms. Foley Carter, your appearance.
I'm Shirley Carter, Boston Township.
Your appearance, please.
Rob Harris can be at the Bronson Township Board.
All right. And Mr. Boyd, your name.
Robert Thomas Boyd.
All right. Mr. Crawford, your appearance, please.
Morning, Your Honor. I'm Bill Crawford.
All right. What are we going to do here? Tell me you got good news for me, please. Tell me you got good news for me, please.
No, last time we were here, Mr. Boyd was ordered to complete the sentencing order in its entirety. He has made some progress. Unfortunately, if we were to go line by line on that sentencing order, he is not compliant with all but the winter storage of the pumps because we're in June. But otherwise, we're not there yet. We do have updated photos. I don't know if this court wanted to see them.
I do, but Mr. Boyd, I want to ask you a question first.
Yes, sir.
You don't have to do this. We've been going round and round on this since June of 25. Hang on one second. I don't believe I've ever revoked your status either. So I'm almost inclined to have to do that today if I'm going to give you more time. You don't have to do what I'm going to tell you to do, right? I'd like you to call your two sons and have them Zoom in.
Pardon?
Have them use Zoom
Oh,
to Zoom into the courtroom. Will you do that for me, please?
all my,
Call your two sons. You have two sons.
oh, yes, sir. They work,
I know. They,
7/12,
so do all these other people. They're Zooming in from work. I'd like you to go out. You don't have to. I'd like you to go out. I'd like you to call them. I'd like to have a conversation. You are forcing me to do something that I don't want to do. You're refusing to take help from people that have offered assistance. Sir, I don't want to debate this. You're a likable man. They've been playing with this for 25 years. I'm frankly to the point where I could be faulted for letting it go so far. You're just not going to listen to me. For whatever reason, I don't think you're being defiant. I dislike judges. I don't like, it doesn't matter to me what the reason. You're just not going to comply. So if I can't get some indication from them that they're going to go over there and help you and understand the severity of this, because I have this belief in my brain, and I could be wrong, that you really haven't discussed the seriousness of this with them. I would like you to go call them.
one works midnights.
I don't care. Good, he's off. He's off.
I can't call him this morning.
What?
He's in bed.
Wake him up,
Oh,
Mr. Boyd.
see what I can do.
Get them both on.
Well, the other one, we're not on much talking terms.
You never told me that before. I don't need to know the reasons why.
Yeah.
Call your other son, get him on here. Please do that for me. We're going to give him the Zoom ID. Will you do that for me, John? Give it to him, or Sadie, give him the Zoom ID and have them Zoom in, and I'll pass the case and we'll go from there. I'm gonna ask you to stick around a little bit, please. Thank you.
Okay, so the judge is going to pass the case, so we're going to jump to where he passed the case to.
You're gonna go out and call and call them?
Yeah, just leave them.
Go out and call, you're gonna call them. Call them.
Yeah.
Yeah, okay. Robert Earl Curitan.
Okay, here we go.
I went to St. Tim's with her. I haven't seen her in years. She doing all right?
Yeah, her husband's serving China.
Oh, no. Jeez. Will you tell her I said hi?
2 hours
And the
later.
other case, by the way, that was put here was already dismissed, the PBT refusal. We put that at the top of the step.
Yes.
Good luck to you. Have a nice day. Thanks, Mr. Ramsayer. Good to see you. Thank you. Deshaun Thompson. Deshaun Davion Thompson. You know what, Mr. Crawford? I need about 5 minutes. I got to get off of here. But I want to get Brownstown. Is Brownstown in Judge Hessen's?
There.
Did I jump to the right point?
Come on in here, Mr. Boyd. Who's your lawyer on this one again?
Crawford.
Mr. Crawford, come on up on this one. Robert Thomas Boyd, 25BA2557.
You want Brownstone here?
I don't want to bother him if you're in front of Judge Hessen. That is not what my intent was.
Taller, see what she,
There's Mr.
Mr. Boyd, your name?
Robert Thomas Boyd.
Mr. Crawford?
Michael, Mr. Boyd.
What are we going to do with Mr. Boyd? Did you call your son?
Couldn't get hold of me on it. Just connected his phone while he sleeps.
He also tried calling his wife, to see his wife, and she didn't answer because she's at work.
I didn't know you were married.
No, his son's wife.
Oh. What am I going to do with Mr. Boyd?
I'm very sure, Your Honor, it appears to me that my client is with every sincere effort that he can in these advanced years and a type of support.
No, he's not. I've given him too long. They've been after him for 25 years to do this. Mr. Boyd, I think it's time for you to go to jail, and I don't want to do that.
I don't want to do.
Why are you not taking care of this?
I took care of a whole lot.
Do you have the pictures that they had?
I don't have the pictures, Your Honor.
Okay.
Pictures.
Only if she's available.
But Your Honor, my client submits that he did get the boat removed. He got the trailer
Yeah,
removed.
but she just got done telling me it's about the only thing he's done that's on the list for him to accomplish when I placed him on probation 11 months ago. And they've been after him for 25 years.
He's on the way.
You got a point.
I didn't get the opportunity to talk with the prosecution to see if we could put our heads together and make a lot of suggestions.
Well, I mean, this has been going.
I know.
He's not going to listen. You're not going to listen to him. I don't think you're being defiant of me in the sense that you're not basically one of these guys that comes in there and thinks he owns the place. But you're not being defiant. You're just, I think there's some issues here.
What the solution is, I don't know.
Well, the solution is probably, I just got to send him to jail, I think.
Well, unfortunately, when you come out, Your Honor, he's going to be in the same situation.
I know, but they've been after him for 25 years. You know how many hearings I've had him here on? Guys, can I have your name and can you both count your appearance?
Caitlin Fuller Farm, Brownsville Township.
Rob Harris on behalf of Bronson.
Can you spell your last name for my recorder? You, Ms. Paris.
Harris,
Harris.
Harris.
All right, what are we gonna do? Give me the pictures, please. Let me see them. Did you show them to Mr. Crawford?
I'm earlier.
I gotta say,
At first glance, Your Honor, they looked a lot cleaner than the other pictures that were in the file. You look brighter, you kind of see the property a little bit more. We could,
Did say there's progress, just
not as much as one would like. So.
He could have cleaned up the whole yard in the time he spent in this
he is
courthouse.
making progress, though. Maybe a little bit,
You can't lock
right?
him up for that.
Looks like the Taj Mahal compared to before, even though it's. You got to get the vehicles out of there. These are inoperable vehicles. What's this wood pile doing here in the middle of the yard?
When they stole my wood last fall, I had to buy some more wood. I heat my house with wood. And, I didn't want to put it in the backyard because
If I give you 2 more weeks, you're gonna have this done?
how about
I know. What do you want me to do? Send him to jail?
I don't know, Your Honor. I know that this has been going on.
I know.
Yeah.
Ad nauseum.
all I've got left is the bushes.
2 weeks. During the review hearing, I can't believe, I don't know what it is about me. I mean, I really don't. I really should have been fed up a long time ago. I mean, he made me send him to jail. How many times you go to jail on this? Once or twice?
Twice.
For how many days?
5 apiece.
Heather, give me a date in 2 weeks, please, or whenever, 3 weeks before I go anywhere, and it's not on Judge Heston's docket. What are we gonna do? July the 1st?
So that, not on her docket?
I want it on my docket. This should be
your
on my
docket will be
docket.
July 1st for Brownstown.
At 8:30. Okay?
Can I just make a note about what needs to be done?
Yes.
Just so that he knows that it's.
Yes, absolutely.
So looking at the sentence, going by line, first, the 2 vehicles that are parked on the grass, they need to be on impervious,
I want you to listen very carefully to him.
must be located on concrete or asphalt driveway surface. They also must be roadworthy, so the flat tires on the RV and cars, those are not roadworthy, so they need to be made roadworthy. The garage was taken down, the permit was pulled, however, there's still no inspection, so it's not completed. So we need to contact the township, have them get out there and make sure it's safe.
Do you understand that?
Yeah, I thought he was the guy I had to have come out and look.
Well, you can set it up with him right now.
No, I'm not the.
Yeah, I know, but can't you help expedite it by?
Absolutely, I mean, and also the cement's still there for the garage, the cement has to be, removed. So that, to get the permit to be passed.
Right.
The cement has to be, so I'm not a building inspector.
Right, I know.
But when I spoke with him yesterday, he said he would not pass it because the cement is still there, the broken cement.
I want to keep the cement there to park the stuff on.
The cement is broken, raised.
It's a cement floor from a garage.
I made the orders initially. You need to follow them and go back to the probation order where everything was attached. And then you prepared another order on this case, correct?
We did, Your Honor.
And it's attached to the probation order.
Your Honor, I also gave Mr. Boyd a copy the last time.
I know. See, you gotta follow that. You gotta read that. Get your son to help you. Get somebody to help you. But if they don't pass it, it's no go.
What's wrong with keeping the cement?
You talk to them about it. I ordered you what to do and I expect you to do it. 3 more weeks, that's it. I can't extend probation anymore under 771. You're coming to the end of the year.
Just to be clear, Your Honor, 2 motor vehicles off of the grass on concrete.
Correct.
Asphalt and roadworthy, and get the building, passing grade from the building inspector.
Exactly.
The garage.
It's all order.
There's more that's coming.
There is, yeah. So there's still junk, trash, rubbish, garbage throughout the property.
It's pretty clear. You gotta get rid of all that.
I am.
Within 3 weeks. Go ahead.
There's no trailer storage, so there's multiple vehicles that are being used as outdoor storage. That can't happen in the township. As Mr. Harris stated, the cement needs to be removed from the garage demo because it's all busted up, so it can't be used as like a pad for parking. The grass and noxious weeds need to be taken care of. There's an ordinance where it's what, 6 inches?
It's 8 inches, but I mean, there's weeds there that are taller than me, especially at the side of the house.
You gotta get rid of them.
Sure.
That's about it.
Home's gone.
Get rid of it, please.
Right over that cement.
No.
I have to have them to park the vehicles on. They order me to park the vehicles on cement. That cement is fine for parking the vehicles on.
Well, you haven't, he's not the building official.
I know.
He's gonna help you get in contact with the building official before you leave here. You
Yeah,
can explain that to him, and he's gonna come in here and talk to me in 3 weeks. If you don't resolve,
okay, we'll see what we can do.
let's get it done. Can't believe I'm not sending you to jail, Mr. Boyd.
Thank you, Your Honor.
Your Honor, I appreciate your benevolence.
Good luck. Sean Thompson. Deshaun Davion Thompson, 26W824 842-863A. And I also have a B file here.
Okay, I'm gonna cut from that. He needs help. He needs help, and yes, his son needs to get involved. His son needs to know the seriousness of the situation. But he's got what, 2 more weeks now? 2 more weeks to get that cleaned up. The problem is he's not willing to let it go. It's not just somebody saying, hey, I volunteer, I'll pay the towing fee to get the cars towed to the junkyard. It's not that easy. He won't let it go. I mean, the trailers have stuff in them that he wants to keep. So he needs some help. I also have issues with laws that tell you how you have to use your property, or how you can't use your property. Now, I realize to some extent there are some situations where there's rodents, for instance. Storing a whole bunch of junk and debris on your property is going to affect all the neighbors. Rodents, health hazards.
Somebody just sent me a video of roaches fighting.
That can be a problem. But not wanting you to put up a flagpole that's taller than a certain amount, or not being able to paint your roof, or paint your house a certain color, or those laws, all the little podunk little complaints you have about your neighbor, must have certain number of trees, or can't have more than this number of trees. Y'all people need to find a hobby that doesn't involve watching what your neighbor does. Anyway, that's it. So good luck, Mr. Boyd. I hope your son gets with you and get that resolved. Because I know one thing, and that's Judge McNally does not want to put you in jail. But he will if he has to. Honestly, I'm surprised that the township hasn't tried one of those legal maneuvers where they take your property. If it's been 25 years, if this has been a problem, they have not tried to condemn the property and say it's for public reasons and pay you the fair value and everything. We see that all over the place, right? I found an amazing house. Like we're shopping for houses, right? Which is really cool because it's fun. We get to shop all over the entire country. It's almost like window shopping because there's no commitment. We just shop on Zillow, find amazing houses, just things like, oh, this looks perfect. It has this whole over the garage area that would work perfectly for a studio. The length is right, so I'd have a longer studio instead of this short, squat one. And the square footage was right, and the price was right, and then had an monthly HOA fee of $4. And that's a deal killer for me. It is. I will not. And it's not the $4, as you can imagine. It's not the $4. It's that there's an HOA. It's that there's a group of people who are not myself who get to tell me how I get to use my property or how I have to use it. And it might be $4 today, but it's $4 that I have to pay every month. And maybe the HOA board down the road votes to make it $400. And if they do, there's nothing I can do about it. It just becomes $400. 400's way too much. $900 a year. Oh, man. Now, if you live in HOA, I'm not saying they're all terrible. They're just not for me, right? There are some HOAs, and I've seen them because I've actually been employed by an HOA. When I was in high school, we mowed lawns up in Park City, and HOAs would hire us to mow the community lawns. And so we were the community lawn. We'd mow every single house in the entire community, bar one, because I guess he was like the HOA president, and he would not allow gas-powered mowers on his property. So either we would mow with his push mower, which my boss did once and then said, I'm not doing that again, or he would mow it himself, which he actually preferred. So, but we were not allowed to refill our mowers anywhere near his property. He did have really nice grass, though. It was really nice. Anyway, there's some HOAs that just give. I mean, they're people. I've got friends who love them around here. There's a bunch around here. Some of the newer developments have HOAs, and they have a pool, and they have this. I've swum. I've swam. I've gone swimming in a HOA pool. Buffered top mark. Thank you. I'll click right now. Okay, it's not up yet. We're just waiting for the judge. But thank you for the reminder. I'll try to focus on that for just a second. And it's good. I've seen HOA clubhouses. I've seen the pools, the community, the playground areas and things that they provide. And that's awesome. If that's for you, find an HOA you love and more power to you. It's just not for me. And so for me, that perfect house that we found, which was beautiful, especially for like studio and storage and everything else, was a deal killer over a $4 HOA, monthly HOA. Can't do it. All right. Let's see if we have anything else we can watch here for just a minute while we wait to start the Top Mark Media Alaska live stream. Looks like Judge Simpson's doing domestic violence stuff. We'll skip that for now, I think. Don't want to go there. See if anybody else has court going today. Hold, please. If you go and you watch as a guest and you jump back to your account, it refreshes everything, which is helpful in a big way. Okay, Judge Phyllis is up. Just 1 second.
Your court costs 108, supervision fees 60, and 250 for attorney fees. You will be placed on a 6-month, or your sentence is 6 months. You will not have to serve that sentence as long as you successfully complete a 1-year reporting probation. It is reporting, so after court, walk down the hall to probation and tell them you're there to report. I'm going to let you pay at the rate of $112 per month, with the first payment due July 15th, and then you'll have one due on the 15th of each month thereafter. Did you want to do house arrest for 10 days or jail for 5?
I'll do house arrest for 10 days.
Wise
All
choice,
right,
sir.
you will be ordered to do that. You're going to start that up within 7 days. And
So you get a week free, then 10 days
anything
at
else,
home.
Mr. Baca?
I don't think there's anything from the state, Your Honor.
Mr. Patterson?
Judge, I just want to make sure he has the phone number for electronic monitoring, which is 316.
Yeah, we know there's a phone number. Maybe you could do house arrest during like March Madness.
My phone number is 3.
We don't need his number. Hey, don't stop.
Okay, I'm sorry.
But I don't want your personal phone number going over
Okay,
YouTube.
I understand.
Thank you, Judge.
That's why I stopped you. Okay. But thank you for wanting to move forward with the court. I appreciate that. All right, if there's nothing further, Mr. Leroy, you may go to court services, and this case will be adjourned for today.
Thank you.
Fulcher. Next one I have is Jimmy Fulcher. Fulcher with an F.
Oops.
We are on the record in BU 2023 TR 3075, State of Kansas versus Jimmy Lee Fulcher. Please announce appearances.
Thank you, Your Honor. Joseph Bach appearing for the state of Kansas.
Your Honor, Darren Patterson appearing on behalf of Jimmy Fulcher. He does appear personally from Courthouse Security One video station. Judge, this is a case where he was on diversion. It's revoked. The court did find him guilty of the charges. We're here for sentencing after obtaining an updated drug and alcohol evaluation.
Thank you. I do have that alcohol and drug evaluation. Did the state get a copy of that?
Your Honor, I did not get a copy. I wouldn't be surprised, though, if it went to Mr. Sweeney. But if the court has a copy, our recommendations are going to be to follow the recommendations in that.
Well, let me... I cannot get my computer to move up and down. I've got a Addiction Recovery Counseling Services certificate, but shouldn't I have the actual report, Mr. Patterson?
Do you have a Recovery Addict internet ownership certificate?
a.m. There was an email that went to court and counsel, including Mr. Baca, Mr. Regier, Jen, and yourself, that did have the updated assessment.
At 11, I have 11:32. I have a correspondence from you for the Monday morning docket. When I open it, it says Addiction Recovery Counseling Certificate Completion. And it just says 1 of 1, like maybe the evaluation didn't get hooked.
No, that was recently sent. I just wanted to provide that to the court because that was the original recommendation that he do the 48-hour program. And he's done that. At 7:54 a.m., there was another email to court counsel, and attached to it is a new Awakening Rio Rancho intake report, which talks about the assessment.
Well, I have a new Awakening Rio Rancho intake report, but it says the client's name has the initials EP on it. It's female. That's not what you're talking about, is it?
That might be it, Judge. I apologize.
You screwed it up, Mr. Patterson.
Could you give me a moment, Judge?
Sure.
It's okay. We can wait. Darren, I know you're busy. You handle basically every single public defender case that goes through this court. That's what you get for having the big sign right outside the courthouse with your phone number on it. It's the one the judge sees outside her window when somebody needs a public defender. Still waiting, trying to get the Alaska court live stream going on Top Mark Media. What time is it in Alaska right now? In Anchorage. Can somebody tell me without... I asked Grok what time it was in Alaska. Or actually, I asked what time it was in Utah last week, and I got it wrong. It completely mixed up the hours. It's 8:35. Okay, 8:35, 10:35. Okay, one of you has to be lying. $8:35 a.m. Okay. I think it starts at 9. we got a spam call. Hang on. Hello? Hello?
Hello. Yes, sir. Good afternoon. My name is Michael. How are you?
I'm fine.
Wait, I'm an answer machine.
You're an answer machine?
Sir, I think your sound is like that.
I've never been told I'm a machine before.
Okay, I'm on just your name is Scott. Is that your right name? Scott.
My friends call me Born, but that's just a
Sorry.
nickname, though.
Okay, by the way, sir, I want to say that do you have health insurance from Marketplace?
I think what you meant to say was, do I have health insurance from the marketplace?
Yeah.
Okay, I'm pretty good at guessing what people mean to say. Is that a bird? You hung up on me. I'm pretty sure I heard a bird in the background. He'll call back. It was like a macaw. It was like a parrot. Sorry.
And it's an attached drug and alcohol, and it went to Mr. Baca, yourself, and Jen.
See what this is.
And it was a add-on email to the one that went out previously on Mr. Fulcher with that certificate. So I think if you open up the previous one with that certificate, it should be on there. Mr. Baca, did you receive that? You're muted. Joe, you're muted.
Still muted.
Looks like it just came through. Mine was a bit slower, and I am reviewing that right now.
So you got the certificate and the evaluation, Mr. Baca?
Your Honor, in an earlier email, I did get the ADSAP certification, and then just now, as I'm reviewing, I do have the evaluation, and it does appear to have a date, April of 2026, and as well behind that, the February of 2024 prior evaluation. I do seem to have both that Mr. Patterson referred to.
Okay, I think I just got the evaluation. Okay, I do have it now. It just came in. Thank you, Mr. Baca. Thank you, Mr. Patterson.
Supposed to start at 8:30. I'm not sure why it's not going. Oh, there it is. Just popped up. Yay. Watch now.
Number 2.
All right, let me know, Mr. Baca, if you're ready to proceed.
I am ready to proceed when the court is, Your Honor.
We are on the record in BU 2023 TR 3075, State of Kansas versus Jimmy Lee Fulcher. Please announce appearances.
Thank you, Your Honor. Joseph Baca appearing for the state of Kansas.
Your Honor, Darren Patterson here on behalf of Jimmy Fulcher, who does appear from Courthouse 31 video station.
Announcements. We're ready here for sentencing. Mr. Baca, recommendations?
Yes, Your Honor. Your Honor, it appears we have 3 counts that we're here for on sentencing today. To make it easier, I can recommend counts 2 and 3 first and then do the DUI. Your Honor, we are recommending the scheduled fine on count 2 of $93. On count 3, Your Honor, there's also a scheduled fine we're recommending of $75. In regards to count 1, which is the first offense DUI, the state is recommending the following. Your Honor, we are recommending the minimum fine, $750, recommending a controlling jail.
Hang on, let me test this real quickly. This is Alaska, just to make sure the feed's working right. Looks like it is.
Please rise for the jury.
This audio is so bad. Okay. All right, that's over on Top Mark Media. We'll have that going today. I think that's good. Let me just double check.
I know probation can end early if they satisfy everything with the probation officer, but that's the arguments and reason for the state recommending that probation be reporting.
Mr. Patterson?
Thank you, Judge. Judge, as to the fines and costs, we're asking the court to adopt a recommendation of the state. They are essentially identical to what was on the diversion requirements. It included attorney fees as well as the fines and costs. The diversion also, well, let me state this. There was a motion to revoke diversion. It did state that the violations were not complete in a 48-hour program. We have provided a certificate because that was the results of the first evaluation was due to the ADSAT program, 48-hour program. He did do that. Judge, as far as conditions of probation, well, he's paid off the case. He's done his ASAP. If the DUI victim panel is ordered, he can get that done fairly quickly. This is a case where he has been on diversion for some time with no new violations. So there has been some time that he has been supervised, albeit by diversion. So we're asking the court to consider a non-reporting probation with just having to submit the DUI victim panel certificate, or a 6-month reporting probation, which should be plenty of time for him to finish a DUI victim panel and show that he's staying out of trouble. So we would ask the court to consider either non-reporting or a 6-month reporting probation. Thank you.
Thank you, Mr. Patterson. Well, Mr. Fulcher, the conviction is for driving under the influence at the speed of 78 miles per hour in a 60-mile-per-hour zone.
18 over.
And failing to check for safe passage before a single lane. All of that combined made for what could have been a very dangerous situation. Your fine on count 1, the DUI, is $750. Your sentence will be 6 months. On count 2, speeding, your fine is as scheduled, $93. Count 3, as scheduled, the safe passage is a $75 fine. Court costs $108. I am going to put you on supervised probation for 1 year, although it can terminate early if you do well. Accordingly, you also have a $60 supervision fee. I'm ordering all standard conditions apply. You will get credit for any fines and costs you've already paid. Now, you won't get credit for that money that went just towards the diversion application fee and the diversion fee, but any money you paid on those other things will be credited.
All right, we're gonna jump again. Sorry, it's court hopping.
You have completed the victim panel or
Thurston.
the recommendations for the evaluation.
Thurston is doing some civil protection orders. Sometimes these are neighbor against neighbor. I'm hoping that's the case, not domestic situations. But let's jump up there and see what's happening to Thurston.
I'm going to start with matter 26-251. So that's Carrie Marty as petitioner and respondent Brian Zeller. And before I swear the parties in, again, what I'm going to do, as I just indicated, is I'm going to briefly summarize what I view as the record so far. I'm going to bring that record up so I can reference it. All right. Okay. All right. So, Ms. Carrie Marty and Brian Zeller are, my understanding, former neighbors. While they were neighbors between December 2nd, 2024 through December 2nd, 2025, there was a civil protection order in place in which Ms. Marty was the protected party and Mr. Zeller the respondent. I know there was some allegations in the current petition around, possible behavior during that time, but there was no violation of the order as far as I can see during that period of time. December 12th, 2025, so soon after the order had expired, Mr. Zeller placed a letter in Ms. Marty's mailbox that appears intended to apologize and try to offer some context and want to build a relationship moving forward or things of that nature. A few days later, December 18th, 2025, Ms. Marty responded also in writing, indicating that she maybe appreciated where he was coming from, didn't want any further contact. Then January 13th, Mr. Zeller, I believe it's indisputed, but left a note on Ms. Marty's doorstep or around her property saying something to the effect of all it would have taken is being nice. Ms. Marty interpreted that in sort of a threatening way. Mr. Zeller has denied that there was any threatening intent behind that. Fast forward to May, Ms. Marty claims that Mr. Zeller had some words with her daughter. Mr. Zeller indicates that doesn't recall that. And then on May 6th, there's an argument between the two. The nature of that argument is very different depending on which side sort of tells it. But there was some sort of argument between the two, leading to Ms. Marty contacting law enforcement. And then since then, my understanding is Mr. Zeller has left and is no longer neighbors with Ms. Marty. But nonetheless, the petition was filed, and here we are. So that's my review of the record. So again, I'll give parties a chance on both sides to, again, fill in the gaps, correct me where I'm wrong, provide extra context, that sort of thing. But I think it's helpful to know where I'm coming from. So to begin then, we'll start with the petitioner. It is Ms. Marty's burden. So Carrie Marty, if you could please raise your right hand. Do you swear or affirm that the testimony you're about to provide on this matter is the truth and the whole truth?
Yes,
okay.
I do.
Go right ahead.
All right. I did move here back in 2023. I moved from Snohomish to be by my sister. She had moved here the year before. I met Brian and exchanged numbers just for in case of emergency and just overall neighborhood watch. After a few months, he began showing signs of unstable behavior and would often lash out via text out of nowhere and out of context, completely initiating contact. In the beginning, I would ask him if these messages weren't meant for someone else because it didn't make any sense to me as to why he was sending them. He would later apologize profusely, telling me he was dealing with stuff and he was so sorry. I began to avoid him because I didn't want to trigger any of these outbursts. This came to a head when he began involving my daughter in his rants and accusations, and at that point, I had requested the anti-harassment. Fast forward to the current, respondent he did drop off the letter in my mailbox. He signed off by saying, if you're not capable to forgive and he would understand, and if that is what I wish, he wishes me the very best. I did respectfully decline in writing, saying I would prefer we continue the no contact the same as the past year. This was mainly because I didn't know what was triggering him and I didn't want to go through it again for both of our sakes. It was extremely unnerving for my daughter and myself in a new town. I signed off on that letter. Continue to get better. I wish you well. This is where it should have ended. Nothing else should have happened after that. January 13th, he did leave a note on my front porch. It's not exactly close. He would have to walk quite a distance to get there. I did send him a letter. I did tell him I had been nice. I literally just wanted to be left alone. I signed it. Please just leave me alone. On the 2nd, he did approach my daughter while she was getting the mail. She can talk through that when it's her turn. It did frighten her, startled her. She did return to the house quickly. On the 5th, the respondent's landlord came to my house and asked for clarification regarding an allegation made by the respondent. Both my daughter and I provided statements. Before he left, he warned us he was going to be terminating his lease and that the next few weeks were going to be tense. On the 6th, I was moving storage containers from my garage to my shop so I could work on a leak I noticed over the winter. I noticed there were a dozen new molehills in the yard. I grabbed the deterrent. I was bent over at the first molehill when he came out of his house towards me, started yelling excessive profanity and name calling. He was screaming that I had ruined his life and I had harassed him for a year and a half. I yelled back to please leave me alone, that I hadn't looked at him or in his vicinity, nor had talked to him about him. I just wanted to be left alone. At this point, there were people at Subway watching as he continued to yell at me, stating the whole town had been following him. I told him I only knew my sister and her daughter's family, and he said that was BS. He went on to say I was being investigated by the police and I had no idea what was coming for me. Just wait. Knowing this was escalating and I wasn't getting anywhere, I just yelled back, fine, I'll call the police so they can work this out. He continued to yell at me until he realized I was on the phone with a non-emergency operator. He ran into his house, ran back out, got in his car, and peeled out shooting rocks. I did end up speaking with the officer and decided to resubmit for another anti-harassment order. The declarations that were made regarding his sister's declarations, both of those are solely based on individual conversations and not witnessed facts. I know the respondent has extreme anxiety. He has told me that. He has a hard time in the past with his perceptions, and I've personally witnessed it and documented it in the first protection order. Regarding his declaration, there's things I feel necessary to address. His statement regarding how we initially met and our interactions thereafter are grossly misstated. From day one, I was kind and accepting to what he was going through because my youngest daughter was going through similar struggles, and this was confirmed as he admitted in his handwritten letter. The reason I care so much is because you guys were nice to me when it mattered most. This is a very big deal. If there's anything I can do to make up for how I acted, I would gladly be willing to do so. His statement regarding my daughter's boyfriend revving his car at all hours of the day and night for 8 months is completely inaccurate. My daughter's boyfriend stayed with us just short of 6 months, and 4 of those months, his car sat inoperable in the grass by my shop. On February 19th, they broke up and he hasn't returned since. His claim of my daughter yelling from the highway and from a truck doing burnouts and driving past his house is preposterous. My daughter has intentionally avoided him at all costs, included not going outside if he's outside. As you can see from the Google map image I provided, how far away the highway is from his house, where the subway is, and the abrupt dead end blocking with the pole yard on the other side. I have had few family members and friends visit from Snohomish, 4 at the very most, and it was my kids. No one we know owns a truck. I've never witnessed any or seen burnout marks in my road between our houses. And then lastly, I just want to address the claim that I was the reason he was evicted. I did submit a statement from his previous landlord discrediting that claim. In turn, I could have had my sister submit a declaration as she's personally witnessed this behavior, but I did not want it to turn into a tit for tat or he said, she said. I'm not here to place judgment or attack his character. I am fully aware that he has since moved to Westport as he outlined in his statement. However, his mother resides in Chehalis and he has family all around the area. Given we live in a cluster of small towns with most retailers found in Centralia, Chehalis, there's a significant probability that we could be at the same retailer, restaurant, or area at the same time. Given his history, I'm not sure he could refrain from lashing out or making a scene if he saw me or my family in public. That's all, Your Honor.
Wow. What happened to the mole? I need to know. I was concerned.
Thank you, Ms. Barty.
Did you fix the mole issue?
All right. And all right. When it comes to non-parties, and so now, and this is this Madison. Oh, I guess it's labeled there. Madison Marty's at you, ma'am.
Yes, it is.
All right. So non-parties typically are not allowed to testify unless the court finds their testimony would be necessary and material for making a decision. In Madison Marty's case, while she's not necessarily the petitioner, she is listed as a protected party in the petition, and some of the allegations and the response to those allegations do involve interactions exclusive with Madison Marty. If there's anything, so you don't have to testify, Madison Marty. If there's anything though that you would like to add as far as the allegations from May 2nd or any of the others, you're welcome to testify as well. And if so, I'd put you under oath first, but is there anything, I just asked first, is there anything you would like to tell me?
Yes, Your Honor.
Okay.
Just a quick one from May 2nd.
All right. If you please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
I do.
Okay, go ahead.
May 2nd, it was about 10 a.m. and I had just woken up. I noticed that I had got a notification that I had a package delivered, which I did not after going out to the mailbox, but I didn't know that. I walked outside in my pajamas, unknowing that Brian was outside. I didn't have my glasses on, so I was squinting. I couldn't exactly see. When I went outside, I turned my back. I could hear him yelling across the yard from behind me. He wasn't standing in the driveway. He was standing in his yard, but facing me and directly talking to me. I don't exactly know what he said in the first part. I know in the second part, he said, "You guys just need to be nice," but in a very angry tone, I would say.
He was not nice about it.
I said, "Okay." He just kept saying it. I said, "Look, I'm sorry. Have a nice day." And I got back inside as quick as I could. I told my mom what happened. And that is all I have from that day.
Okay.
So we have moles now in an unknown package. So many cliffhangers.
Are you able to describe how that made you feel?
Shaken up just a little bit. I do have a problem with like confrontational anxiety. So when I do get confronted or yelled at or things like that, my body does tend to my heart rate just spikes. My body goes numb a little bit. It's kind of like an adrenaline rush, but in opposite effect. So I was definitely shaken up a little bit. My heart was racing when I walked inside, and I couldn't feel my legs.
All right. Thank you, Carrie and Madison Marty, for your testimony. Next, I'm going to hear from the respondent and the respondent counsel. Ms. Cruz, would you like to go first? Would you like your client to testify? I'll sort of let you direct the ship on your end.
Yeah, Your Honor, I have some questions for my client.
Sure. All right. Then let's see, Mr. Zeller. Did we lose Mr. Zeller?
Yeah, that's our first question. Where did he go?
If we did lose him,
It's like
he
whack-a-mole.
did let me know that he doesn't. Oh, he's getting back. He's getting back on. He got kicked off really quick.
All right. We'll hold off for Mr. Zeller.
Not a good look, sir.
And then I would like to reserve a closing.
Sure. All right, Mr. Zeller, looks like we lost you there for a minute, but now you're back. Are you, can you hear us okay? There we go. Nope, no problem.
Had to
All right,
address
Mr.
the
Zeller,
mole issue.
I'm going to put you under oath now, and you'll take some questions from your attorney, and I may have some follow-up as well. If you could please raise your right hand. Do you swear or affirm the testimony you're about to provide today is the truth and the whole truth?
Yes.
All right. Go ahead, Ms. Cruz and Mr. Zeller.
Thank you. Mr. Zeller, tell us what was the intended purpose of that initial note that you had left in their mailbox?
If he says dating.
I just wanted to apologize for them dealing with my anxiety, and I wanted just to move forward in a more positive and friendly manner.
Okay, and tell the court, just in case it might become an issue today, do you suffer from extreme anxiety?
Yes, I do.
Okay, does it sometimes get to a point where it's debilitating?
Yes.
Okay. Any notes that you've ever left or any letters that you've ever left to the petitioner, were any done in a threatening manner?
No.
Okay. And tell me about the day where, well, let me first say, do you remember or do you recall a day where you were speaking to their daughter on May 2nd?
No.
Okay. And tell me about the verbal disagreement that was outside. Tell me about that day.
Anything specific?
Just tell me how kind of that it started.
I was just going to my mailbox. I just woke up. I was groggy, and I came out and was walking to my mailbox, and she was digging in a mole hole, and she just pokes her head up and like giggles and tells me she got me evicted, and then from there, I said that she had issues, and then I asked her to stop having her friends harass me and going by my house, and she then said that she claimed that she didn't have any friends, and I then said that's BS, and I went inside and I went over to my she ran over and sat on her porch and called the police on me. So I went inside to grab my keys and left and went into my friend's house to get away from them.
Okay. Did you perceive the petitioner at that time as afraid of you?
No. She also stated that she told me to come fight her.
Okay. And so is it your testimony who started the discussion?
I'm blaming the mole.
She did.
She did.
There's
Okay.
clearly a mole.
And Mr. Zeller, when did you move? Approximately.
Gosh. I think it was about a month and a half ago.
Okay. And where did you move to?
I stayed in cabins in Ocean Shores to get away, and then I went to my original hometown, Westport, and I've been here since.
Did the cabin owner know you were there?
Approximately how far of a drive is the city of Westport to Rochester?
About an hour and a half.
Okay. Do you, the petitioner states that you have family in Rochester. Tell the court, are you close with those family members? Do you visit them or not so much?
The ones that are in Rochester, I don't really talk too much, and they visit me anyways. And my parents actually live farther south. So I don't really see any reason for me to even run into them.
Okay. Do you have any desire to go back to your former residence or even Rochester at all?
No.
Okay. Did you, when you moved, did you have any belongings at your home that were left?
Yeah, I actually left some of my belongings because I was so uncomfortable. I didn't even want to be there. And I called my landlord's son and asked if he would meet me there, so then I would have someone there just in case anything happens. And he said he wasn't able to, so I declined to even stop there because I was just too uncomfortable to be there by myself.
Okay. And the petitioner alleges in her petition that despite you moving, she's afraid that you'll return to harm her, her daughter, her dog, or damage her property. Mr. Zeller, have you ever hurt her, her daughter, or her dog?
No.
Have you ever damaged their property?
No.
Do you have any reason to have any further contact with the petitioners?
No.
Have you ever released
Okay,
moles in their
Your Honor,
lawn?
those are all of the questions that I have. Thank you.
Thank you, Ms. Cruz. All right, Mr. Zeller, I have just a couple of follow-up questions of my own, and they are specifically around the May 6th incident, because that's where I think yours and the petitioner's kind of allegations seem to diverge more than anywhere else. And so in the petitioner's exhibit materials, she describes the May 6th incident as, let's see, I got to zoom up on it. Sorry. She claims that during the course of that argument, that you said something to the effect of, you have no idea what's coming for you. Do you recall making that statement or something similar to that?
No, I never said anything like that.
Can you think of anything you may have said that could be sort of interpreted as something to that effect from that incident?
No.
And it was your testimony, if I remember correctly, that you were walking to your mailbox and that Miss Marty initiated the contact that led to that argument. Is that right?
Yes, Your Honor.
Okay. All right. Those are all my questions, Mr. Zeller. Thank you. Yeah, I know Ms. Cruz requested some time at the end to make a closing statement, and that's fine. I'll have my final kind of engagement here is I have a few rebuttal kind of questions for Carrie Marty.
Ask about the mole on the
and
package.
again, this is trying to suss out a bit more of this May 6th incident. And so we've got Mr. Zeller.
What was the deterrent?
Testifying that his understanding was that you initiated the contact. I know from your description of May 6th that you believe he initiated the contact. Can you talk more about how that engagement started?
She was talking to the mole. I got you evicted to the
sorry,
mole.
I'm frustrated. I was bent over and I'm like putting deterrent in the hill, like in the molehill. And he starts yelling. He's outside, he's yelling, and he's like something to the effect of, I've ruined his life and for a year and a half. And then I looked up and he is, the only thing I can say is spewing. It was like this, almost a minute long repetitive statement as if it had been rehearsed, and he's just going off on me and screaming, and I've ruined his life. And I'm like, I kept saying, just stop, just leave me alone. Nobody's talking to you. I know he claims I have all these friends. I don't have friends here. I was very uncomfortable. It makes my, it's unfortunate because I'm sure he is a nice guy, but if you look at this entirety in this pattern, you can see that he is not only tormented me, but some of the things that he has said in text messages are just bizarre and unnerving. I have called the police multiple times because it does freak me out when he starts getting like that. So when he said, just you wait, I was shaking so bad. I'm like, that's fine. Let me call the cops right now and let's get this figured out because I can't do this.
All right. Okay. Thank you. And I asked him about this statement. So I'll ask you too. I know, again, I have your exhibit here in front of me. So your recollection is that he said during the course of this, you have no idea what's coming to you. Is that what you, okay.
Yeah, he said I was being investigated and that I have no idea what's coming to me. Just wait. That's when I panicked and I was like, that's fine. I'll call the cops right now and let's just get this figured out. And he's still yelling at me, and there's people in Subway staring at us. In the moment, I wish I had just gone to get a statement, and I didn't. But I did call non-emergency line.
Subway has moles?
Okay. All right. Thank you, Miss Marty. I'm going to hear from Miss Cruz next. She'll have some concluding remarks to make there. I don't have any more specific questions for you. Is there anything you'd like to say to sort of summarize your petition? Or any concluding remarks?
Is that from me, Your Honor?
Yes.
One thing I just want to say is I didn't want to bring any of the previous tenants, relationship with their landlord up, but he had a moving company provided by his landlord and they cleaned his house out. So I'm not trying to do this out of any, I live in a very small town and there's a grocery store here that's expensive. So I'd have to go to either Walmart or even if I need anything for my house, Home Depot. That's all in Chehalis. There's very few large box stores here and I have to go down south to do any shopping. So I'm not sure how I want to end that statement and I'm flustered.
All right, understood, ma'am. And thank you. That's fine. And again, I do have your petition in front of me with your statement. All right, Ms. Cruz, I'll turn back to you for concluding remarks.
Thank you, Your Honor. A few different things here. First, really, when you look at the situation as a whole, I'm going to argue that there's no course of conduct. So we do have a prior protection order. I understand that. However, here, the next thing that we have for this protection order, the first thing we have is a letter that did not in itself alarm, annoy, harass, or was not detrimental to the petitioner. She has not testified to that letter in itself has completely just bothered her. And then we have the petitioner sending back a return letter. She actually even sat on that first letter, not sure what to respond for a while. She said it took her a little bit of time to think about, but that letter in itself wasn't detrimental. And then we have a situation where the petitioner is saying that my client spoke to her daughter. My client doesn't actually remember that day. And to be honest and fair, Your Honor, the petitioner's daughter testified that she couldn't see my client nor she could barely hear if it was my client. So it's not even completely known what was said, nor if it was him. He doesn't recall that specific contact with the daughter in itself. And then we have an alleged note in a door here. I think that it could be annoying possibly at this point. This is where I think we have the one conduct, but course of conduct has to be two or more separate continuing acts or contacts. So I think the note in the door potentially could be. However, what was specifically stated in that note, I don't see how it could be very detrimental to somebody's mental health. There's no threat, there's no anything like that. More of anything like, okay, that was a weird thing to say. Lastly, we have a verbal dispute outside. There is some different renditions of this depending on who you speak to, but my client is testifying today that she spoke to him first. Additionally, although the petitioner is not required to, she has heard multiple times now that my client has said that she has threatened, hey, come fight me then, and she hasn't actually denied that she said that. So my first argument is that there's no course of conduct. My second argument is that there is some testimony to emotional distress. There's not enough testimony as to substantial emotional distress. Some annoyance, or like I said, even some emotional distress is not enough under the RCW. It must be substantial. The daughter even testified after an encounter where she could barely see or hear a person. I wrote, she specifically stated, I was shaken up, quote, just a little bit. Surely not substantial emotional distress. And my last argument is, although it's not required to prove under the statute, I still think this does matter. My client moved away. He moved very far away. In fact, he moved an hour and a half away. Even if he were to come visit family and, let's say, accidentally run into the petitioner at Walmart or what have you, if a protection order was put in place, that's not going to prevent accidental run-ins. What it can prevent is somebody speaking to one another, but it's surely not going to prevent an accidental run-in. However, despite that, my client has no intention to return to his former neighborhood at all. The petitioner states she is afraid that my client will come back to Rochester. That's a fear. There's no proof of that. Lastly, the petitioner states that she is afraid he will mess with her house, car, daughter, or dog. There's no proof of any of that happening. He has not physically harmed anybody, and he has never, come and destroyed their property, for example. So at that point, we have a fear that he is going to return. But Your Honor, that's not at all what my client is testifying that he wants to do. So I think that it matters. And, he didn't move 20 minutes away. I think it would be he would have to travel an hour and a half to come harass these people and then leave. I don't think my client has any intention of doing that, and he testified today that he doesn't. He just is trying to move on with his life. So, Your Honor, based off of the no course of conduct or no course of conduct or a lack thereof, and then not enough testimony to establish substantial emotional distress, and the fact that my client has moved away, we're asking to find in my client's favor and find that the petitioners did not meet their burden. Thank you.
All right. Thank you, Ms. Cruz. All right. I'm going to just take a minute or two and finish up reading a few of the materials here from both sides before I make my decision.
And Your Honor, I apologize. I would like to make one objection. I was sent an email that was provided, it looks like, from my client's former landlord. Your Honor, I understand that there's very relaxed rules in these hearings and that pretty much anything goes. However, it's not at all provided under penalty of perjury, and I always think that matters. So I'm going to argue that the last thing that was submitted should not be considered. Thank you.
All right, thank you. And I don't actually know if
already read it. Marty has her hand up.
I even had a chance to review. There's an email from the former landlord. Is that what I'm hearing?
I don't know. I was sent, petitioner tried to serve me with the document. It wasn't attached to the email. I let her know it wasn't attached to the email, so she forwarded me an email that was from the former landlord. So I don't know how you're looking at it, but I know she's shaking her head. Can I ask the petitioner? She's been shaking her head the whole hearing. Please stop. Thanks.
You can't.
All right. Well, so here, hang on.
Look at the look on her face. Oh my goodness.
Yeah. I haven't had a chance to review what has been filed on. Looks like that was Thursday. Part of it too is there's once cases are filed, the notice rules apply to when somebody is served before a hearing to give parties a chance to hear everything.
Your Honor.
Thursday before the hearing. Is that Thursday? Yeah. Okay.
This is going down.
We do try to, again, the rules, as Ms. Cruz there noted, are relatively lax. But when it comes to the rules of evidence, which don't apply, yeah. Okay. Go ahead, Miss Marty, if you'd like to say a few words here. But I'm just looking at this now. Go ahead.
Your Honor, the declarations were shared with me 5 business days prior to today. I was, first of all, I didn't address everything that was in those declarations, but I wanted to address the one where he's blaming me for him getting evicted. So
yeah,
I called the court.
Hang on, Miss Marty. So there's a couple of things that I want to just kind of focus in on. The first is, so I've got looks like Mr. Weaver submitted information about kind of the issues with tenancy. I'm not considering on one side or the other. Mr. Zeller's kind of what happened for him between him and the landlord and what led to an eviction. I'm not considering that. I'm looking at Mr. Weaver's email. I don't really find this relevant. And then on the same time, I'm not, the arguments that Miss Marty got him evicted as well, I'm not considering as a response either. So this evidence around and the arguments around, Mr. Zeller being evicted and who got him evicted and the landlord's perception of him as a tenant, I'm not considering any of that as part of my decision today. And so I think that is a separate issue that I'm not considering one way or another. What I do, though, think is relevant, and I know I kind of already noted that Miss Marty had said her final piece here, but I do have one last follow-up question. Miss Marty, do please try to keep your comments confined to answering this question. Ms. Cruz did raise as one of her arguments testimony around the elements on substantial emotional distress. That is a question in my mind as well. I know that's something that you didn't really expressly hit on one way or another. As the finder of fact in these hearings, I'm able to observe witnesses. And while you're on Zoom, it's my observation that you seem, in my opinion, rather distraught. Again, the finder of fact here, one of my roles is to assess witness credibility and how witness presentation. But at the same time, I think Ms. Cruz does make some good points. I do want to give you, though, the opportunity, since it's your burden, to address that particular argument on even taking all of these things as true, whether or not that led to substantial emotional distress. I'll give you an opportunity to address that argument, though.
I wish sorry. The amount of distress that this has caused me is unmeasurable. I've gone to the doctor multiple times. I shut the curtains in the front of my house. I hide in my house because it faces that side. Only in the last month have things really started to calm down, and I feel like I'm getting my peace back. But no, everything that he does and says, it literally rings like panic, sheer panicked. So, yeah, he said not to bring anything up, and that's fine. I don't know how else I can say it. I'm trying to be respectful. I just want him to leave me alone.
All right. Okay. Thank you, Miss Marty. So this time I'm prepared to rule. And for the record, I didn't consider arguments on either side regarding Mr. Zeller's status as a tenant or the eviction and reasons behind evictions and things of that nature. I agree with Ms. Cruz that isn't necessarily relevant to these particular proceedings. That said, I am finding in favor of the petitioner, and I'm going to go through why. And I'm going to start with the no course of conduct argument that was raised by Ms. Cruz. And I think it's important to address. It's also the first element. And as I said at the beginning, Ms. Cruz is correct that a knowing and willful course of conduct is that very first element here. And I do find, though, that it's more likely than not that a course of conduct exists. While the original civil protection order had expired when the current allegations began, I do think the status of that order is relevant for determining not whether there was a violation of a court order, which there wasn't, but whether there is an ongoing course of conduct. And I think that the first civil protection order expired on December 2nd, and then on December 12th, Mr. Zeller, sort of which is not in dispute, puts a letter in Miss Marty's mailbox. I think that does show that he was ready to engage with the Martys as soon as that order expired. If it had stopped there, I don't think there would have been an issue. Miss Marty, she indicated, kind of sat on that for a few days and considered it. I think she was upfront in her response, even that she took some time to think about what he said and whether or not to allow continued contact, but did then reply and pretty unequivocally saying, essentially, I wish you the best, but I would not like any further conduct. Again, at that point, I think everything is fine. I don't think there's been any unlawful harassment at that point. What concerns me, though, is then about a little less than a month later, there's another note from Mr. Zeller to Miss Marty on her doorstep saying, all it would have taken is being nice. Even if that wasn't intended as a threat, which I'm also, observing, Mr. Zeller, it seems in the context of the nature of his first note and then this one, I can see a world in which there was no real harassing intent behind that. But that does come within the context of pretty unequivocal response from the Martys saying, go on any further conduct. And then there are allegations after that of further engagement. I realize engagement when there's neighbors, that can be difficult to avoid. But I think looking at this as a whole, stepping back and looking at the greater context here, we've got a civil protection order expiring a couple days later. We've got a written note, a response saying we don't want any contact, but additional written communication after that. And then at least one disputed, but an allegation of contact, and then undisputed contact between the two. So I think looking at that in the context of this first protection order having just expired, I do find that there's that course of conduct. I also find that there's evidence of both subjective and reasonable substantial emotional distress. Again, as the finder of fact, one of my jobs is to assess witness credibility, and I think it was outlined in the written materials. Miss Marty had expressed in her written materials, feeling distressed. I take her testimony today as substantial emotional distress. And I also think looking at the substance of the communication, again, that first note being sort of apologetic in nature, I think that coming on the heels so soon after the first order expires and then follow up in written engagement, I do think that would again, looking in the greater context, would cause substantial emotional distress. And the last thing I'll say on that too is, I think the first letter from Mr. Zeller was on balance sort of kind-hearted and understanding, Mr. Zeller, your the anxiety that you suffer, and I don't dispute that at all. It seems like you really do. And so the on balance, the note does seem to be sort of good-natured. But another thing that sort of does concern me is at the end, at your postscript, you do say that, I'm genuinely trying to do the right thing, so please don't get freaked out or try to get me in trouble. What that tells me is, even in that first note, there was a sense that, this might not be okay, and this might not be acceptable for me to have done this. And I think that's clear in the PS that already there's that sort of.
Am I able to respond to that?
Well, I've made my decision, Mr. Zeller, and so at this point, again, on balance, I think you were reaching out to try to mend fences. I'm not saying there's anything ill-natured there, but I think the ongoing communication after that pretty unequivocal response from Carrie Marty, that's really what I'm kind of grounding my decision on. And then the final piece about, it sounds like you live in Westport, and you're not neighbors anymore. That is important in these decisions. But that said, this is, that doesn't necessarily categorically mean that, a no protection order is no longer appropriate, especially when we are in a relatively small community here in the South Sound area. So I don't think someone moving from Rochester to Westport necessarily addresses some of the concerns about ongoing contact in this situation. So I am granting the order. It will continue for another year. The provisions of the order will include
everything from the previous order. I was surprised they got it. I didn't think.
And folks will get copies of these, but they will include no contact with both the Martys, Carrie Marty and Madison Marty, directly or as it shows in the order through third parties or electronically. As well as a let's see. Yeah, and then there'll also be the exclude or stay away order. Now, I understand that, Mr. Zeller, you live in Westport now, so hopefully the exclusion from Miss Marty's property is not going to be a problem there. If you all do run into each other incidentally, as the language of the order indicates, it's not coming within or knowingly remain within 1,000 feet. So what that means is it allows for that kind of incidental contact, provided there's no communication. You just got to extricate yourself from the situation. So if you run into each other at the store, it's knowingly remaining after knowing you're within that buffer and then knowingly remaining,
you leave.
That's the violation there. So it does allow and recognize for that incidental contact. So those will be the two restraint provisions of the order. Like I said, I'll be signing those today. Mr. Zeller, I'm going to ask you if you have any questions. I'm making my decision now, but do you have any questions, sir?
I'm just wondering, if they were to continue to harass me, well,
counter.
Well, I can't give you legal advice. What I'll say is nothing prevents you from going through the same process as a petitioner.
I was told that's retaliation. I actually wanted to do that myself, but I was scared to because it looking like retaliation.
Well, talk to an attorney. It sounds like you've got Ms. Cruz in her firm. So if you have legal questions, I'd direct you to your attorney. Okay. But you being the restrained party in a protection order doesn't prohibit you from engaging in the same process. So talk to your attorney.
He'll be back.
Any other questions, sir?
Nope.
And to the Martys, any questions?
No, Your Honor.
All right. I'll be signing that order later today, and then do we send out? I forget. Do we send
It's just the electronic case file.
It's just an okay. All right. And so I will be in the electronic case file. So that file that you all accessed to upload your exhibits for today, for today's hearing, that's where a copy of the order will be if you would like to review it and grab copies of those. All right. So thank you all. Thank you, Ms. Cruz, as well, for being here today. And you're all excused and allowed to log off.
Thank
All
you,
right.
Honor.
All right, we're gonna jump. We've got Minecraft Court. Something happened in Minecraft Court this morning that we have to check out. So we're going to go there. It's a little bit longer. We haven't been Minecraft Court in a long time.
Give me just a moment here. I'm gonna.
That one. Hang on.
Noted it was 1548, and I believe the prosecutor asked you that's the time when he came to the door. Is that? Do you recall that?
I believe so.
Did I rewind all the way?
3:48 in the afternoon.
Yes.
Which was
Yeah, that's what it started. That's how it starts.
I'm looking at the body cam footage, and I noted it was 1548, and I believe the prosecutor asked you that's the time when he came to the door. Is that? Do you recall that?
I believe so.
Which would have been 3:48 in the afternoon.
Yes.
Which was approximately 2 minutes after his wife had answered the door.
Correct.
Because you did in your report, you say it took several minutes. Did you even open the door to see if they were coming?
Correct.
Okay. At that point, did you think he was being evasive, or do you think he was doing something nefarious?
I did.
Once he came to the door, did that dissipate?
I mean, he changed his clothes, so I was.
If you had blood coming down from you, and wouldn't you clean yourself up?
Yes.
And it appeared to you that he had cleaned himself up.
Correct.
Did you have any doubt that he was the one operating the motor vehicle based on your investigation up until the point he came to the door?
No.
The questions that you would ask him, one of them was, you talked to him, or you didn't ask him, but they had asked you, the prosecutor asked you, did you see anybody else at the house? You answered no, correct?
That's right.
Did you guys inquire as to whether or not there were any other occupants of the house or anything?
I didn't have a need to, so no, I didn't.
As part of your investigation, Mr. Boyd, Dennis was what you needed.
Correct.
And that's what you focused on?
Correct.
Okay. Now, when you showed him the picture, did you feel that it was fairly obvious that it was him with the motorcycle, the person that was in front of you, and you showed that to him and he said he didn't believe that was him? What did you think at that point?
I was hoping he would just come clean. That technique works a lot for me, and it didn't that time.
And that's not unusual for people that you're investigating, for them to lie to you, correct?
Correct.
People want to try and avoid any issues that they would have?
That's correct.
At what point did you arrive at the hospital?
I don't remember. It would have been minutes before that warrant was signed.
The 6:43 time that you were asked when the judge signed it, you would have been there just a few moments before?
Correct.
And then with him saying he wanted to take a pee, had he asked repeatedly to go to the bathroom?
I believe so.
Approximately how long prior before you showing up did you learn that he was trying to use the restroom?
I think I was told that by either Officer Hagen or one of the nurses.
So it would have been going on prior to the search warrant being present at the hospital, correct?
Correct.
Why would he be allowed to have any water?
Didn't want to dilute any test.
Is that based on scientific knowledge or just common sense that you guys would believe as officers?
I don't know. I mean, it just makes sense to me that water would dilute a sample. And if we were allowed to have have him have water, then we would be challenged on why did we let him have water. So the easiest thing is you're not gonna die in 3 hours, so you're just not gonna have any water.
In your investigations, in your experience, training, and everything you know as a police officer and a human, one of the things that affects people and their ability to focus, concentrate, would be a head injury, correct?
Correct.
And it's pretty obvious from the reaction of the fire department that that was something significant, correct?
Correct.
Were you aware that he needed staples to treat that injury?
I was informed later, yes.
Was that surprising to you based on what you had seen from Mr. Boyd's injury?
I didn't know it would need staples, but I mean,
you're not the medical expert,
correct.
But you're not surprised by that after you saw it, correct?
Correct.
So would it be...
All right, I'm being told I'm doing this wrong.
That would have affected him and his ability to focus or think or respond?
Okay, hold on. So, let's see. Josh says if you're going to watch this, you have to start from the video from this morning. That is 56, 54. It's broken up into 4 different videos. This is the only one I could see. Hold on. Let me see if there's another one. We'll pause right there for a second. Judge John P. O'Donnell. Okay, there's Minecraft. Okay, we have to start at the 56-54. There's a whole bunch of videos. Okay, so we start at the 56-54. Which one's after that? Give me the timestamp, Josh, sorry. We'll start at this one. Then we'll jump to the... It's called Minecraft because if you look behind me, the pixelated part of the window is the jury box. That's the Minecraft portion. This is a bench trial, though. We're waiting for the part where the defendant takes the stand and might not be telling the truth. I can hear someone's mowing the lawn outside the courthouse.
All right, this is 20C, or 26 CR 182, State versus Dennis Boyd. 5-count indictment. Ms. Tuttle, with regard to the indictment?
Your Honor, the state would move to dismiss counts 2 and 3 of the indictment prior to trial and would ask to renumber it so that counts 4 and 5 are now counts 2 and 3.
All right.
Did I say that?
Mr. Deeb?
No objection, Your Honor.
All right, so 2 and 3 will be dismissed. Count 4 will now become count 2, and count 5 will be count 3.
Thank you.
Anything else preliminarily?
Yes, Your Honor, we do have a signed stipulation. The parties have stipulated to the fact that the defendant does have a prior conviction, to the authenticity and admissibility of the certified copy of that prior felony OVI conviction, and to the chain of custody, authenticity, and admissibility of State's Exhibit 2, which is a buccal swab taken from the defendant in order to do a comparison of DNA.
All right, has that been signed by everybody?
That's been signed by all parties. And can the state move to admit those 2 exhibits now as well?
Yeah, go ahead. What exhibits are they?
1 and 2.
Any objection to that? I assume not. Okay. Let me see those, Laura.
It's definitely lawn care day outside the courtroom, and this morning was vacuuming the courtroom carpet day as well, as you can see. Like a good carpet in the courtroom. Helps keep the noise in the room low.
Okay, so 1 and 2 are admitted pursuant to the stipulation. Yeah, please. All right, anything else before we start?
We're prepared to proceed with opening statements.
Mr. Deeb, are you prepared to go?
Yes, we are, Your Honor.
All right.
Mr. Deep has all the stickers on his laptop.
Actually, Your Honor, we would move for a separation of witnesses.
Granted.
And I would move to incorporate the indictment into my opening statement.
That's also granted.
Thank you. On October 20th, 2024, at about 3:20 p.m., the Menor police responded to the scene of a car crash. A motorcycle had driven directly into the back of an SUV.
Ooh.
The rider was in the street and he was bleeding from his head. You'll hear that the driver of the SUV called for help, but the motorcyclist said, "No, don't call 911. You'll hear that the motorcyclist was the defendant, Dennis Boyd. You hear that an unidentified individual helped the defendant onto his bike, and while still bleeding from the head, the defendant drove away from the scene. Upon arriving to the crash scene, Menor police found blood in the roadway where the crash occurred and blood on a broken-off mirror to a Harley-Davidson motorcycle. That blood was swabbed from the roadway and sent to the Lake County Crime Lab, where it was determined to be the defendant's blood. The driver of the SUV was able to get a photograph of the defendant before he left the scene, and Menor police were able to determine that the motorcycle was registered to Dennis Boyd, who lived on Heather Hill in Menor, Lake County, Ohio. Police responded to the defendant's residence less than 30 minutes after the crash. At his home, they located the motorcycle involved in the crash hidden inside of his garage. Additionally, police located the defendant, who appeared to have just recently showered and changed his clothing. You'll hear that when confronted with the details of the crash, the defendant denied any involvement. You'll learn that the defendant smelled of alcohol, had bloodshot, glassy eyes, and refused to perform standardized field sobriety tests. The parties have stipulated that the defendant has a prior felony OVI from 2015. He was then placed under arrest for OVI and began bleeding from his head while in the back of the police car. You'll see the blood was in the same location as it was in the pictures taken by Vanessa Clapp at the crime scene. The defendant was taken to the Menor Police Department and then transported by ambulance to Lake West Hospital. You'll hear how he was observed at all times, how he was read the BMV 2255 and refused to submit to any chemical testing. You'll hear how he only complied once officers had a signed search warrant to take his blood, and how blood was drawn 3 hours and 35 minutes after the time of the crash. You'll further hear how this blood was sent to the Lake County Crime Laboratory for testing to determine blood alcohol concentration at the time of the crash, and then sent to the Miami Valley Regional Crime Laboratory for an expert opinion regarding retrograde extrapolation. You'll hear from Tyler Meter and Kylie Daniel about their scientific methodology and testing, and that their results yielded blood alcohol concentrations well above 0.08. After you've heard all of this testimony, we'll ask that you find the defendant guilty of operating a motor vehicle under the influence, operating a motor vehicle under the influence with refusal to submit to a chemical test, and failure to stop after an accident. Thank you.
All right.
My client was at work that morning. He got up, went to work stump grinding with his friend. He did ride his motorcycle. For that motorcycle, he did not have insurance. He normally puts it away after September. So we let his insurance lapse. It was a nice day, so we rode his motorcycle to his friend Chris's house. They fixed the stump grinder, then they went to his friend Otis's house where they did the stump grinding around 3 p.m. Around that time, he headed home from Madison. As he was driving home, he was on State Route 44. As he glanced away from the road on 44, prior to Lakeshore Boulevard, where he was getting off, the vehicle in front of him stopped very, very quickly. It was driven by Vanessa Clapp, and he did not have time to avoid the accident. He hit the rear of her vehicle, was thrown to the ground. He sustained some injuries, but nothing life-threatening or that appeared urgent to him. He picked up his motorcycle after addressing Ms. Clapp, and he told her not to call the police, and then he went home and left that scene.
And he started drinking.
At home, he started drinking.
There it is.
Interacted with his son briefly, went and showered, came back down, stepped down for a little bit, and then the police arrived. He was not drinking prior to the incident. However, when he got home, the fact that he was upset about what happened, and the fact that he didn't have his motorcycle endorsement, he figured that he was in trouble. So at that point, he had just been drinking and getting ready to watch the Browns game with his son. Prior to the accident, he had not been using alcohol, but after the accident, besides over-the-counter medication, like Tylenol and ibuprofen, that's when he drank heavily. We believe that the impairment was because of that alcohol that he ingested after
Thank you. Your first witness?
Thank you, Your Honor. The state would call Vanessa Clapp.
All right. Parked his car in the garage, or hid his motorcycle in the garage. Then started drinking.
Would you raise your right hand, please? You swear a testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God.
She gives a walking oath.
Good morning.
Good morning.
Could you please state your name and spell your last name for the record?
It's Vanessa Clapp, like clap your hands with 2 P's.
And where are you employed?
Lake County Public Defender's Office.
What's your position there?
I'm the director of the office.
Is it safe to say you are familiar with many people in this room?
Yes.
And where do you live?
In Perry Village.
And is that in Lake County, Ohio?
It is.
Do you recall what you were doing on October 20th, 2024?
I do.
What were you doing that day?
I was headed out to go kayaking.
Okay. And was that a Sunday?
It was a Sunday, beautiful day.
You said you're going kayaking. Where were you going kayaking?
At Mineral Lagoons.
And about what time did you leave to get to the lagoons?
About 3 o'clock.
Okay. And you mentioned it was a beautiful day.
Yes.
Could you describe the weather a little bit?
Sunny, warm, blue sky, dry, no rain.
And what route did you take from your home to the lagoons?
I went Route 2 to Route 44, headed north.
Okay. And that's all in Lake County, Ohio?
It is. I got off at, like I said, 44 North, which is in Menor.
And while you were driving, did anything eventful happen?
Yes.
What happened?
After I turned to head north on Route 44, I was driving to go at the 283 exit, and I passed Blackbrook. A car in front of me began to slow down suddenly and then came to a complete stop.
And is that how many lanes of travel?
It's 2 lanes headed north to the other direction. I was in the right lane.
And the car was right in front of you?
Yes.
And you were able to stop and avoid hitting that vehicle?
Yes.
Did you see what caused that vehicle to stop short?
No.
What happened next?
I looked in my rearview mirror immediately to see how the cars behind me were faring, and I saw a motorcyclist approaching, and hoped he was able to miss my car, but he wasn't. Okay. He struck the back and side passenger panel.
So he crashed into a probation office worker?
What happened after he hit struck your vehicle?
His motorcycle went flying off to the left of me, which would be the left lane, and he was ejected from his motorcycle and landed on his right side and his head hitting the ground.
And at that point, did you get out of your vehicle?
I did. Well, first I made sure no other cars were coming up, and then I got out.
And then what did you do after getting out of your vehicle?
Then I looked up I saw that he was on the ground. I looked up toward the other car. The driver had gotten out and was headed our way. I also, by the way, started calling 911 right away because there was an accident and I was fearful he was injured.
Okay. So the woman from the car that stopped short, she came and approached you guys?
She did.
Okay. And that was simultaneous to when you were calling 911?
Yes.
How close were you to the motorcycle operator?
About 6 feet away.
And was he able to get up?
He did. He stood up. An individual in a car behind me had come out of the car and had helped him to right his motorcycle, set it up on both wheels.
Did that motorcycle operator make any statements?
No, the only thing he said is, I told him I was calling 911 because there was an accident, obviously, and he said, don't call. But I said too late, basically.
Okay. So after that passerby, I suppose, helped him right his motorcycle, did he get on it?
He did.
And were you able to take some photographs?
I was.
Okay. If I showed you those photographs, would you recognize them?
Yes.
All right, I'm going to show you what's been marked as States Exhibit 3A and 3B. It'll appear on that little screen in front of you. And yeah, Tim, it'll be shown on your little screen too. Thank you. Do you recognize those photographs?
I do. Those were the ones I took that day after he got on his motorcycle and began to drive away.
And they fairly and accurately depict the scene from October 20th, 2024.
They do.
Your Honor, I would ask for permission to admit and publish.
Any objection to 3A and 3B?
They're sort of already published.
Admitted.
Can you make them
I
bigger?
was looking at 3A. About how far away were you from the defendant when you took that?
About 6 feet, maybe. Yeah, about 6, I think. I was standing at the back, towards the back of my car. The shadow on the ground is of the individual who came up and helped him to get his motorcycle sat up correctly.
And did you notice that the defendant was bleeding at all?
Yes,
Is that blood, the injury in this photograph at all?
it is. If you zoom in, it's actually at the top of his head. He's bleeding down the right side of his face by his ear.
Would you zoom in, Ms. Tuttle? Is that the blood that you speak of behind the ear? All right, moving on to State's Exhibit 3B. What is this picture of?
I snapped that as he was driving away. I moved behind him. That's my shadow. And I snapped the photo of him to get his license plate.
Gotcha. Thank you. So you said you were about 6 feet away from him, correct?
Yes.
Did you smell anything?
No.
Did he seem impaired to you at all?
No.
Do you have any training in identifying roadside impairment?
No.
And you said you called 911. Did the police respond to the scene?
They did.
Okay. And did they document the damage to your vehicle?
They did.
Okay. And can you tell us about the damage to your vehicle?
Yes. So he hit, his motorcycle hit the passenger rear part of the back of the car on the side. So I had damage, and the side was crushed in, and the back door was damaged, and there was damage to the back bumper.
And were you able to have that repaired?
I was.
And about how much did you have to pay in order to have that repaired?
$5,300, approximately.
Ouch.
Insurance paid.
Okay.
But the motorcycle cost
And were
more.
you able to drive that vehicle away from the scene?
I was for a little bit, and then it was felt unsafe to drive. It was kind of shaking, so I had it towed.
One moment, please.
Boom. I bought caviar, guys. I did it. Should arrive
Going
tomorrow.
back to when the defendant was still on the scene, did you ask him to stay on the scene?
No.
Do you see the operator of that motorcycle in the courtroom here today?
I do.
Could you point where he's sitting and describe an article of his
Certainly.
clothing?
He's wearing a gray shirt sitting by Mr. Deeb.
Okay. Your Honor, may the record reflect that the defendant has, or the witness has identified the defendant?
Yes.
One moment. Nothing further.
Ross.
This comes down to whether or not he was drinking before or after the accident. That's
Good to see you this morning in court in a different capacity. That day, the woman that was driving in front of you, did you ever converse with her?
Yes.
Okay. Did she stay on scene?
No, she left after we had a conversation.
Did you ever figure out why she stopped so abruptly?
No.
Describe how she stopped. Was it like slamming on the brakes where you didn't quite have to screech your tires, or was it a slow stop?
She had begun to slow a bit and then just stopped. Not screeching tires, but just...
Like very abruptly?
Yeah.
How did you have to brake?
Similar.
So,
I was slowing a bit, and then I had to hit the brakes.
So it started as a slow stop, and then all of a sudden, boom, right to a complete stop?
Mm-hmm.
And were you at a complete stop when you were struck by the motorcycle?
Yes.
Approximately how long do you think you were stopped before impact occurred?
It was within seconds.
Very quickly?
Yeah, I'm trying to imagine it now. 5 seconds. It was very quick.
Very quick. And did it
Felt
appear...
that way, at least.
Felt that way? I'm sure it did. Did it appear as though he tried to avoid you?
Yes. He was swerving. I saw him swerving.
So he was more towards
trying to get in the left.
More towards the middle of your vehicle when you first saw him, and then he kind of tried to get away?
No, he was more on the left side trying to get over, but he nicked me.
Did you feel that he had time to evade you?
No.
Because the way you had to stop with the vehicle in front of you, it was so quick that he wouldn't have had time to react?
That's correct.
And
that was my impression.
That's your impression, yes. How many words do you think you exchanged with him?
With the motorcyclist?
With the driver of the motorcycle.
5. I'm calling 911. That's basically it. He
And
said, don't.
when you had that conversation with him, you said that he was about 5 or 6 feet away from you. Was he that close? Was he closer at that point?
No, it was still probably about 6 feet away.
And you couldn't smell any alcohol?
No.
And as far as any other signs of impairment, did you see anything that would lead you to believe that he was under the influence of drugs or alcohol?
Nothing.
You don't have any training in detecting roadside impairment, correct?
I don't have any training.
But in your experience, for what you do for a living with the Public Defender's Office, have you represented
Overruled.
Have you represented people on OBIs?
Yes, many.
Are you familiar with what police officers would do to investigate an OBI?
I am.
And knowing what the police would look for with your experience, did you see any of those signs of impairment? Erratic driving? Or
Well, she's already indicated by her answers that she didn't notice any signs of that nature.
So just to clarify, you didn't see any signs of impairment when you interacted with the officer, just to sum it up.
When I interacted with the motorcyclist, no.
How long do you think he was on the scene prior to him leaving?
It was very quickly, probably with a minute or so, he was up and gone.
Did he seem to have any trouble moving around?
No, not at all.
Did you see him drive away?
I did.
Did you watch him drive away?
I did.
Did you see where he went?
Yes, he drove away and exited at 283 Lakeshore, which is the next exit. Pardon me?
From the pictures that you had just seen,
right?
Motorcycle, you can see that the exit is just up ahead.
Right, that's where he exited. He exited and went left.
When you watched him drive, did he appear to have any issues driving?
No.
He was able to ride straight, keep his bike in a normal
Yes.
operating?
Yes, he was. Seemed fine to me.
Approximately how long until the officers showed up?
But maybe 5 minutes.
And when you spoke with the officers, you explained that the woman in front of you stopped just like you said, and you informed the officers that it didn't appear that he was under the influence or anything, correct?
Yes.
At that time, did it appear that the officers had a tentative conclusion as to what may have happened?
No.
I don't have any questions, Your Honor.
Any redirect?
One moment, Your Honor. No.
All right, you may step down. Thank you. Next witness.
The state calls Sergeant Tyler Law.
What's the name?
Tyler Law, L-A-W.
Senator, for the record, we are familiar with the witness, obviously. I am very familiar. I know you're all certified police officers. We would stipulate for the qualifications to the extent the state feels comfortable with it.
Any problem with that?
No, Your Honor.
All right, step forward, please.
Defense
Raise your right hand.
stipulates
You
to
swear testimony
qualifications.
about gives the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, have a seat.
Checks his fly during the oath.
Ms. Tuttle.
No better time, I guess.
Good morning.
Good morning.
Can you please state your name for the record, spelling your last?
Tyler Law, L-A-W.
And where are you employed?
Menor Police Department.
What's your job title?
I am a sergeant.
Okay, how long have you been a sergeant for?
Today's my first day.
Congratulations.
Thank you.
All right. Were you working as a certified peace officer in Menor on October 20th of 2024?
I was.
And did you get a call to report to the scene of an accident on 44 North, just past Blackbrook?
I did.
Is that in Menor, Lake County, Ohio?
It is.
What was the nature of that call?
It was an injury accident between a vehicle and a motorcycle. While en route to the call, dispatch advised that the motorcyclist left the scene, was last seen traveling westbound on Lakeshore Boulevard.
Were you dispatched to that call at 3:20 p.m.?
Yes.
And what time did you arrive on scene?
Within 10 minutes of that.
Okay. Were you the first officer that made it to scene?
I was.
What did the scene look like when you arrived?
When I arrived, there was a SUV pulled off to the right side of the roadway. There was a female standing in the grass off to the right. She was identified as Vanessa Clapp.
Was her vehicle damaged?
It was. Looking at the back of her car, it was on the left rear. There was some damage to the vehicle.
Who was the reportedly injured party?
The motorcyclist.
Was the motorcyclist there when you arrived?
No.
Was the motorcycle there when you arrived?
No.
Were there any signs that a motorcycle had been there?
There was. A motorcycle mirror was found on the roadside.
Okay. Did you find any evidence that someone had been injured in that area?
We did. On the motorcycle mirror, there was a drop of a red substance that looked like blood. There was also some drops of a red substance in the roadway where the accident occurred that appeared to be blood.
Okay. Did you speak to Miss Clapp to figure out what had happened?
I did.
And what did you learn?
She advised that she had to quickly stop. A vehicle in front of her had stopped. She wasn't sure why. She had to slam on her brakes. The motorcycle was behind her and rear-ended her.
Was there any collision between Miss Clapp and the car in front of her?
No,
Okay, so that car was not involved in a collision?
it was not.
All right. Did you have any pictures of the man who was involved in the crash?
She did. She had a picture of the man that was involved in the crash as well as the motorcycle.
Were you able to view those?
I was.
Who called 911?
I believe Vanessa said that she advised a male on a motorcycle that she was going to call 911. And when she did so, he told her not to, and then he left the scene.
Okay. Were you the primary officer on this case, or did someone else take over the interview for you?
Someone took over the interview. This was my assigned zone for the day. I just happened to be there first. I was closer at the time.
Okay, so did Officer Miller take over for you?
That's correct.
And while he continued talking to Vanessa, what did you do?
I started looking over the scene for evidence to see if there's anything else that I could find.
Based on the photos you were shown, were you able to glean any information about who the rider of that motorcycle was?
We were, yes.
Tell me about that.
We were to run the license plate through our system and determine that it was registered to a Dennis Boyd.
And where did Dennis Boyd have his registered address as?
Heather Hill, which is an address in Menor.
Okay, and is that pretty close to where you were?
Yes.
So based on the fact that we know that this is a registered owner in Menor, just minutes from where you are, what do you decide to do next?
Officer Miller and I decided to go to Dennis's house to speak with him about the accident and to make sure that he was okay.
Okay, and do you know how many minutes later you arrived at Dennis's home?
From the time we left the scene?
Yeah.
Or within 5 minutes. It was very, very close.
Okay. Is there anything you noted when you were approaching the home?
The garage door was shut. Patrolman Miller was able to see into the windows on the top of the garage, and he noticed that the motorcycle was in the garage with its hazards on, the same motorcycle that we had pictures of.
And do we know it's the same motorcycle because it had the same license plate on it?
That's correct.
Did you knock on the door?
With the hazards on.
Okay, and who came to the door?
Dennis's wife came to the door.
Did you tell her you needed to speak with Dennis?
We did.
Did Dennis come to the door instantly?
No, it took a minute, but he eventually came to the door.
What did he look like when he came to the door?
His hair was wet. He was wearing different clothing than was in the photo that we had. He was barefoot. One thing I noticed right away when he stepped outside is his eyes were glassy.
Did you smell anything about his person?
I originally did not. I was probably 10 feet away. I then stepped closer, and I could smell a strong odor of an alcoholic beverage coming from his breath.
Did you notice a head injury?
Not at this time. I did not.
Do you see the defendant in the courtroom today? Do you see the man you saw at that house?
I do.
Can you identify him by an article of clothing?
He's wearing a button-up shirt.
Can you give me a little bit more than that, where he's located?
Everyone's all the way to the left, he's wearing some glasses.
We can stipulate this at a time at my, Your Honor.
All right, there's stipulation.
Did you and Officer Miller confront Dennis with the facts of the motorcycle crash?
We did.
Did he admit to that?
He did not.
Did he admit to leaving his house that day?
No.
Did he admit to crashing his bike?
No.
Did he admit to riding his motorcycle that day?
No.
Did he get confronted with those pictures that Miss Clapp showed you?
He did, yes.
Did he admit that those were him?
No, he denied that it was him.
What did he say he was doing?
He said that he was at home, and when we arrived, he was sipping a beer watching the Browns game.
Okay. Based on your observations and his behavior, what did you decide to do next?
We walked him down to the roadway, to a flat surface to conduct field sobriety tests.
Why did you take him down to the roadway to do that?
Just because it was a flat surface. It's easier for people to perform these tests than on a sloped surface.
Is the defendant's driveway sloped?
Slightly, yes.
Okay. Is there any other reason why you would bring somebody near your cruiser to do field sobriety tests?
Yeah, we can also get a better view from the dash cam on our cruisers.
Are you trained to do standardized field sobriety tests?
I am.
Do you have any extra training beyond the average officer in these?
Yes, I've been to ARIDE training, which is Advanced Roadside Impaired Driving Enforcement training. That was in 2018.
Okay. Are you trained and comfortable in the standardized field sobriety tests?
I am.
What tests did you start with here?
The HGN test.
What is the HGN test?
It looks for nystagmus in the eyes, which is involuntary jerking in the eyes.
How did you perform that test?
I had Mr. Boyd stand at the rear of one of our cruisers. I gave him the instructions that he needed to keep his head still and follow the tip of my finger with his eyes and his eyes only. And that's how we started.
How did Mr. Boyd do with that test?
He stared straight forward. He did not follow my finger with his eyes.
Okay, so you said, please follow my finger, started to move your finger.
That's correct.
Did his head stay straight forward?
It did.
And his eyes stayed straight forward?
That's correct.
No movement at all?
No.
So what did you do when that happened?
I asked him if he understood the instructions and re-explained them.
Did he say he understood?
Yes.
Did you restart the test?
I did.
And what did Mr. Boyd do?
He continued to stare straight forward.
At this point, did you ask if he was going to take the test?
Yes, I believe actually Officer Miller asked him, are you going to refuse to do this field sobriety test? And he said, yes, I'm not doing them. Or
Did he refuse to take any further tests as well?
That's correct, yes.
So what happened after he refused to take the field sobriety tests?
He was placed under arrest.
Where was he put after he was placed under arrest?
In the back of a police car.
Did you notice anything about him once he was in the back of the police car?
Yeah, that he had an injury to the side of his head.
And was that injury in the same location as the photo where Miss Clapp had showed you from the side of the road?
Yes.
Was he bleeding from his head?
Yeah, he started to bleed, once he was under arrest.
Did you take him back to the station?
I did not.
What did you do?
I stayed on scene and did an inventory tow sheet for the motorcycle and waited for Patrolman Burton to arrive.
Okay, and did the two of you collect that motorcycle and then head back to the station for the day?
That's correct.
One moment. I have no further questions. Thank you.
Cross.
Good morning, officer.
Good morning.
Now, approximately what time do you think you went to Mr. Boyd's house?
I can't recall the exact time. I would say maybe 20 to 30 minutes after we arrived on scene at the accident.
Okay. You said that you interacted with Miss Clapp and you spoke to her.
That's correct.
Did she inform you how the operator of the motorcycle appeared?
She said that she asked him if he was okay, and he said that he was fine.
Did you guys ask her if he appeared impaired at all?
I did not. I believe Officer Miller did.
But were you standing right there when that conversation took place?
Yes, I believe so.
And when she was asked if he appeared impaired, she said no, correct?
That is correct, yes.
And you're familiar with Miss Clapp, are you not?
From this incident, yes.
You didn't know that she was a public defender at the time?
Actually, I did not. I did not realize that at the time, no.
Okay. Now, did you ask her if she smelled alcohol?
I did not.
Did Officer Miller?
I'm not sure if he did or not.
Okay. When you arrived at his house and he came to the door, his hair was wet.
That's correct.
So it appeared as if he had taken a shower?
Yes.
And you said at 10 feet you couldn't smell anything, but you took a step closer and you could smell a strong odor?
Yeah, a few steps. It wasn't one step. It was a few steps. I got up next to Officer Miller.
Okay, so you're five or so feet away from him and you could smell the odor?
That's correct.
And he was evasive with his responses. Would that be fair to say?
Yes.
What did he tell you he'd been doing that day?
He said he had been at home drinking beer and watching the Browns game.
Prior to showing up at his house,
we're going to go 1.25 speed.
Driver's license?
Yeah, I personally did not.
Were you informed by any other officers what his driving record was prior to going to his house?
I don't recall. I know once we were on scene, I believe after he was arrested, I remember talking about his OVI history, but I don't recall before then talking about it.
You don't recall when you learned of that, but you do know you knew at the time he was arrested?
After he was arrested, yes.
Okay. Did it appear as though he was obviously impaired when he came to interact with you and Mr. Miller, Officer Miller?
I wouldn't say obviously, but there was indications that he was impaired.
What were those indications?
His glassy eyes and the odor of alcohol.
What about his speech?
I don't recall any obvious things from his speech, but I clearly remember the eyes and the odor.
Did he have any other indications before he was placed into a patrol car, such as the way he was moving, his balance, being unaware of what the question was and failing to answer it, being belligerent, a mood swing, or anything like that?
No. It did seem when he stepped out of the house, he was a little uneasy on his feet. I mean, I wasn't afraid that he was going to fall down or anything, but it just seemed...
Do you know if he received any medical treatment?
I believe he did eventually, yes.
Were you aware that he was taken to the hospital?
Yes.
And he was treated for a head injury?
That's correct.
In your training, when you're doing the HGN, the test, are you supposed to ask if they have any head injuries recently?
Yeah, I asked if he had any medical issues or any problems with his eyes or anything like that.
But is a head injury one of the things that they tell you to specifically address prior to giving the HGN?
I know there's some general medical questions. I don't know.
Would a head injury throw off the HGN?
It could.
Okay. And he had a pretty significant gash on the back of his head, correct?
Yes, there was a gash on his head.
And he needed medical treatment for that, as determined by the Mentor Police, correct?
Yes, by the Mentor Fire Department. We called them to analyze his injuries, and they determined to take him to the hospital.
Were you there during this interaction with the Mentor Police Department?
With the fire department?
Yeah, with the discussion about his medical care.
No.
You're just aware of it because you know the investigation?
Yes.
Back at the police department, did you interact with Mr. Boyd?
I did not.
Okay. After he was placed under arrest and taken back to the station, did you have any other interaction with him?
I did not.
When he interacted with the officers, other than denying any of the statements that you guys believed to be true, how did you interact with you and your fellow officers?
I'm not sure what you're...
He was engaging. He answered your questions.
Yeah, I mean, there wasn't anything...
He wasn't being rude or anything like that?
No.
His demeanor was fairly calm?
I would say so.
Did he inform you that he had been drinking?
Yes.
Okay. From the odor that you could smell, are you familiar with the way different alcohols smell on someone's breath, such as beer or any other intoxicating liquors?
No, alcoholic beverage. I mean, I could smell probably a beer, I would say, but... Yeah.
Like beer versus whiskey, the way that would smell. Would they smell different?
Yes, they can smell different, yeah. I mean, if you were to put both of those in front of me, I think I could...
Well, if I took a drink or anyone took a drink and then you were to smell their breath, would there be a difference in your mind?
I don't believe so, no. It's just the alcoholic smell is what I smell.
And
the bells of justice
are ringing. The rate at which you drink alcohol affects the way the alcohol will affect someone's system, correct?
How quickly you drink it, is that what you're asking?
Yes.
Yeah, yes.
So the quicker you drink it, the quicker you would be impaired or intoxicated?
That's correct.
And depending on the type of alcohol you drank, it would have a different effect on a person during your investigations?
Correct.
At what point did you see the head injury? You said that was when he was placed in the vehicle?
Yes.
The entire time that you were interacting with him, were you facing him or were you around towards the rear of him, the side?
I was facing him, yeah.
Did you see where his head injury was?
I believe it was on the right side of his forehead, or not his forehead, his head.
For the record, you're indicating more like back towards behind your ear on the right side. Would that be fair? Like back behind the ear? More towards the rear?
I just remember being on the right side of his head. Specific locations, I don't recall.
When you saw that injury, did it look like something that needed to be addressed with medical attention?
No, not that I recall. It wasn't. I don't believe it was bleeding at the time that I saw it.
Okay. So could you see that there was an open wound?
Yes, I believe so. Yeah.
Did he complain of any other parts of his body that were injured?
No, not to me. We did notice that he had some injury to his right index finger. He advised that was from a work injury.
What about his back, his neck, his legs, any other parts of his body?
I did not notice anything. No.
Approximately how long do you think it took him to come to the door? From the time, let me withdraw that question.
Yeah.
You interacted with his wife, and she came to the door in normal fashion, right?
Correct.
And she immediately went to go get him at your direction. Okay. And shortly after that, he came to the door?
Yeah, I would say so, yeah.
Did you see him prior to him coming to the door?
No.
How were you guys able to observe the motorcycle?
There's windows on the garage door. Patrolman Miller is tall, so he can
You
see.
guys are both over 6 foot tall, correct?
I'm not over 6 foot tall. No, I'm maybe right at 6 foot 5'11".
Okay.
I like to tell people I'm 6
I would
foot
have
tall.
put you at 6 foot, but I know Officer Miller is well over 6 foot.
He is.
Okay. So you could see into those windows?
Yes, he could. I could not without. Maybe on my tippy toes I could see in there, but he could see right in there.
Did you have an opportunity to look through the window on your tippy toes and see the motorcycle?
I don't recall doing that. No.
No further questions, John.
Any redirect?
Yes, Your Honor. Okay. Did you and Officer Miller ask the defendant if he had sustained any injuries?
Yes.
And he denied that?
Correct.
You asked him about bleeding from his head, right?
Yes, that was talked about, yes.
He denied that?
Correct.
Was he in a fresh white shirt at the time that you saw him?
Yes.
Was there any blood on that shirt?
No.
Did the defendant keep asking you, what are we doing here?
Yes, he did question what we were doing multiple times.
And was that in response to you performing your job?
That's correct.
Was that in response to the field sobriety tests?
Mm-hmm.
Was that
correct.
a yes?
Yes.
And was that in response to asking him questions about the crash he was just involved in?
Yes.
He didn't tell you the truth, did he?
No.
No further questions. Thank you.
Maybe cross.
Just briefly. Pretty much any question you guys asked him that would have been related to operating a motorcycle that day, he denied, correct?
That is correct.
He admitted to drinking, and he denied leaving his house, correct?
That is correct.
He denied operating his motorcycle.
Correct.
And he denied the injuries.
Correct.
So if he would have admitted that he was injured, that would have been him admitting that he was operating his motorcycle that day?
That would have been more evidence towards that, correct.
Yeah. I mean, you would have, if he said, yeah, I'm injured, and he had a fresh injury, it would have gone along with what you guys thought had happened.
Correct.
Nothing further.
You may step down. Thank you.
Thank you.
Next witness.
The state calls Patrolman Mark Burton.
Burton?
Burton, B-U-R-T-O-N.
Burton, that's a good name. We are sped up. We're in Ohio Minecraft Court on a DUI case with a Harley-Davidson motorcycle. Did the drinking happen before or after the crash? That's the question.
You raise your right hand, please. You swear testimony about gives the truth, the whole truth, and nothing but the truth, so help you God. Have a seat.
Does the defense again stipulate to the qualifications of this witness?
For every officer that ever been an officer that called it, same stipulation.
All right.
May I proceed? Good morning.
Morning.
Can you please state your name for the record, spelling your last?
Mark Burton, B-U-R-T-O-N.
And where are you employed?
City of Mentor, Police Department.
And what is your job title?
Patrolman.
Are you also an evidence technician?
Yes.
Were you working on October 20th of 2024?
Yes.
And did you get called out to the scene of a crash on Route 44 North just past Blackbrook?
Yes.
Is that in Mentor Lake County, Ohio?
It is.
What did you see when you arrived at that scene?
A vehicle that was struck and some vehicle parts on the side of the roadway.
Was there anything you observed in the actual roadway?
Some red substance that might have been blood, fresh blood.
As an evidence technician, what did you do to document that scene?
The scene was photographed and eventually samples were obtained of the red substance.
What did you use to photograph the scene?
A Nikon digital camera.
Is that department issued?
It is.
How are those photos stored from that Nikon camera?
Onto a flash drive, which is on the camera, and then uploaded to our evidence computer.
Are you the one that personally uploads them to the evidence computer?
Yes.
Would you recognize the photos you took of the scene if I showed them to you today?
Yes.
We're going to pull up State's Exhibit 4, and that is for A through H. We're going to scroll through these pictures for you. Do you recognize those photos?
Yes.
Are they a fair and accurate depiction of the scene as you saw it on October 20th, 2024?
Yes.
The state moves to admit and publish Exhibit 4A through H.
Any objection to 4A through H? No, Your Honor. All right, they're all admitted.
All right, let's start with 4A.
Ooh, that'll buff out.
Does he have the clicker? He does. Can you not touch the clicker for 1 second? It's connected to the same mouse.
Touching the clicker.
We're here at State's Exhibit 4A. What do we see here?
See 44 north, we see the vehicle that was struck off to the right side of the berm.
Okay. Is that at the 283 exit?
Yes.
Just in the distance?
Yes.
All right, let's go to 4B. What do we see in Exhibit 4B?
Part of the vehicle trim from that belonged to that Jeep, and also a small mirror, which appeared to be from a motorcycle.
When you say part of the vehicle trim, is that the like boomerang shaped item that we see in the middle of the screen?
Yes.
And the mirror, is that circular item just to the left of it?
Yes.
Okay. 4C. What is Exhibit 4C?
That is the mirror and the back of the mirror that sheared off of the motorcycle with red substance, which appears to be blood.
Okay. Let's go to 4D. What is this?
That would be the mirror and also the trim piece from the vehicle.
Okay, so this is just the other side view of what we previously saw?
Yes.
All right. 4E. What are we seeing in 4E?
There was some splatters of red substance on a roadway where the accident occurred.
Okay, is that your shadow in the bottom of the photo?
It is.
And are the splatters of blood in that left lane of travel?
Yes.
Okay, let's go to 4F. I believe we can see them better there. Okay, can you show us with that pointer where those splatters of blood are? If you push the top button, that should give you a red dot to show us. Okay, so those, you're circling
This
in
area
the
right here.
center of the photo near the bottom.
Yes.
Okay. And then we're going to go to 4G. What are we seeing here?
The rear of the vehicle that was struck and the damage to the left side from the impact.
Okay. And 4H. What are we seeing here?
Again, the damage from the vehicle and the missing trim piece that was in the roadway.
Okay. So with all of this information, did you collect any of the physical evidence in the roadway?
The mirror was collected.
Okay. And did you do any swabs of the roadway itself?
Yes.
How do you take swabs from a roadway?
It's a new collection kit, which is swabs in a sealed envelope, and then water that comes in little tubes. I forgot the exact name of the water. It's used to moisten the tip of the swab itself, and then the evidence is collected with the moistened swab and then placed back in the pouch.
Do you wear gloves while you do this to avoid any contamination?
Yes.
All right, so what did you take swabs of?
The roadway, the spots of red substance in a roadway at that point, and later on the mirror and the red substance that was on the back of that mirror.
Okay, so we have, would you recognize those swabs from the roadway if I showed them to you today?
Yes.
I'm approaching with what's been marked for identification purposes as State's Exhibit 8A and 8B. Do you recognize those?
Yes.
What are they?
Swabs of roadway, 2 different areas.
Is 8A marked swab of roadway 1?
Yes.
And 8B is marked swab of roadway 2?
Yes.
And those are in the same or substantially the same condition as when you collected them?
Yes.
State moves to admit Exhibits 8A and B.
Any objection to 8A or 8B? They're admitted.
Right, you said you also swabbed the back of that motorcycle mirror.
Yes.
And did you mark that swab as DNA swab MC, meaning motorcycle?
Probably, yes.
Would you recognize that if I showed that to you today?
Yes.
Approaching with State's Exhibit 9.
Probably. Let's get a little more definitive. Probably. There's a good chance. More likely
What's
than
that
not.
I just handed you?
A DNA swab with MC from the motorcycle written on it.
Is that in the same or substantially the same condition as when you packaged it?
Yes.
State moves to admit Exhibit 9.
Any objection to 9? It's admitted.
After you were done collecting evidence and documenting the scene, did you ever go to the defendant's home?
Yes.
And what did you do at the defendant's home?
The motorcycle was moved out of the garage and then photographed, and then the motorcycle was also swabbed for DNA evidence.
Okay. What do you do with those swabs once they are collected and labeled?
They were placed in evidence.
Okay, and then are they eventually submitted to the Lake County Crime Lab for testing?
They can be, yes.
Were these submitted for testing?
Eventually they were.
Did you take any photos of that motorcycle at the defendant's home?
Yes.
Would you recognize those if I showed them to you today?
Yes.
Pulling up State's Exhibit 5. Those will appear on your small screen. We're going to scroll through those. It's Exhibit 5A through G. Do you recognize those?
Yes.
Are those photographs that you took of the defendant's motorcycle?
Yes.
Do they fairly and accurately depict the motorcycle as it looked on October 20th when you took those photos?
Yes.
State moves to admit and publish exhibits 5A through, is it H?
G, I think you said G.
A through G.
Any objection? All right, they're all admitted.
What are we seeing here in exhibit 5A?
The motorcycle owner's residence.
Okay. And what is this?
The motorcycle.
What can we note from the motorcycle from this picture?
There was some damage on the left side.
Can you show us where that damage is that you're noting?
We have damage up here where the mirror would have been.
And would that mirror that you found on the roadway fit right in that part of the bike?
Yes.
Does the mirror from the roadway look the same as the mirror on the right side of the bike?
Yes.
Okay, what other damage do we see?
There's also damage down here. Looks like to the saddlebag area.
Any other damage that we can see or anything of note in this photo?
Possibly this bar right here from making contact. It's all scraped up.
Okay. Let's go to 5C. What do we see here?
The rear of the bike.
Okay, are we able to clearly read the license plate on the bike here?
We can, and also the missing mirror.
Okay. Is the plate on that bike the same as the plate in the photos that were provided by the eyewitness to the crash?
Yes.
All right. Can we tell anything about the front right side of the bike?
Yes. Damage from probably the initial impact, which this bar being bent in.
Okay. Let's take a look at 5D. What are we able to see here?
The damaged bar, also some drops of red substance, which possibly be blood.
Okay. 5E. What's this?
The missing, where the missing mirror was, and also some fresh blood on the left control area.
Okay.
Or red substance, which appears to be blood.
5F.
The same thing from the previous photo.
So there's more blood?
More blood,
just in this
yes.
picture? Okay. And 5G.
Some appear to be smeared blood on the seat area and also here on the lower portion of the fuel tank.
Is there a scratch there?
Looks like scuff with some possibly smeared red substance in there.
Okay. And these photos were stored and maintained in the same way as the ones you discussed in Exhibit 4?
Yes.
Was this bike eventually towed?
It was.
In Harley
One
terms,
moment.
that's totaled. That's a totaled bike.
I have no further questions. Thank you.
Good morning, Officer Burton.
Good morning.
Did you ever interact with Mr. Boyd?
No.
Okay. What happened with the blood swabs that you took?
They were placed into evidence at that point.
And after they were evaluated, did you learn the results?
I did not know, not personally.
You never checked with the crime lab to see what anything came back as?
No, they were. I didn't know when they were being sent out. They were initially just placed in evidence.
How long have you been an officer, Officer Burton?
With Mentor for 20 years.
20 years. You've done a lot of accident scenes, correct?
Sure.
Now, with the pictures and the damage you just described, be fair to say that it's when you see the vehicle damage to the SUV and then the bike, were they consistent?
Yes.
And that right bar, I believe it was in 5C that you would describe, that was bent in, that would appear to be where he struck the vehicle?
Appear to be, yes.
Okay. Did you ever, even though you didn't interact with him, did you ever see Mr. Boyd?
Just at the residence, I believe.
Was he already under arrest and placed in a Mentor Patrol car?
I don't recall at that point.
Did you see him standing? Or you don't recall?
I don't remember.
Okay. Other than the accident and the blood that you collected, did you have any other part of the investigation as far as determining any level of impairment or investigation as to Mr. Boyd and his condition at the time of the accidit?
No.
Nothing further on.
Any redirect?
No, Your Honor. Thank you.
All right, you may step down. Thank you.
Thank you.
Let me take about a 10-minute break. Okay.
All right.
We have to skip ahead. Or did they skip it for us? Hang on, let's see. Is that the end of this one, Josh? Let's see, that's this one over here. That's the end of that one. Okay, so now we start with the other guy, because we just ended with... Where's it not going? Now we start on the next one. Hang on. Is that the first one, or is that the next one, Josh? Hang on. So the next one... To make sure we watch these in order. They take a lot of breaks. This one is 48 minutes long. Okay. Oops, that's not it. Hang on 1 second. 6:48. There we go. All right. Can his bike still play Freebird obnoxiously loud? Hopefully. What else is the bike good for? Every true Harley guy's bike is scratched up like that because of dropping it, trying to back it out of the bar's gravel parking lots. No. We've got a Harley Davidson shop just down the road from us here in Winterville, and I think it's called the Graveyard or the Boneyard, Harley Davidson Boneyard. And they used to have their own really big skull and crossbones sign because it sort of goes with the pirate theme of the area. But Harley Davidson made them sort of like go to corporate logos, and they made it all normal. But it's pretty cool. Lots of Harleys around this area.
All right, next witness.
The state calls Officer Colin Hagen.
We're still going 1.5 speed, right? 1.25.
Raise your right hand, please. Swear testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Have a seat.
Good morning. Can you please state your name for the record, spelling your last?
Colin Hagan, Hagan.
And where are you employed?
Mentor Police Department.
And what's your job title?
Patrol Officer.
Were you working on October 20th of 2024 as a police officer in Mentor?
Yes,
And did you get involved at all in an incident regarding a Dennis Boyd?
I did.
Do you see Mr. Boyd in the courtroom today?
I do.
Do you recognize him?
Yes.
Can you identify him by an article of clothing that he's wearing?
He's wearing a collared shirt, light colored.
Okay, and where's he located in the courtroom?
Sitting right there.
Now, we stipulated when it identified my client.
All right, stipulated.
How were you first involved in this investigation?
I got called originally to drop off some evidence collection kit to Patrolman Burton that he was on the scene.
Okay, so you physically went to the scene on Route 44 North?
Correct.
Did you spend any real amount of time at the scene, or was it just kind of dropping off a kit and leaving?
Dropping off a kit and leaving.
Did you ever see the defendant while you were there?
No.
Did you get involved later in this case again?
Yes.
And how did that come to be?
I was at the station where they brought Dennis back, and then they requested FD to transport him to Lake West. I rode in the ambulance with Dennis to Lake West.
When you were riding in the ambulance with Dennis, how close were you to him?
Sitting right next to him.
Okay, where were you located in the back of the ambulance?
Sitting on the bench.
And where was the defendant located?
Sitting on the cot.
Were you able to notice anything about the way he looked or smelled?
The only thing I could see was that he was bleeding from his head, and he did smell like alcohol.
Okay. Did he make any statements to you while he was in the back of that ambulance?
Not that I can recall.
Okay. Was he pretty quiet?
Yes.
When you got to the hospital, where did they take him?
To the emergency room.
Did they do any sort of medical testing on the defendant?
I believe so. They did their standard procedures.
Did you stay in the defendant's presence at all times?
Yes.
Was he always within your eyesight?
Yes.
And did he do anything strange while he was around you?
The only thing I can remember is he kept wanting to get up to drink water out of the sink.
Did you tell him that he wasn't allowed to drink water?
I told him he was not allowed to drink water.
Did you ever have to restrain him or pull him back to stop him from drinking water?
I did once, yes.
Why was he not allowed to drink water?
Because we were going to do a felony OVI, and Officer Miller was going to work on a search warrant for his blood and urine, and I did not want him to dilute the test in any way.
Is part of your training and experience that with an OVI you have to observe someone not put anything into their mouth for a period prior to the testing?
Yes.
And would drinking water conflict with your training and experience?
Yes.
Okay. Was the defendant asked to submit to a chemical test by giving breath or blood or urine
Yes.
while he was at the hospital?
Yes.
And was he asked by being read a BMV 2255 form?
Correct.
Are you the one that read that form?
Yes.
Did you have your body-worn camera on while you read that form?
Yes.
Was everything recorded that you did?
Yes.
Would you recognize that footage if we showed it to you today?
Yes.
Up on the screen, we have State's Exhibit 6. Is this your body camera?
Yes.
Is that a fair and accurate depiction of what you saw at the hospital on October 20th of 2024?
Yes.
State moves to admit and publish Exhibit 6.
Any objection to 6? It's admitted.
We're going to play State's Exhibit 6.
All right, look at the little screen.
Oh, Bob, can we publish?
This one, it helps to have it on a big screen TV.
Is your body camera silent for the first 30 seconds after you turn it on?
Yes.
I wish they'd say that differently. Is your body camera silent for the 30 seconds that it's playing back before you turn
Is that
it
the
on?
defendant we're now seeing in that hospital bed?
Yes. Panel, read this something, okay? Yep. You now are under arrest for OVI, operating a vehicle under the influence of alcohol and a drug, or combination of them, operating a vehicle under the influence of a illicit controlled substance or illicit metabolite of a controlled substance, operating a vehicle after underage alcohol consumption or having physical control of a vehicle while under the influence. If you refuse to take any chemical test required by law, your Ohio driving privileges will be suspended immediately and you will have to pay a fee to have the privileges reinstated. If you have a prior OVI conviction or operating a vehicle while under the influence of a illicit controlled substance or illicit metabolite of a controlled substance under state or municipal law within the preceding 20 years, you are now under arrest for state OVI. And if you refuse to take a chemical test, you will face increased penalties if you subsequently are convicted of state OVI. If you take any chemical test required by law and are found to be at or over the permitted amount of alcohol, a controlled substance or metabolite of controlled substance in your whole blood serum, or plasma, breath, or urine as set by law, your Ohio driving privileges will be suspended immediately and you'll have to pay a fee to have the privileges reinstated. If you take a chemical test, you may have an independent chemical test taken at your own expense. Do you understand that? Okay. So what? Right down here. Put a clipboard on you. Can you see if I got one? Right. So this signature right here is just advice in the form. The advice on the back of this form has been read to me, and I have received a copy of this form. Okay. You can either sign or you can refuse to sign.
I'm not going to sign anything right now.
So you're refusing to sign?
Yeah.
Cool.
Cool.
Thank you very much. Cool. Just right there. Yeah. Cool. Anything else? That's it, man. Appreciate you.
All right, the time on that top of that body camera was between 16:55 and 16:58.
Yes.
Okay, so that would be 4:55 to 4:58 p.m. that this occurred.
Correct.
And you asked the defendant to sign that form?
Yes.
Did he decline?
Yes.
Was the defendant asked if he would voluntarily give his blood?
Yes.
Did he decline?
Yes.
When did he eventually submit to a blood test?
After a search warrant was given to him.
I have no further questions. Thank you.
Cross-examination.
Officer Hagen, you've made some OVI investigations in your course of working as a mental police officer, have you not?
Yes.
Okay. While you were with Mr. Boyd, were you looking to see if he was impaired or just checking him out to see if there's any additional evidence that could be garnered?
I was just there to watch him at the hospital.
But as a police officer, knowing what the investigation is, would you keep an eye on those things in case something came up?
Yes.
Such as you said, you observed the odor of alcohol in the ambulance?
Yes.
Anything else you observed?
No, I did not.
How long were you with him at the Mentor Police Department before they took him to the ambulance?
I showed up when the ambulance got there and they were outside in the parking lot, so I wasn't there very long at all.
Did you see him being transported to the ambulance?
Yes.
How was he transported to the ambulance?
I believe they brought up the cot and he was in handcuffs in the front of him.
They took him on the cot, they didn't walk him out?
I believe so.
You don't recall?
I do not recall now.
Okay. That's about a 15-minute ride?
I would say so, yes.
Did you notice anything else other than the odor of alcohol while you were with him?
Just that he was bleeding from his head.
Well, talking about indicia of impairment, any other observations that you made?
No, he was just sitting there pretty quiet.
At the hospital, how long were you there with Mr. Boyd?
I would say maybe an hour, a little bit more.
After the 1658 where he refused to sign, that the prosecutor just talked about, how much longer were you there?
Until Patrolman Miller showed up with the search warrant.
Did you stay while they executed the search warrant, or did you leave when Officer Miller appeared?
I stayed.
And at that point, when presented with the search warrant, was Mr. Boyd compliant?
At first he was not, and then we told him we would force it from him, and then he complied.
When he was not compliant, was it more just verbal, like, no, I don't want to give it to you, or was he physically aggressive in any way?
Just verbal.
From the video, we see he's pretty docile sitting in bed. Is that the way he was just about the entire time, other than the statements where he declined to give a sample?
Yes.
Did he appear to have any trouble moving around at any time? Did he walk that you saw?
He did get off the gurney once to drink water out of the sink, or attempted to.
Was that prior to you reading the 2255 form or after?
I do not recall.
Prior to reading the 2255 form, had you tried to get water?
I know he kept asking for water.
At what point did you have to restrain him from getting a drink?
The point that he actually got up and physically started walking towards the sink.
And do you recall if that's before he denied a chemical test?
I don't remember when it was.
Now, there's a 20-minute observation period. We have to make sure that the suspect does not ingest anything, correct?
Correct.
And that's put anything in their mouth, burp, extensively, or anything like that?
Correct.
Okay. And drinking water would cause a problem, is that correct?
Correct.
And once he denied or declined to take any of those tests, did you still decline to let him have any water?
I just told him we would get him water once the tests were completed.
Did you know they were getting a search warrant?
I did, yes.
Did you inform Mr. Boyd of that?
I don't remember. I believe I did.
Before Officer Miller showed up, or when Officer Miller showed up?
I don't remember.
After he had declined to take a chemical test, which would be breath for the 20-minute observation period for anything in his mouth, did you allow him to get water?
I did not until after the test.
Until after the search warrant blood draw?
Correct.
After he declined to give a breath test, why did you decline to give him water?
I just didn't want him to dilute the test in any way.
How would that dilute the test?
With him drinking water and them possibly getting urine and blood. I didn't know.
How would that dilute the test?
I don't know that that has any bearing with regard to this officer. He doesn't have any expertise in that.
Nothing further. Thank you, Your Honor.
All right. Any redirect?
No,
You
thank
may
you,
step
Your Honor.
down. Thank you. Next witness.
The state will call Marissa Solomon.
Woo! Outside. Results never came back from the...
Raise your right hand, please. You swear the testimony about to give us the truth, all the truth, and nothing but the truth, so help you God.
Yeah.
Right, have a seat.
Good morning. Can you please state your name and spell your last name for the record?
Marissa Solomon, Salomon.
What is your occupation?
I'm a registered nurse.
Can you describe your background and training that you took to become a registered nurse?
I went through a 2-year nursing program and then received my bachelor's through another nursing school.
Where are you currently employed?
I'm currently employed for Cleveland Clinic.
And what's your position?
I'm a registered nurse in the emergency department.
Back in October of 2024, where were you employed?
Lake West Emergency Department.
And that's the hospital in Willoughby, Lake County, Ohio?
Yes.
And back then, was your hair darker?
Yes.
Do you have any training in doing OVI blood draws?
Yes, so someone who is competent trains you on how to do it, so that way it gets passed along so everyone is taught how to do it appropriately.
And that's on-the-job training?
Yes.
How many have you done in your career?
Over 100.
What is the procedure for an OVI blood draw?
So we have kits at Lake West that are provided to us. You use everything that is in the kit. The only thing that's not in there is like a tourniquet and like a Band-Aid, but there's betadine in the kit and everything like that, and you follow the steps through the kit to draw the blood.
The kit is a white cardboard box?
Yes.
And are the 2 test tubes included in the kit as well?
Yes.
Those are glass vials with a gray top?
Yes.
And do those contain a preservative and an anticoagulant?
Yes.
Okay. And the kit contains betadine. What is significant about that?
That way we're not using alcohol to mess with any of the results. We use the betadine, and it kind of balances that out.
And that you put that on the patient's skin before?
Yes.
Do you make sure that you are present when police officers are reading over the patient's rights?
Yes.
Do you wear a glove when you do these OVI draws?
Yes, I do.
And how do you then label or organize the tubes after you're done?
So in the kit, there's actually labels. You have to sign it. You put the patient's information on it, goes over the tubes, and then you put them in the packaging, and the box itself ends up being sealed with your date and initials.
And after you seal the box, what do you do with it?
Hand it to the police officer.
And were you working at Lake West on October 20th, 2024?
Yes.
And on that date, did you come in contact with the person who later became known to you as Dennis Boyd?
Yes.
And did you draw blood from that person?
Yes, I did.
And were you requested to draw blood by a law enforcement officer?
Yes.
And did you use the same method you just described when drawing blood from Dennis Boyd?
Yes.
Do you remember anything about, I know this was 2 years ago, but do you remember anything about drawing blood from Dennis Boyd?
I remember he was in one of our trauma bays coming in, and I remember there was police officers present. And remember he was also handcuffed to the bed at the time.
Do you remember a judge coming in?
I do.
And why was the judge there?
He was there to sign a warrant for the blood.
And you were able to draw Dennis's blood?
The judge came to the
Can you
hospital?
briefly walk us through the process of how you did that?
So after we had the warrant present, then I placed tourniquet on his arm, used the betadine provided in the kits. There's a needle and the tubes are already provided through the kit as well. Drew the patient's blood following standard procedures, covered it up, and then labeled the test tubes, put it in the packaging, sealed the box, and gave it to the police officer.
Okay, one moment. Nothing further.
Cross-examination?
No questions. Oh, you know what? I'm sorry, go ahead. Sorry. Did you treat Mr. Boyd?
I did not.
Were you aware of what treatment he received?
I assisted when he first walked in the room, or when he first was in the cot in the room, but other than that, I was there to only do the OVI draw.
Were you aware that he received staples in his head for his head injury?
I was not.
Okay, nothing further, Your Honor.
Thank you, Your Honor. Did you notice that the defendant was bleeding from his head?
There was blood on the sheets, but I was not present during most of the care other than the OVI draw.
In your training and experience, do drunk people tend to bleed more than sober people?
Sustain.
Nothing further.
Anything? No. All right, you may step down. Thank you. Next witness.
The state would call Kelly Reese.
Kelly Reese is what I heard for the next one.
Will you raise your right hand, please? You swear a testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, have a seat right here.
Good morning. Could you please introduce yourself and spell your last name for the record?
Kelly Reese, R-E-E-S.
Where are you employed?
I'm employed by the Lake County Crime Lab here in Painesville, Ohio.
What's your position?
I'm a forensic analyst in the DNA section.
And how long have you been employed at the Lake County Crime Lab?
Since April of 2024.
What are your duties as a forensic analyst?
I analyze evidence for the presence of body fluids, such as blood and semen. I collect samples from evidence items that could potentially contain DNA. I perform DNA testing on evidence items and on known reference samples, and then I make comparisons between the two to determine if a person could be included or excluded as a source of the DNA.
What education and training do you have to qualify for your position?
I graduated from the University of Rio Grande in Rio Grande, Ohio, with a Bachelor of Science degree with a major in biology and a minor in chemistry.
Rio
and
Grande
then
or
when
Rio?
I got my first job, which was with the Ohio Crime Lab, the Ohio State Crime Lab, which is the Bureau of Criminal Identification, commonly referred to as BCI, I received approximately 1 year of in-house training at that lab. That entailed attending lectures, taking both written and practical exams, completing non-probative casework, having a mock trial, and passing a proficiency test before beginning any casework. Then when I came to the Lake County Crime Lab, I received approximately 6 months of in-house training to make sure that I'm proficient in the instrument, the chemistries, the methods and procedures that are utilized within this laboratory.
And how long were you at BCI?
For 11 years.
She calls it Rio Grande.
Yes, I was a DNA forensic scientist.
How do you keep up in your field?
So we have to have at least 8 hours of continuing education every year, and we have to read scientific articles pertinent to DNA every year.
And just briefly, can you explain what the crime lab is in general?
Yep, the Lake County Crime Lab is a full-service forensic testing laboratory. We offer testing in the areas of DNA, fingerprints, firearms, chemistry, toxicology, and we service primarily Lake County law enforcement agencies, although not exclusively Lake County.
Is the crime lab accredited?
Yes.
Can you briefly explain what accreditation means?
Yes, we are accredited by ANAB, which is the ANSI National Accreditation Board. And the purpose of accreditation is to make sure that we are following industry standards that are set by outside accreditation bodies to make sure we are producing the highest quality work product. These standards involve all aspects of the laboratory, from the way evidence is submitted and stored to the training and educational requirements of the analyst to the methods and procedures that are used in the lab. Accreditation is an ongoing process, so every year aspects of the lab undergo an internal and external audit, and every 4 years we undergo a full reassessment to make sure that the standards have not only been adopted but continue to be implemented throughout the lab.
So the lab itself is accredited. How about the individual divisions or disciplines within the lab? Are those also accredited?
Yes.
So is the Lake County Crime Lab accredited in DNA?
Yes.
And was it accredited in DNA back in 2024?
Yes.
And the whole lab was accredited in 24?
Yes.
What is the lab's procedure for receiving evidence?
So law enforcement agencies submit through our evidence intake custodians. The evidence intake custodians make sure that the evidence is packaged, sealed, and labeled properly, and they assign a unique case number for each case and item number for each item. We utilize a laboratory information management system, which is LIMS. It's an electronic system to store all of our case information. Through the LIMS system, a barcode is created for each item, and that barcode is how chain of custody is tracked while those items are within our lab. Once a case is created, all of the information has been uploaded into LIMS, and barcodes have been created. The evidence technician then would transfer the evidence into a locked evidence storage area that only laboratory personnel can access.
Wonderful. And then what do you do when you're done with your analysis?
I'm sorry?
What do you do with your evidence when you're done with the analysis?
So when we are completely done, we return it to that same locked storage room for the law enforcement agency to come and pick it up.
Okay. Is there what is the process when you receive an item of evidence that possibly contains blood?
So we have a screening test. It's called a presumptive test for blood. It is not confirmatory, but it is an indicator that blood may be present.
And can you quickly describe that testing procedure?
Yes, it is a chemical stick, if you will, that has chemicals on the end of it, and when it comes in contact with blood, it's a quick color change test that changes the color on the end from a yellow-orange color to a blue-green color.
And you call it the hemosticks test?
Yes.
And what is the process for testing for DNA?
So there are 4 basic steps to the DNA process. The first step is extraction. This is when we isolate the DNA off of the sample that it's on and away from all of the other cellular material that's in that sample. So we end up with just DNA. The next step is quantitation. This is when we determine how much DNA is present. The next step is when we make copies of that DNA so that we have enough for the final step, which is when we develop a DNA profile.
And you need both the items of evidence with the DNA on it and also a standard from an individual?
Yes.
Is DNA unique to each individual?
Yes. No 2 people, except for identical twins, have the exact same DNA. That is why when we characterize the DNA, we are able to tell 2 people apart.
Did there come a time in the Lake County Crime Lab receive evidence from the Mentor Police Department regarding a Mentor Police case, Dennis Boyd?
Yes.
And what evidence did the lab initially receive in August of 2025?
So the DNA section received 3 items of evidence initially. 2 of them were swabs from a roadway, and 1 was a swab from a motorcycle.
And those were evidence items 3, 4, and 5?
Yes.
I'm going to show you what's been marked as States Exhibit 8A and 8. And 8A and B, and also Exhibit 9.
I expect the guitar to kick in any minute now.
Also Exhibit 2.
Okay.
Exhibit what?
It's a good song.
Do you recognize these?
Yes, I do.
So States Exhibits 8A and B, are those the swabs from the roadway?
Yes.
Evidence items number, what were they?
3 and 4. Mm-hmm.
And then Exhibit 9 is evidence number 5, which is a swab from the motorcycle?
Yes.
And on September 2nd, 2025, did the lab receive a DNA standard from Dennis Boyd?
Yes.
And that's is that what is in States Exhibit 2?
Yes.
And do your initials appear on those envelopes?
Yes, I have my initials right beside the barcode that has the unique case number and each item number, as well as over the seal.
And did you perform an analysis on these items?
Yes.
And did you memorialize your findings in a report?
Yes.
I'm going to show you what's been marked in States Exhibit 12. And with that clicker in front of you, you should be able to go to different pages.
Okay.
Or Lauren will scroll for you. Do you recognize States Exhibit 12?
Yes.
Is it a fair and accurate representation of the report that you issued in this case?
Yes.
And is it a copy?
Yes.
Where are the originals kept?
In our LIMS system for the case.
Does the Lake County Crime Lab maintain these reports in the ordinary course of business?
Yes.
The techniques you used to utilize the DNA evidence in this case, were those techniques generally accepted within the scientific community?
Yes.
And are your findings in your report accurate and reliable?
Yes.
Do you process the evidence with DNA and the DNA standard at the same time?
No, we always begin with the forensic evidence to start, and we work that all the way through. And I look at the DNA profiles from evidence and make some determinations, like, for example, how many contributors are present, and do we even have enough of a profile to make a comparison? Once I look at the evidence profiles, then I determine whether or not I need to run a standard to make those comparisons.
Gotcha. So moving to the evidence that was submitted in this case, States Exhibit 3, 4, and 5, did you perform that preliminary hemostatic test?
Yes.
And what were your findings?
Those 3 items were all positive for the presumptive test for blood.
What was the next tests that you did?
So after that is when the DNA testing started for those 3 items. And I developed a DNA profile from each of them. I was able to determine that all 3 profiles had the same characteristics, so they were from the same single source male.
Okay. What did you do next?
I then ran the standard from Dennis Boyd and performed DNA testing on that item.
Were you then able to compare those 2 results?
Yes.
And what did you find?
So the DNA standard from, the DNA profile from Dennis Boyd's standard had all of the same characteristics that were found in the evidence samples. So when I did that visual comparison, there was a match. Anytime we have a match, we then perform a statistical calculation that gives weight to the strength of that match. So in this case, can I have the report back? So in this case, the DNA profiles from the swabs from the roadway, both of those, and the motorcycle, are 239 septillion times more likely to occur if Dennis Boyd is the source of the DNA than if the profiles derive from an unknown individual.
How many zeros is in septillion?
Septillion has 24 zeros, so it is a number that is massively huge that our brains cannot really comprehend. In our laboratory, in order to make an association between a suspect and evidence, we have to have a likelihood ratio of at least 1,000,000 times more likely. That's because 1,000,000 times more likely in the forensic world is considered a very strong association. So 1,000,000 has 6 zeros, 1,000,000,000 has 9 zeros, 1,000,000,000,000 has 12 zeros, and a septillion has 24 zeros. So it is significantly larger than what is even considered a strong association.
In the swabs that were taken from the roadway, was there only one contributor?
Yes.
Are your findings reviewed by anybody?
Yes, all of my findings are reviewed in a technical review as well as an administrative review.
One moment. Nothing further.
Cross-examination.
Nothing, Your Honor.
All right, you may step down. Thank you.
Thank you.
Next witness.
The state would call Tyler Meter.
Raise your right hand, please. You swear to testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God. All right, have a seat.
Could you please introduce yourself and spell your name for the record?
My name is Tyler Meter, Tyler. Last name Meter, Meader.
Where are you currently employed?
At the Lake County Crime Laboratory.
What is your job title at the Lake County Crime Laboratory?
I am a forensic analyst in the Controlled Substance Department as well as in the Toxicology Department.
And how long have you been employed at the Lake County Crime Lab?
Approximately 7 years now. October of 2018 I started.
Briefly, what are your duties as a forensic analyst?
A forensic analyst, my duties in the Toxicology Department consist of analyzing bodily substances for the presence of alcohol and drugs.
And what education and training have you taken to qualify for your position?
I graduated from Mercyhurst University with a Bachelor's of Science degree in Applied Forensic Science with a concentration in forensic chemistry. Following that, once I was employed at the crime laboratory, I completed an extensive year-long training program that consisted of reading all of our procedures, watching competent analysts perform work, being competency tested as well as proficiency tested, as well as receiving a certification through the Ohio Department of Health to test alcohol, blood and urine for alcohol.
And how do you become certified by the Department of Health?
To become certified by the Department of Health, You have to be practicing toxicology volatile analysis for at least a minimum of a year, complete proficiency tests and pass them, deemed competent by your laboratory, and then following those steps, the Department of Health will send you a certificate stating that you are certified to perform volatile analysis.
And do you renew that annually?
Yes, that is renewed annually.
Were you certified back in 2024?
Yes, I was.
I'm going to show you what's been marked as States Exhibit 14A and B. Do you recognize those?
Yes, that is my Ohio Department of Health alcohol testing certificate.
Your Honor, the state would ask to admit and publish States Exhibit 14A and B.
Objection. All right, they're admitted.
And this indicates that you were certified by the state of Ohio in 2024 and in 2025?
Yes.
Is the Lake County Crime Lab accredited in toxicology?
Yes, they are.
And was it accredited back in 2024?
Yes.
What is the process for testing blood?
The process for testing blood will, one, consist of retrieving the evidence from our locked evidence room inside of our locked evidence cage. I will scan that into my possession by its unique barcode, which its chain of custody will be tracked in limbs. I will ensure that the box that the toxicology specimens are submitted are properly sealed. I will then itemize each blood tube and or urine container in the evidence, and then I'll proceed with my testing.
Okay. And can you describe the testing that you do on the blood tubes?
Yes, the volatile testing is done on the Headspace GC-FID, a Headspace gas chromatography with a flame ionization detector. That instrument will separate out any and all volatiles and identify what the volatile is and the concentration of that volatile based on the signal that the FID produces. The samples are run in duplicate. They have to fall within a 2.5% window of the lower volume. The volatile analysis, I will do an independent 6-point calibration curve per batch and also run 3 control blood samples for each batch, and those values have to fall in acceptability ranges or the batch will be a failure and I will not be able to report results.
Where is blood evidence stored when not being tested?
The blood evidence is stored in the refrigerator in the evidence room. Once I retrieve it, I will do the testing, and then the blood is stored in the refrigerator in the toxicology room.
And with respect to this case, did there come a time when the Lake County Crime Lab received evidence from the Monroe Police Department regarding a Dennis Boyd?
Yes.
And did you receive a sealed cardboard box labeled Boyd, Dennis E?
Yes, I did.
And what was included in that box, if you recall?
Included within that box was 2 sealed gray top tubes containing whole blood.
And are you familiar with those boxes and those tubes?
Yes.
And can you describe what they are?
The boxes, the Lake County Crime Laboratory purchases boxes or kits, as we call them, which consists of 2 gray top tubes with the appropriate anticoagulant and preservative in the tubes, with a povidone iodine patch, which is used to clean the skin or injection site so no volatile or ethanol is used for sterilization, and 2 seals to properly seal the container, the blood tubes, when they're done.
I'm going to show you what's been marked as States Exhibit 7A through...
We have the whole bird menagerie outside.
There's Exhibits 7A and B. Do you recognize these images?
Yes, I do.
Did you take these images?
I did.
And what are these?
The States Exhibit 7A, the first picture I see is the top of the toxicology box looking down, which states the individual's name and the agency's case number.
And the second one?
The second one is a front snapshot of the box with our Lake County Crime Laboratory barcode on it.
Your Honor, permission to admit and publish States Exhibit 7A and B.
Any objection? No. All right, they're both admitted.
So that's that white cardboard box we were speaking of.
Yes, and if I also may, you'll see 2 dates on the top of the box. That is the date in which I opened that container of evidence.
And that yellow seal, who affixes that to the box?
The yellow seal in the middle center of the box, that would be either the hospital or the submitting agency.
Okay, moving on to States Exhibit 7B. What is this view of the box?
That is the view of the front looking at the box with our laboratory barcode, and then the blue tape on the top is one of the seals that I placed on the container when the sample was going into storage.
Thank you. Did you perform analysis on the tubes that contained in that box?
Yes, I performed analysis on one of the tubes submitted in the box.
2 were submitted?
Correct.
And did you memorialize your findings in a report?
Yes, I did.
I'm going to show you what's been marked as States Exhibit 11. Do you recognize States Exhibit 11?
Yes, I do. That is an electric copy of the report that I generated in this case.
And does the Lake County Crime Lab maintain these reports in its ordinary course of business?
Yes, they do.
The techniques that you used to analyze the blood evidence in this case, are those techniques generally accepted within the scientific community?
Yes, they are.
Are the findings in your report accurate and reliable?
Yes.
Did you test evidence item 001A, so that first tube, using the method you previously described?
Yes, I did.
What did you find as a result of your testing?
Would you be able to scroll? Thank you. I tested item 001A, the whole blood. I determined that the whole blood contained an ethanol concentration of 0.177 grams per 100 ml ethanol.
Okay. Are your findings reviewed by anybody?
Yes, all of my findings are, they go through a technical review. A technical review consists of all of my notes and generated data are reviewed by another independent, competent analyst to make sure that all of my testing and methodology is done correctly. Once they do the technical review, they will then submit the report for administration review, which will consist of going over all of the grammatical wording within the report, which then will be released to the submitting agency.
And what did you do with the tube that you tested when you were completed with your testing?
After testing was completed, I then placed the tube back into the cardboard box, placed a seal on that, and then I put the container into our freezer within our evidence cage for permanent storage for at least a minimum of a year.
And what did you do with the other tube, item 1B?
The other tube was sent overnight via FedEx to Miami Valley Crime Laboratory to perform additional testing.
And did you include ice packs in that package?
Yes, I did.
One moment. Nothing further.
Ross.
Nothing further, Your Honor.
All right, you may step down. Thank you.
Thank you.
Okay, we're hauling.
Next witness.
Your Honor, the next witness is Kylie Daniel. She'll be appearing remotely.
All right, you want to
on the big screen.
Time, get that ready and let me know. Okay.
Thank you.
All right.
She should already be awake.
Uh-oh. Judge calls a break. All right. All right, you're done. Let's see. Yeah, he wants the break. He got it already. So now the next portion, we have to go through this. Let's see, why am I there? Should be 6 instead. That was, let's see, which one was that? Josh, I'm trying to find the next one. Hang on. That was the 48-minute one.
Barcode on it.
Okay, we got that one.
Illinois at Chicago.
Okay. Next one's right here.
I'm also a certified diplomat in forensic toxicology by the American Board of Forensic Toxicology.
And do you complete ongoing training?
She's a diplomat, whoever this is.
Can you repeat that?
Do you complete ongoing training?
Yes.
Are you certified by the Ohio Department of Health to perform laboratory tests using the GC method to test for alcohol?
Yes.
And were you certified in 2025?
Yes.
We're going to share our screen and show you what's been marked as States Exhibits 15A and B. Do you recognize States Exhibit 15A?
Yes.
What is it?
This is my Ohio Department of Health permit for alcohol testing by gas chromatography that was valid March 25th through March 26th, or March 2025 to March 2026.
Your Honor, permission to admit and publish States Exhibit 15A.
Any objection?
Moving on to 15B, do you recognize this?
My OAH permit for alcohol testing issued March 2026 through March 2027.
Again, permission to admit and publish.
No objection.
All right, they're both admitted.
Is the Miami Valley Regional Crime Laboratory accredited?
Yes, it is.
Okay. And is it accredited in toxicology?
Yes, it is.
And it was accredited back in 2025?
Yes.
Are you familiar with the principle known as retrograde extrapolation?
Yes.
Can you please describe what retrograde extrapolation means?
Due to the way alcohol is eliminated from the body, it is eliminated at a very constant rate in a very predictable way. We can use formulas that have been backed by decades of research to calculate what an alcohol concentration would be at the time of an incident when the blood is actually drawn hours later.
Okay. And what training or study have you had regarding blood alcohol physiology and retrograde extrapolation in particular?
In addition to my previous education, I've also completed our training program here at the lab that includes shadowing, mock case work, written exams. Yeah, in addition to everything else I already mentioned.
And how many retrograde extrapolations have you performed?
5 to 6.
And have you ever testified as to a retrograde extrapolation before?
No.
Can retrograde extrapolation be used to calculate what an individual's blood alcohol concentration would have been at an earlier time?
Yes.
And what information do you need to know in order to perform that analysis?
We need to know many different variables, including the subject's sex and weight, and then any other additional information is helpful, including when the individual stopped drinking, how many drinks were had, what exactly was drank, things like that are all helpful.
Is it safe to say the more information you have, the better?
Yes.
How is alcohol metabolized or eliminated in the human body?
When ingested, it enters the digestive tract. From there, it's primarily absorbed in the small intestine. Then it goes into the bloodstream. From the blood, it is distributed throughout the body, throughout the water in the body, and then it is eliminated at a very constant rate in a linear, predictive way.
Okay. So there's a typical or standard elimination rate that is generally accepted in the scientific community?
There's a range, yes.
And when you perform a retrograde extrapolation calculation, what elimination rate do you use and why?
We use 0.01 to 0.025 gram percent. This is a very large range to encapsulate all the variability in the population, things like tolerance, what food was in the stomach, all those little variables. It is a very conservative, wide range.
And how long does it take you to do one of these calculations?
A couple days. When we get a request, we say give us 2 weeks. But I'll spend a couple days on it, and then it goes through a review process by my supervisors.
And I don't want to get too into the weeds with the math, but can you briefly describe the calculations that you use?
It takes into account the subject's weight and sex, and the time of the incident, the time of the blood draw, and then those elimination rates.
And you using all that information together, you were able to come to a final analysis.
Right.
And are the principles and methods you just described generally accepted and considered reliable in your field?
Yes.
Were you asked to perform a retrograde extrapolation analysis by the Lake County Prosecutor's Office in the Dennis Boyd case?
Yes.
Did you prepare a report summarizing your findings?
Yes.
I'm going to show you what's been marked as State's Exhibit 13A. So we'll share the screen again in a moment. Do you recognize State's Exhibit 13A?
Yes.
Is it a fair and accurate representation of one of the reports you issued in this case?
Yes.
Is it a copy?
Yes.
Where are the originals kept?
The results state ethanol at 0.179 plus or minus 0.018 gram percent.
Does the Miami Valley maintain these reports in their ordinary course of business?
Yes.
And then I'm going to show you State's Exhibit 13B.
I've been resisting my urge to chirp back at these birds.
And do you recognize State's Exhibit 13B?
Yes, this is my opinion and back extrapolation report in this case.
And does Miami Valley maintain these records in their ordinary course of business?
Yes.
What evidence did you receive from the Lake County Crime Lab in order to do your analysis?
We received 2 gray top tubes of whole blood.
Okay. And how was that transported to your lab, if you know?
Through FedEx in this case.
And before you performed your retrograde extrapolation, were tests performed at your lab?
Yes.
And what were those tests?
We did a volatile screen test and a volatile confirmation test on the blood.
And what does that mean?
So the volatile screen test uses headspace gas chromatography, and it looks for ethanol, methanol, isopropanol, acetone, and some huffing agents. So the volatile screen test will give us a presumptive positive or negative compared to a cutoff value. And then anything that is positive will go on for a more specific, more sensitive confirmation test that gives us a quantitative value.
And did you rely on the results of these tests when coming to your conclusion in your retrograde extrapolation?
Yes, I did.
And were those results in line with the results from the Lake County Crime Lab?
Yes, they were.
And in this case, what information did you have about the defendant's known blood alcohol concentration in order to do your testing?
Are you referring to the ethanol value?
Yes.
It was 0.179 plus or minus 0.018 gram percent.
And then what other information were you provided in order to prepare your report?
The subject's sex and weight, the time of the blood draw.
Were you provided the police report?
Yes, the police report, yes.
And you were not provided when the defendant stopped drinking, correct?
Correct.
And are your findings based on the defendant not consuming any alcohol after the time of the crash?
Correct.
And can you please walk us through the calculations you made in this case?
So my initial calculations were 0.219 to 0.279 gram percent. Because we don't know when the subject started or stopped drinking, we don't know when the 2-hour post-absorptive window was met. So because of this, we do an extra calculation that accounts for unabsorbed drinks in the stomach. So this just gives us even more conservative range. And taking this into account, even with 4 unabsorbed drinks in the stomach at the time of the incident, the range was 0.115 to 0.206 gram percent.
And that is over 0.08?
Yes.
And that's the most conservative measurement that would benefit the defendant the most?
Yes.
So from
what would
a
that level of
0.12
impairment look like
to a
physically?
0.21.
Objection.
Overruled.
You can answer.
In the average person, they may exhibit signs of impaired judgment, slowed reaction time, drowsiness, disorientation, slurred speech.
And in this case, the blood was originally drawn on October 20th, 2024, and your lab received it about a year later on October 8th, 2025. Could that gap in time have any bearing on your results?
Because I can't account for the storage before it came to us, but when we received it, it was in a gray top tube, which does contain a preservative and an anticoagulant.
And was the blood clotted?
It was not.
You had no reason to think that the sample had not been stored properly?
Correct.
And your results are based on the defendant not consuming any alcohol after the time of the collision. Would your opinion change if he had continued to drink after the time of the crash?
It may, yes.
And are you able to give us an opinion right now?
I cannot.
And why is that?
Because of all the variables previously mentioned, I would have to sit down and, like I said, take a couple days to do those calculations and go through that review process again.
So giving an opinion on different variables is not something you'd be able to do here on the witness stand?
Correct.
And would a person having a head injury have any bearing on their blood alcohol concentration?
I believe that's outside of my scope.
Nothing further.
She objects to the question.
Thank you, Your Honor. A brief moment.
Hello, Ms. Daniels. Can you hear me okay?
Yes, I can. Thank you.
I am Mr. Boyd's attorney, and I just have a few questions for you. When you were provided with the information, did you speak with the officers?
No, I did not.
The information that you gleaned was solely from the police report that was provided to you?
Correct.
And based on the opinion that you derived, where his blood alcohol was, would you say, between 0.115 and 0.206, that is based on the facts that you learned from the police report?
And accounting for 4 unabsorbed drinks in the stomach.
You were asked if that opinion would change if you drank after the crash, correct?
Yes.
They asked you that. And you said it would change, correct?
It may.
It may. If he had been drinking after the crash, which you believed did not occur, would those numbers of that range be lower or higher?
I can't make that opinion.
Well, if there was additional alcohol that was drank afterwards, it would change your opinion. Would you believe it to be lower?
I can't make that opinion on the stand.
Now, you didn't speak with Mr. Boyd or anyone from his family, correct?
Can you repeat that?
Did you speak with anyone from Mr. Boyd's family? Did you speak with anyone from Mr. Boyd's family?
No.
Now, with your results, you assume that he had to have something to drink prior to the accident, nothing after, right? That's based on your opinion?
Yes.
Now, when you come to that, could you tell what he was drinking?
No.
Now, if without the specific information, would the type of alcohol make a difference when you're going as per drink?
No.
No. What is a standard drink for a beer? In your report, it says a standard drink contains 14 grams of ethanol. An example is a 12-ounce 5% beer.
Correct.
So, what would say a whiskey or a bourbon? What would a standard drink for a whiskey or bourbon be?
It's still 14 grams of alcohol.
And how many ounces of say 100 proof alcoholic beverage would be needed to have 14 grams of ethanol?
I don't know on the stand.
Would they say it was 100 proof alcohol? Would that drink be 2 ounces, or would it still be 15 or 12 ounces?
I'm not making calculations on the stand.
I'm not asking you to make a calculation, but what would you consider a standard drink?
I don't recall if it's 1 or 2 ounces.
She is not here to math.
If it was reported that he was drinking, say, a 100 proof whiskey or an 80 proof whiskey, that standard drink would be a much lower volume, but it would be consistent with the 14 grams of ethanol per that alcohol?
It would change the calculations, yes.
Okay. And in general, say someone has a 100 proof, what is the standard drink for a 100 proof alcohol? You don't know that?
No.
Is this something that is in your resources that you would apply? You just don't have it available to you now?
No.
Now, if Mr. Boyd had drank a significant amount of whiskey without the officer's knowledge after the accident, would your findings change?
With different facts of the case, my opinion would change.
And at this point, you don't feel comfortable saying whether the number would be lower?
I can't make that opinion.
And the facts that you received that are listed in your report, such as you don't know when Mr. Boyd had his last drink, it's based on his sex and body weight as they listed them. It was based on the fact that they did not believe that he had any alcohol after the accident. Those are the facts that you based your decision off of?
Yes.
And if any of those factors were different, then your decision or your findings would be different, correct?
They may be, yes.
How much more significantly different would they have to be prior to your findings being different? Because you just said they may be different. What would have to be changed significantly for your decision to be different?
Significant is a relative term.
Say he weighed 20 pounds more.
She is super cagey.
I can't make calculations on the stand.
Well, I'm just asking, would your report be different? Without the calculation, would that affect the findings and would that make them lower?
A different weight would change the calculations.
And the ingestion time of the alcohol, if it were later than the officers had told you, that would change your absorption rate and your findings also, correct?
It may, yes.
That's about the best he's going to get.
If it was reported to you that he had drank 15 ounces of bourbon after the accident and 80 proof liquor, without making any calculations, would you expect your findings to change?
I would have to do those calculations.
Okay, but in your training and experience and your education, would that make the results different?
It may, yes.
And that would lower the amount of alcohol that you would say would have happened at approximately the time of the accident, correct?
Can you repeat that?
if that were the case and he had drank a significant amount, say 15 ounces of a 80 proof alcoholic beverage after the accident, and that was given to you, your findings would be significantly lower. Is that correct?
I can't make that opinion on the stand.
Based on your training and experience, without making a definitive answer, would you believe that those would be lower?
I cannot make that opinion on the stand.
Nothing further, Your Honor.
Redirect.
Briefly, Your Honor.
She will not math
So
today.
you don't know how your findings will change until you actually do your calculations, correct?
Correct.
And at any point, did anyone contact the Miami Valley Regional Crime Lab or you and give more information about what the defendant drank, that he drank 15 ounces of 80 proof liquor?
No.
The only information you had was what was in the police report?
Yes.
Nothing further.
Any recross?
No, Your Honor.
All right, thank you very much, Ms. Daniel.
Thank you.
All right, next witness.
The state calls Officer Jonathan Miller.
Raise your right hand, please.
Of course.
You swear the testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God.
You stumbling because you're drunk, sir? Oh, just kidding. This is the one we started on before, so we're going to speed through this again. Some of this will be a little familiar.
Can you please state your name for the record, spelling the last?
John Miller, LLER,
And where are you currently employed?
Lutheran West High School in Rocky River,
In what capacity?
school resource officer.
How long have you worked there?
Just finished up my first school year, so 8-9 months.
Were you previously employed for the Menor Police Department?
I was.
Were you employed there in October of 2024?
I was.
In what capacity?
Patrol officer.
Were you working on October 20th of 2024?
I was.
And were you called to the scene of the crash that we've been discussing today?
I was.
What was the nature of that crash?
Motorcycle rear-ended a Jeep, and the motorcycle left the scene. It was reported that the motorcyclist was injured.
What time did that call come in?
I believe around 3:20
Okay.
p.m.
3:20 p.m. was the time of that call?
Yes.
And who was at the scene when you arrived?
Officer Law.
And anyone else present?
Vanessa Clapp.
Did you speak to Ms. Clapp?
I did.
Did she provide you with any photographs from the incident?
She did.
How did she provide those to you?
She had them on her cell phone. She showed them to me, and then I had her airdrop them to me because I didn't exchange my personal information with anybody.
Were those the photos we saw in State's Exhibit 3 earlier today?
Yes.
Now, how did you find the motorcycle in this case?
The license plate was in the picture, so I radioed it out, and the information was given back to me from NCIC in Leeds.
So, at this time, was Patrolman Burton handling the collection of evidence at the scene?
He was.
What did you decide to do?
I decided to go to the listed address of the owner of the motorcycle.
Okay. And where was that home?
On Heather Hill in Menor.
How far is Heather Hill from the scene of the crash?
Mile and a half, maybe? Mile?
Okay, so how long do you think it took you to get there?
5 or so minutes.
Were you wearing a body-worn camera during this incident?
I was.
And was that body-worn camera activated for portions of the day?
It was.
Was it activated for the last part of your drive to the defendant's house and during your interactions with him?
Yes,
Have you reviewed that footage prior to coming to court today?
I have.
And I know we reviewed a redacted copy. Was that a fair and accurate depiction of the day as you remember it, minus any of the redactions?
Yes.
You got permission to, we're going to pull it up on the screen, State's Exhibit 10. Is this the beginning of that camera footage that you watched?
Yes.
Your Honor, the state moves to admit and publish State's Exhibit 10. It is a redacted copy. We did provide that to defense counsel prior to the time of trial, and they did agree to the redactions.
No objection, Your Honor.
All right, submitted.
Right. What time is it at the top of your body camera right now?
3:45 p.m.
Okay, and then you said that the time of the call was at 3:20?
I believe so.
All right, so we're 25 minutes after the time of the crash?
Yes.
All right. Let's press play. Does it take 30 seconds for your audio to kick in?
I think it's a minute, but
It's 30 seconds.
when you see my hand come to the camera, that's me activating it.
Good explanation, sir. Starts immediately when I activate it. Just saves everything that happened before.
Ms. Bell, can you pause the video there?
Okay, so he
All right,
peeks in the
officer,
garage
what are you doing here?
first.
I'm looking in the garage for the motorcycle.
Are there windows that you're able to see through?
Yes.
Do you have
Is
a
the motorcycle
warrant?
in there?
It is.
How are you able to determine that it's the same motorcycle?
Same license plate, and the driver's side mirror is missing.
Okay, is it in any sort of state of operation?
The flashers are on. I'm not familiar with how that works, but I know in some cars your flashers will turn on after an impact.
We're going to resume the video.
Sit in there.
And it's 15:46 right now as you're ringing that doorbell?
Correct.
That is 26 minutes after the time the 911 call?
Correct.
Hello.
Hi. We need to talk to Dennis.
Oh, hold on. Let me get it for you.
Okay.
Dennis!
Oh my God, this bullshit.
Doors for you!
They're going to Halloween. We're trying to get her to leave and go somewhere else, but she's not cooperating with us.
The kids can run in there. Who's Dennis? The Ravens have arrived. You hear them in the background. There we go. You got to have the guitar with the bells. Dogs are going off.
Hey, Dennis, look.
Hold on. Max.
That dog was big. It's all right, Max. I'm nice.
Come on, inside.
You're a monster.
They want to open the garage.
Sorry about dogs.
All right, right now it's 15:48.
Yes. How are you? Are you okay?
I'm all right.
Okay, so it's 15:48 when the defendant finally comes out of the home? So is that 28 minutes after the collision?
Yes.
Okay, what does he look like when he comes out?
He's wearing a different outfit. Appears to be like cleaned up, barefoot.
Okay. Did he look like he had just taken a shower?
Yes.
Were you able to observe any blood?
No.
You just asked him, how are you? How did he respond to that?
He's good.
Okay, we're going to resume the video.
Accident.
No?
Your bike. You hit a lady on 44. Dumped your bike.
No?
Somebody else borrowed your bike?
I don't know.
You don't know? Okay. Well, how'd you get this?
What? What's that?
This mark here.
Well, Reamer smashed my hand at work.
Reamer? Okay. So, is that your wife?
Yes.
Okay. So you came home and you talked to her. You said you dumped your bike.
No.
She said you did.
She said that?
Yeah.
I didn't drive my bike.
No. Okay. How much you had to drink today?
Not too much.
No.
Can you pause that himself?
Well, 15
How much
ounces,
does the
100
defendant tell you
proof.
you had to drink?
Not too much. And then prior to that, something I would always do when I was suspected a drunk driver was get close to smell him, and I was looking for a wound. I was actually looking for the blood, and on the picture he had a considerable amount of blood here, so my eyes were looking here. I didn't look where the actual injury was because I didn't know where it was, and so I could immediately smell the odor of an alcoholic beverage coming from him.
How close were you to the defendant as you were smelling him?
I was less than a foot at sometimes.
Okay, and that's when you were able to smell him when you were up checking the side of his head?
Mm-hmm.
Is that a yes?
Yes, sorry.
Okay. Were you able to know anything about his eyes?
Yeah, his eyes were glassy, and it was clear to me he was limiting his speech. And
When you say limiting his speech, what do you mean by that?
the less he talks, the less he can slur.
Okay. Let's resume the video.
Okay.
That's next
that guy
level
looks
stuff.
awfully like you. So we can just handle this like men. You got in a crash, you're drunk, shit happens, you brought the bike home, and we're here. That's how it works.
No, that wasn't me. I don't think.
Okay.
Who is that?
So when's the last time you had a beer?
Well, I've been sitting here drinking beers all day long.
Okay.
Can you pause that, Mr.
All right. Well, you come over to my car.
All right. What did he tell you he was doing?
Drinking beers all day long.
Did he say he was drinking 15 ounces of 100 proof whiskey?
He did not say that.
Did he say he was chugging drinks?
No.
Okay. Did he say he'd just been drinking all day?
Yes.
Okay. Let's resume the video. It looks like
When's the last time you had a beer?
I've been sipping on one right now.
Okay.
Sitting in Western Bronx.
All right. Did you take a shower when you got home? Keep walking.
No.
We're going to walk in the car, right?
Nope. Should I go get my shoes on?
No, I don't think you need your shoes.
All right, how many cars are there in that driveway?
2.
And there was a motorcycle in the garage?
Correct.
Okay.
One base, what's the time of this call? Copy that.
Well,
yeah, he's got it.
Let's walk this way, then we get out of that.
Yeah, sure.
Okay. You can face me. You're okay. You're right. You take any medications?
No.
Okay. You wear contacts or glasses?
No.
Okay. Do you have any impairments that would cause you to not be able to stand, balance, walk? No. Your eyes are okay. Okay. Just keep your hands on your pockets.
Well, I'm sorry.
Oh, we can just pat you down real quick.
Yeah, that's fine.
All right.
Cool. Okay. I'm just gonna put you through a couple tests. Just make sure you're okay to drive a car.
Or ride a bike. Even though you don't have a bike license. And you got a big gash on your head and I have a picture of you. So if you want to just... No? So you're going to do sobriety tests. That's what you're going to do. You want to do them?
Yeah, sure.
Okay. Would you face me?
Yep.
Okay. I need you to follow the tip of my finger with your eyes, okay? Keep your head still. Just follow it with your eyes. All right? Watch the tip of my finger, please. Do you understand instructions?
Yeah.
Okay. You're going to need to watch follow the tip of my finger with your eyes.
Yep.
Okay?
What are we doing here, guys?
Okay.
You were drunk riding a motorcycle, so we're testing
I wasn't drunk driving a motorcycle.
You're drunk now?
I'm sitting here in my own home.
Are you telling us you're not going to do the rest of the tests?
Yeah, I don't want to.
Okay. Turn around. You're under arrest. Put your palms together like you're saying a prayer. Fold your fingers. Fold your fingers. Fold your fingers. Yeah, there you go. Okay.
Can I ask why I'm under arrest?
What did I just tell you?
Because I wasn't breathalyzer or your test?
Yeah, you're hammered and you crashed your motorcycle.
I didn't crash my motorcycle.
Who crashed your motorcycle? Have a seat. So you have the right to remain silent. Anything you say can and will be used against you in court of law. You have the right to an attorney. Have one present with you while you're being questioned. If you can't afford to hire one will be appointed for you free of charge. You understand all that? So no one was driving your motorcycle today? It's in the garage with the flashers on, missing a mirror. You have a big cut behind your head. I have a picture of you on the same motorcycle with the same license plate and blood on your face. So
he's got you, man. He's got you.
Here's your chance.
I don't know what you're talking about.
Okay. I want some shoes. We're gonna have to tow this thing.
All right. Why did you do those field sobriety tests down in the street?
So there was big dogs. His wife was present. Based on everything I saw on the front step, he was going to be arrested, but I was going to do the tests in the street. Just if there was any drama, we'd be away from the dogs, be away from the wife, and he'd be close to the cruiser. And then there's another, you can see in this picture, there's a dash cam of that cruiser too.
Did you see anyone else in the home other than Mr. Boyd and his wife?
No.
Okay.
And as we were down here is when the blood started to run down his...
Okay. When did you see the blood?
Down here at the street.
When
I started to point it out to him.
Okay, after he had been placed under arrest?
Around that time.
Okay. Did you believe that he had sustained a head injury prior to doing any of this testing, based on the photos you had?
I mean, he obviously had hit his head.
Okay. But
injured, I don't know.
Did he repeatedly deny having any injuries?
Yes.
Did he repeatedly deny being involved in any sort of crash?
He did.
Let's resume the live camera. Looks like we've got a little bit of a lag.
One there. And the supervisor is under arrest for another. Can you run him all the way through? And start to tow this way for a motorcycle. All firm. I have an earpiece in, this is why you're not hearing the feedback. If you hear feedback, it's from another officer.
There's no question, sir. No pending question.
Yeah, I guess we'll take some pictures of this.
Okay, big guy.
Okay, so do you want to just step out here real quick with me?
Yeah, here. You stay here. Stay.
All right. So here. So here's the deal.
Did Dennis's wife give you consent to open up that garage door to get the motorcycle out?
She did.
Was she just incapable of lifting it herself?
She said she had just had either a knee or a hip replacement.
Okay. Let's resume the footage.
Wait. You hit a lady on your motorcycle and you're drunk, and it is what it is, you know?
Yeah, we need to get it fixed.
Okay.
Is that okay?
Yeah.
Bike's still
Yeah,
hot?
this mirror was left there. It's all bloody. I just need the keys for this because we have to tow it. Okay. I don't even.
I can look in the house. I think they're like a fob type thing.
Oh.
Fob.
Okay.
I'll look inside.
Okay.
You stay. I'll stay right there.
Sir, you're very clicky.
Stay. You stay all fun.
Come here, buddy.
Get inside.
How old is that one?
About 6 months. Little guy.
And a pair of shoes for him.
Okay. Oh yeah, Charlie will.
Okay. So we're gonna tow this thing. We're gonna take a picture of it, and then we're gonna tow it, and then he'll be able to call you here in a little while. Okay.
I appreciate letting me know.
Yeah. I'm just gonna leave with him. I don't know how to move a motorcycle and put it in neutral, but he does. Yeah. We're good, bro.
Okay, cool.
He's in my car.
Okay. So now we have everything. We're just gonna put DNA in evidence. We don't need to.
Yeah, I'm not gonna send it because the same. You can tell where the mirror's from. But I think we just keep it.
Okay, just enter it.
Yeah, and he's got a big gash.
Let me wait. You must have cleaned that up.
They don't test it?
Well, I asked her. I said, "Did he have any beers?" And he got home. I was like, "Okay." And one time the call came in 20 minutes. There's no way you got this drunk because he's hammered.
Yeah. You think we cooperate if I take photos of him?
Not now. Later.
Yeah. Maybe next to do it later.
Well, just not now.
Okay.
All right. I don't know if this is going to be one of those search warrant ones where I got to do all that nonsense.
I don't know. Just photos like that?
Yep, photos, and then you got to back it up because we don't know how. You got to put it in neutral and move it?
Yeah, just to.
I don't know.
If I drop it, I swear to God.
All right, I will get this going.
I don't know how to drive a motorcycle. You know how.
Yes.
Hey Siri, how do I get to the police station from here?
You have any questions? What's up? Do you understand what I told you, though? Or do you not remember? What did I say to you? What's that?
The video footage was pretty loud there. What did the defendant say?
I couldn't hear it.
Were you able to make it out?
Maybe if I heard it again.
No.
Sir, that's distracted driving. Don't be using a computer one hand while you're driving. What's with the whole 10 and 2 instead of one hand at 12 o'clock? water in front of him because he won't let him. You see how it is? Rules for thee and not for me. That's what it is. Imagine policy is that you should pull over before typing, but who's going to stop him? Are we seriously going to watch the whole drive to the station with nothing happening?
Station 5 meet me in the back lot to check up. This will come on his head.
Copy. Was that you radioing to have medical care there when you arrived?
Yes.
Because of the cut on his head?
Yes.
Did the defendant request medical care?
No.
So he radios for
it's
medical
not uncommon
care.
for us to have people with superficial
No pending
wounds that
question.
need, some gauze on it and remain in the jail overnight or whatever.
The witness is narrating his video. There's a Harley. Hear the potato sound. Still next to the bike. Rolls through the stop sign. Never stops.
Step back.
Copy.
Are you pulling into the Menor Police Station now?
I am.
Would a fire truck and ambulance usually be back there, or are they there because you called?
They're there because I called.
So this guy's on a motorcycle. He rear ends somebody on 44 and he falls off the bike. And
allegedly.
Someone helps him. He's drunk. He rides.
Well, he's probably going to just, given the fact that he's intoxicated, and I heard the ball come in, he's going to need to go to the hospital.
Yeah.
I'm not signing him off. I mean, I hate to be that way, but, you know.
Okay, let me.
Especially especially if he's intox and he has a visible head injury.
Yeah.
I mean,
okay.
It's a
Let me
no-brainer.
get somebody else up here with me. Okay. All right. You guys want to? I need someone else in the back lot with me. We're all 10-4.
They're saying, I heard the call come in. He has to go to the hospital. Not here.
Dennis, these guys are going to check your head, okay? Pardon me? These guys are going to check your head. It's on this side, right behind his ear. Big animal. We're going to take him to the hospital and get checked out.
So the medics basically say, there's no way we're going to sign off on this guy and let you just put him in the jail.
At first glance, I couldn't even see his cut, and then it started bleeding. He's refusing everything. Could just let him go. I don't know. How bad is the cut? They have to transport it? It's going to happen. Well, the boss said, yeah.
switch his cuffs to the front.
Okay.
And then
basically said since it's a no helmet, DUI, crash on the road, he should go get treated.
I heard dispatch originally sent you guys to it, and the caller said he was, their words were thrown from the bike or whatever.
Yeah.
I'm not going to put all of us at risk and let him go in the cell and he goes to sleep, and then that's it.
For sure.
So,
well, let's find out first if he's got a felony conviction, just to see, because then we'll...
I thought you did that.
I couldn't get a CCH while they haven't attached to the call.
Okay. So I was trying... Short term, we just switched the cuffs to the front. We'll start evaluating.
Wow. Wow. The police just want to lock him up. The medics are like, we can't do that. He needs to go to the hospital. He shouldn't have come here. You should have taken him to the hospital.
Yeah, I was going to say, private moments.
Does anything else hurt, Dennis?
He's got swelling here. He has swelling in 2 places. All right, you're up here. Let's swing your legs up. All right. We'll slide in the range.
They probably got to have one of those rival anything else.
Yeah, we're going to have to just do the standby on it for now until we can verify that it's a felony and we have to...
Yep. Dude, I couldn't even see it the first time. Shit. All right, let me park this. Yeah. A good clip. 20 maybe.
This officer's trying to cover for himself, saying, oh, I couldn't even see it was bleeding until I got here. But he knew there was blood at the scene of the accident. So now he's going to ride up.
Hey, John, if he goes, one of us has to go with you, right? Or...
yeah, the beginning.
Okay, no problem. So, you'll have to follow and I got to ride.
Okay.
We may just let him go, but they got to check the CCH.
Okay.
All right, when you say you may just let him go, does that mean that you weren't going to charge him for OVI?
I mean, we would charge him at a later date.
Okay, but you would let him go so that you didn't need to pay for his medical transport?
That's, yeah, yes.
Okay. Were you able to run his CCH?
Ultimately, yes.
Were you able to confirm if there was a prior conviction for a felony OVI?
Yes,
Was that from 2015 out of Geauga County?
it was.
You said that you would ride in the back of the ambulance there. Did you wind up riding in the back, or did Officer Hagen?
Officer Hagen.
Based on the defendant's level of cooperation, did you anticipate that he would voluntarily give you a chemical test?
Overruled. I did not.
So what did you do instead of going to the hospital?
I drafted a search warrant.
Okay. Did you have some difficulties with getting that search warrant processed?
Yes.
Were you attempting to use the Easy Warrants online system?
I believe I was the first one ever, yes.
And were you unable to do such?
Unable to get the signature to work.
Did you wind up needing to ask the judge to meet you at Lake West Hospital?
I did.
Who met you at Lake West?
Judge Condon.
Did he sign that search warrant at 6:43 p.m.?
He did.
And was the blood drawn at 6:55 p.m.?
It was.
And is that 3 hours and 35 minutes following the time of the crash?
It is.
What was the reason for that 15-minute delay between the signature and the blood actually being drawn, since all of you were at the hospital?
We were about 20 yards from Mr. Boyd, and he just wasn't going to comply. So then we brought in staff, and we were going to use reasonable force to get it from him, and that was expressed to him, and then ultimately he complied. And multiple times he said he was going to get up and pee on the floor because we wouldn't let him pee because we wanted the urine for the test.
Was that blood collected in those gray top tubes as described by the witnesses that have previously testified?
It was.
And was that sent to Lake County Crime Laboratory for testing?
It was.
And that was the same blood sample discussed by Nurse Marissa Solomon, Tyler Meter, and Kylie Daniel today?
Yes.
One moment. And just confirming that the scene of that crash was in Menor, Lake County, Ohio?
It was.
All right. I have no further questions. Thank you.
Ross.
Officer Miller, let's see. Ultimately, what citations were issued to Mr. Boyd?
I believe leaving the scene of a crash, OVI, and I believe there was like an administrative one for vehicle forfeiture.
Was there also an assured clear distance for an accident and a no motorcycle endorsement?
I believe so. At least no.
If they were listed in your report, you would have listed them because you cited him with those?
I or somebody else, yes.
Okay. Now, when he first came to the door, when did you first smell the odor of alcohol? Was it fairly soon, very quickly?
It was on that first, when he stepped out onto the little landing.
Okay. If you stepped away from him, did you lose the odor?
I don't remember. It depended on the wind.
But it seems like from your body cam footage, you were fairly close to him the entire time until he was placed in the patrol cruiser, correct?
Correct.
Okay. And you heard Officer Law testify that he had to be about 5-6 feet away before he could smell the odor. Do you remember that?
He had to be 5 feet away to smell it?
Well, he said it was actually 10 feet, he didn't smell it. He stepped closer. And I said 1 step, he said maybe 2 or 3. And I asked him about 5 so feet, and he said yes. Do you recall that testimony?
Yes.
So does that seem fairly accurate from your experience being on the scene with Mr. Boyd?
Yes.
At what point did you learn Mr. Boyd's driving history?
The OVIs or the no MC endorsement?
Any of it. I'm assuming they all came together. It would be his leads?
It would have been radioed to me because I was out of the car, so I couldn't see it myself. I think I knew before I went to the house that he had the multiple DUIs, or OVIs.
And were you aware that he didn't have a motorcycle endorsement?
I was.
You referenced that to, I believe, Officer Burton.
Yes.
Or another officer when you were on the scene at your body cam. You mentioned that he
Yes.
didn't have an endorsement, so you knew that?
Yes.
Okay. He was not very honest, in your opinion, when he was speaking with you at his house, correct?
Correct.
And you referenced numerous times that your conclusion is that he was impaired.
Correct.
Or intoxicated. Same difference, right?
Correct.
When did you make that determination?
As soon as I smelled it, the smell is kind of like the bow on the present. I see all the other things, and then the smell, I know it's not
bow on the
it could be
present?
drugs, but that's when I know.
Got it.
But you've been doing this, you were a Menor police officer for 24 years and 11 months and 1 day?
Mm-hmm. Yes.
As I just learned today.
Mr. Dean, hang on 1 second. I got to attend to something. It'll take about 5 minutes.
All right. Judge calls an audible and says, "Wait, don't go anywhere." Leaves the witness on the stand, who promptly gets down and gets his water. Let's fast forward just a little bit because we can. Oh, now we can't.
Forensic science from the University of Illinois.
Hang on. We're going to go back and get the next one, which I believe is the last one.
From looking at the body cam footage, and I noted it was 15:48, and I believe the prosecutor asked you, that's the time when he came to the door. Is that, do you recall that?
I believe so.
Which would have been 3:48 in the afternoon?
Yes.
Which was approximately 2 minutes after his wife had answered the door?
Correct.
Because you did in your report, you say it took several minutes. You even opened the door to see if they were coming?
Correct.
Okay. At that point, did you think he was being evasive, or did you think he was doing something nefarious?
I did.
Once he came to the door, did that dissipate?
I mean, he changed his clothes, so I was.
If you had blood coming down from you, and wouldn't you clean yourself up?
Yes.
And it appeared to you that he had cleaned himself up?
Correct.
Did you have any doubt that he was the one operating the motor vehicle based on your investigation up until the point he came to the door?
No.
The questions that you would ask him, one of them was, you talked to him, or you didn't ask him, but they asked you, the prosecutor asked you, did you see anybody else at the house? You answered no, correct?
That's right.
Did you guys inquire as to whether or not there were any other occupants of the house or anything?
I didn't have a need to, so no, I didn't.
as part of your investigation, Mr. Boyd, Dennis was what you needed.
Correct.
And that's what you focused on?
Correct.
Okay. Now, when you showed him the picture, did you feel that it was fairly obvious that it was him with the motorcycle, the person that was in front of you, and you showed that to him and he said he didn't believe that was him? What did you think at that point?
I was hoping he would just come clean. That technique works a lot for me, and it didn't that time.
And that's not unusual for people that you're investigating, for them to lie to you, correct?
Correct.
People want to try and avoid any issues that they would have?
That's correct.
Now, at what point did you arrive at the hospital?
I don't remember. It would have been minutes before that warrant was signed.
The 6:43 time that you were asked when the judge signed it, you would have been there just a few moments before?
Correct.
And then with him saying he wanted to take a pee, had he asked repeatedly to go to the bathroom?
I believe so.
Approximately how long prior before you showing up did you learn that he was trying to use the restroom?
I think I was told that by either Officer Hagen or one of the nurses.
So it had been going on prior to the search warrant being present at the hospital, correct?
Correct.
Why wouldn't he be allowed to have any water?
Didn't want to dilute any test.
Is that based on scientific knowledge or just common sense that you guys would believe as officers?
I don't know. I mean, it just makes sense to me that water would dilute a sample. And if we were allowed to have him have water, then we would be challenged. And why did we let him have water? So the easiest thing is you're not gonna die in 3 hours, so you're just not gonna have any water.
In your investigations, in your experience, training, everything you know as a police officer and a human, one of the things that affects people and their ability to focus, concentrate, would be a head injury, correct?
Correct.
And it's pretty obvious from the reaction of the fire department that that was something significant, correct?
Correct.
Were you aware that he needed staples to treat that injury?
I was a four-blader, yes.
Was that surprising to you based on what you had seen from Mr. Boyd's injury?
I didn't know it would need staples, but I mean,
you're not the medical expert,
correct.
But you're not surprised by that if you saw it, correct?
Correct.
So would it be likely that that would have affected him and his ability to focus or think or respond in any way, shape, or form?
I don't know that.
But you do know that that's a factor to consider, correct?
Yes.
Now, after he had given the samples, which he was required to do with the search warrant, at that point, was he compliant?
Yes.
When he would not, prior to him not giving the sample voluntarily, when you say, look, we're going to take that sample, once you informed him that you were going to take that sample and you had the manpower to do that, is that when he complied?
Yes.
So he didn't want to, but he wasn't going to fight with you guys?
Correct.
From the odor of alcohol, from the odor that you could smell, could you tell what he was drinking?
I could not.
Did you ask him what his other drinks were, other than the one he told you he was just sipping on?
I did not.
So you knew he had been drinking since he was home?
That's what he said.
Did you think that was incorrect also?
I did.
Why did you think that was incorrect?
I learned other information.
Wasn't that the most likely thing based on what you observed from him, of all the things, or all the answers he had given? That was the most likely one to be true?
I've encountered this before and found it not to be true, so
But in this case, you don't know if that was true or not, correct?
That's true.
Now, from the time that he was at the door at 3:48 p.m. and he exited that door to his home to come into contact with you, at that point on, had he had anything to ingest, either any food or water?
I don't believe so.
Well, we know from Officer Hagen's testimony that when he was with him, he wouldn't let him drink anything.
Correct.
And he was with him up until the search warrant was executed, correct?
Correct.
And you were with him prior to him going into the ambulance, and there was nothing on the scene there, or at least I didn't see any waters or anything, you didn't ask for anything. So up to that point, we know that he hadn't ingested anything, correct?
Correct.
And you're aware that the blood alcohol that was taken at 6:55...
Sorry, I'm getting a hamstring cramp.
Yeah.
I'm sorry, I'm getting the cramp. This witness chair is really uncomfortable.
And that was the execution of the search warrant was 3 hours and 35 minutes after the accident.
That's correct.
So we would know that at least, I would say, for approximately 3 hours, we know that he did not ingest anything.
Correct.
And his blood alcohol was 0.177 for the lab results. Did you review that?
Correct.
and it was, what was it, 0.246 per the urine?
I believe so.
You know the standard for the blood would be 0.08 for the minimal OVI, correct?
Correct.
And for the urine, do you know what that level would be?
Not off the top of my head.
Just one moment, Your Honor. So for the urine, would the minimal level be 0.11? With whatever the grams per nanograms or milliliters, whatever that is.
Is that the legal limit or what his
The per se
was?
limit for the low tier for an OVI for urine. Are you aware of what that number is?
I used to know that number. I don't remember.
As far as you would know, are you aware that if a sample is breath, blood, plasma, or urine, then the per se limit is different?
Yes.
You don't know exactly what they are by memory?
Correct. Yeah.
Okay.
Yes.
And you also know that the high tier limits would also be different, correct?
Correct.
And at 6:55, after 3 hours, he was 0.177. What would you believe that number would show in a person?
It would be it would depend on their size and that, but usually it's all the symptoms, all the things he was showing, the slurred speech, the glassy eyes, slowed movement, odor of an
Train in the
alcoholic beverage.
background.
And he appeared more intoxicated later when you saw him at the hospital than he was when you initially saw him on the scene. Isn't that correct?
I didn't make that conclusion.
Did you have minimal interaction with him at the hospital?
Yes.
Okay. So you couldn't, and he was in the bed that entire time, correct? So you couldn't determine his impairment at that point by any of his physical characteristics?
Just the speech and the slow to react, but the walking, no, I didn't see that.
And those were still consistent, if not greater than they were when you initially saw him?
Yes.
With the information you received about him wanting to urinate, him wanting to have water, would you consider that a factor in somebody who would be impaired?
The way he was acting, yes.
But he wasn't like that with you at the scene, correct?
Correct.
So he became not belligerent, but somewhat on the low scale of that?
I believe he was intoxicated and uncomfortable, and he had to go to the bathroom.
Okay. Nothing further, Your Honor.
Any redirect?
Yes, Your Honor. Officer, based on your training and experience, does a person's blood alcohol concentration change when they have a head injury?
No.
That's impacted by the amount of alcohol that a person consumes?
That's correct.
Okay. And did the defendant explicitly tell you that he had been sipping on beer all day?
He did.
Did he ever mention drinking whiskey?
He did not.
Did he ever mention drinking any kind of liquor?
No.
Did he twice tell you that he was drinking beer?
Yes.
And that it was all day?
Yes.
No further questions. Thank you.
Any recross?
No, Your Honor.
All right, you may step down. Thank you. Next witness.
Your Honor, the state rests pending the admission of any outstanding exhibits. I believe we've moved everything into evidence, though, and have those prepared on a court drive, copied over, but we have not performed the hashing process yet.
Okay. Everything that you submitted, or everything you identified, with the exception of the expert reports.
Yeah, so 11, 12, and 13 are the only ones that we identified but did not admit.
Right, those are the reports, correct?
Yes.
All right, so everything else was admitted without objection.
Okay. We have those on the court drive, but we'll perform the hashing procedure before we pass that over.
Okay.
Thank you.
Then why don't we take a break for lunch? And then
I can make a rule on that at this point.
Sure.
And if I could ask if we could pick up after lunch at 1:20, I do have something in Painesville Municipal Court that I would just have to address to continue. I was hoping that we would be completed by this time. And they'd asked me to continue if they're hopeful that I could be there. But I have to be there in person and ask for it to continue, even 1:15.
Judge, we would be fine going through without a lunch break or
Okay.
coming back at 1:15.
well,
Skip lunch,
do you have
Judge.
witnesses ready to go?
I have 2 witnesses at this time and a third one that we believe should be here. We don't know where he is.
Okay, go ahead and make whatever motion you want to make.
I think Rule 29, Your Honor, I don't believe they've proven every element of the offenses. So we have Rule 29 on each of the counts that are charged.
Your Honor, the state has presented sufficient evidence that a reasonable jury could find the defendant guilty beyond a reasonable doubt on each and every element of the offenses. First off, we have provided a stipulation that the defendant has the prior conviction required for the OVI offense. Additionally, we've provided evidence of his impairment through not only his conduct and his operation of that motor vehicle, but additionally the evidence from the Lake County Crime Lab and Kylie Daniels for her expert report and that backwards extrapolation that show that he would have been well over a 0.08, falling in line with impairment for the requirements of operating a vehicle under the influence. We haven't heard any testimony or evidence that there was any consumption of alcohol after he was driving that vehicle. The statements that were made to the police department were untruthful, as admitted by Mr. Deeb himself. So we'd ask the court to allow us to proceed on that count. As far as the refusal is concerned, we saw the 2255 be read to the defendant, telling him he had the right to submit to chemical testing. We heard that he refused that not only to Officer Hagen, but to Officer Miller, and then that a search warrant was required in order to get any sort of chemical testing that we did have. And we've heard an abundance of evidence regarding the failure to stop after an accident. The defendant was involved in a collision. Whether it was his fault or not is of no consequence to that charge. He was a participant in a motor vehicle collision, and he chose to leave the scene of that accident without providing his name or his information. So there is sufficient evidence on that, and we would ask the court to overrule the defendant's motion. Thank you.
Your motion is overruled based upon the evidence and the standard applicable. Call your witness.
Timothy Boyd.
Timothy Boyd. Timothy Boyd, the identical twin cousin of the defendant, takes the stand. No, just kidding. That would be a twist, though, right? That would be a twist. Twin cousin who lives with them and rides motorcycles.
And would you raise your right hand? Swear testimony about to give us the truth, the whole truth, and nothing but the truth. Help you God.
Yes.
All right, have a seat right
Step
here.
farther forward. This must be son. I think it's the son.
Oh. Tim, could you please state your name and spell your last name for the court?
Timothy Boyd, B-O-Y-D.
And where do you currently reside?
470.
We don't need the address.
And who lives at that residence?
My father, my mom, and me.
So you currently live with your parents?
Yes.
On October 20th of 2024, where did you reside?
5497.
Don't need that either.
So with your parents?
Yes.
Going back to October of 2024, were you employed?
Yes.
What were you doing for a living?
I was working at Byers in Menor.
Byers Ice Cream?
On the 20th of October, do you recall what date that was of 2024?
It was a Sunday.
Were you working on that day?
No.
On the 20th of October in 2024, when I reference or ask questions, I'm referring to that date, okay?
Okay.
So on that date, do you recall the time you woke up?
Probably around 11, I want to say.
Did you have anything on your schedule that day?
No plans, really. I was going to watch Browns game. That's about it.
What time was the Browns game?
4-ish, 4 o'clock.
What was your plans for the Browns game that day?
Me and my dad were going to watch it. That's the plan.
When did you guys formulate that plan?
A little earlier in the week. We usually watch every game on Sunday, so.
And you were going to watch them at home?
Yeah.
When you woke up, did you talk to your dad?
No, I didn't.
Before we get into this, I should say, the gentleman sitting over here next to where I was sitting or standing at the far end here with the glasses and the collar button-down shirt, is that your father, Dennis Boyd?
Yes.
Now, did you speak with him that morning?
No, I did not.
Why not?
I was sleeping.
Okay. When you got up, do you know what it was?
I later found out my mom had told me he was working with some buddies.
Did you talk to him throughout the day prior to him arriving at the residence?
No, I did not.
Any texts or phone calls?
No.
So, when was the first time that you saw your father that day?
When he arrived at the house later that afternoon.
Where were you when he arrived?
Upstairs in my room.
How do you know he was home?
I heard his bike pull in.
When you heard his bike pull in, what did you do?
I went downstairs.
When you came downstairs, did you see your father?
Yeah, I did.
Why don't you tell me about that?
He was sitting in the kitchen, right by our sink, and he was having a drink.
So he was in the kitchen, and you could see him having a drink?
Yes.
Describe the layout of your house for us.
We lived in a split-level home, so it was like 6 steps downstairs, leads into the living room. To my right is the kitchen, and front right is the dining room. It's all open. I can see everything.
So if he's in the kitchen, would you be able to see him from the different rooms in the house?
Yes.
And when you came downstairs and you first saw him, where exactly were you?
At the bottom of the stairs.
How far away from him were you?
Probably 6 feet, 7.
What did he look like at that point? What was he wearing, and did you notice anything about him?
He had an orange shirt on, jeans. His back was turned to me.
And you heard him come in, so you say you heard his motorcycle pull up. So was that his motorcycle?
Yes.
When you said he was drinking, what did you see?
His head tilted back and then put a glass on the countertop.
What kind of glass was he drinking from?
It's like a circular whiskey glass, I want to say.
How large is that glass?
12 ounces.
Was he drinking whiskey?
Yes. Yeah. There was a bottle of Jim Beam right next to him.
Jim Beam's a whiskey?
Bourbon. Is that bourbon?
Are you a whiskey drinker or bourbon drinker?
No.
Bottle of
Did you see
Jim
the bottle
Beam.
of Jim Beam at that time?
Yes, I did.
Had you seen the bottle of Jim Beam prior to your father coming home that day?
Yeah.
How full was that bottle of Jim Beam?
3/4 of the way.
What size bottle was it?
The standard is a fifth, I think.
Just a regular bottle?
Yeah,
Where did you guys keep that bottle?
in the fridge.
Did you hear him going to the fridge when he came home?
No.
Now let me.
So, what part of his body could you see when you first saw him having a drink?
Just his entire back, top to bottom.
He was facing away from you?
Yeah.
Okay, I'm going to pause just for a second. Would it be wrong to say that this is a very believable story? Getting absolutely plastered right before watching the Browns, your team, play. I'm not a big fan of sports, but are the Browns like a top performing team, or are they more lower performance? Somebody still help me out here.
And
just curious.
Did you move or walk, or did he move or walk so you could see a different portion of him?
Not at that moment, no.
After you saw him have that first drink, what did you see him do?
Poured himself another one.
Team to lose again.
Approximately how full did he pour that glass?
A little over half.
That's what I'm saying.
What did you do while he was doing this?
I had noticed there was a red wet spot on the back of his head, so I said, "Hey, what's up? Are you okay? What's going on?" And that's when he had let me know. He said, "Yes, I'm fine." I laid my bike down.
When he spoke those words, how did he address you? Did he look at you and look you in the eye and have a conversation, or was he, describe how he was?
It was like a little side glance, I guess, and then turned away. He seemed pretty upset.
Upset you?
I didn't think so. I just, in general.
So his demeanor wasn't very friendly to you at that point?
No, it wasn't.
You said he seemed upset?
Yeah.
Did you see him moving around in the kitchen?
Not at that moment, no.
You saw him pour a second drink?
Yes, I did.
What did he do with that?
He proceeded to drink it.
How long did it take him to drink it?
Not very long.
How long were you with him before you saw him finish his second drink?
I remained downstairs. I just wanted to keep an eye on him, really.
But from the time you initially saw him drinking the first drink until the time you saw him complete the second drink, how much time do you think passed?
Oh, minutes. Less, a couple minutes.
2 minutes?
Yeah, I'd say.
And you had addressed him. What did he say to you?
He just said, "I'm fine. I'm okay." I had to lay my bike down. It was short.
What did you think he was upset about?
Well, I know he loves his bike, so.
If he says he laid his bike down?
Yeah, it's probably pretty damaged. I don't know what he did, but.
Would that be upsetting to him?
Yeah. Oh yeah.
Why didn't you inquire further?
I just know not to poke the bear, I guess. I could hear in the tone of his voice that he was pretty upset, and I didn't want to bother him.
Okay. So, moving to after his second drink, and you had that short, brief interaction with him, what did you see him do?
He was kind of feeling himself out, it looked like. He was walking around the kitchen a little bit, and he was wincing. It looked like he was walking with a little bit of a limp.
Is that usual?
No.
What did you believe at that point regarding the status of your father?
He was not okay.
Did you feel the need to inquire for any emergency services?
No, I mean, I saw the red spot on the back of his head, but it wasn't leaking. It wasn't squirting blood anywhere. And like I said, he was pretty upset, and I didn't want to bother him, so.
When you said he was wincing around the kitchen and limping, was he having trouble performing any tasks?
No.
So after that second drink, what did he do?
Proceeded to drink it.
Okay, and then after he finished that one?
That's when I went and sat down on the couch, and I saw him walk upstairs.
Prior to him going upstairs, did he pour another drink?
I believe so.
Did you see him drink that drink?
No, I didn't.
When you went away from that initial location, where did you go?
I sat on the couch in our living room.
From that vantage point, could you still see directly to your father?
Yes.
Was there anything obstructing your view?
No.
And did you see him having any difficulty moving around or departing the kitchen?
No.
When you saw him depart from the kitchen, what did he take with him?
His glass and his bottle.
So he took the bottle of Jim Beam and the glass upstairs with him?
Yes.
Did you see him take any more drinks?
No, I did not.
And at that point, what did you do when he went upstairs?
I just sat on the couch. I was messing around on my phone. The Browns pregame was on, so I was watching it on TV.
And did you go upstairs and check on it?
No, I didn't.
Do you know what was going on upstairs?
No.
Do you know if he had showered at any point?
I did hear the shower start, yes.
At this time, since you've come downstairs, had you interacted with your mother?
No, she was outside at the time.
While your father was inside and you were talking with him or observing him, had she come in at all?
No.
Did you guys see her or know what she was doing?
I didn't.
Had you tried to address her at any time?
Not while he was there, no.
So during the time that your father was there, did you have any interactions with your mother?
No, I didn't.
As far as you were physically observant, did you see your father and your mother have any interactions?
No, I didn't.
Now, did there come a time when you came back downstairs?
Yes.
Where were you when you came back downstairs?
I was still on the couch.
And what would you say, just a few minutes later, were you keeping track?
Maybe 20.
Were you paying attention to the time?
No, not really.
As far as what you observed when you came downstairs, what was he wearing?
Just the shorts.
No shirt? Nothing else?
No.
Just a pair of shorts?
Yes.
When you saw him come downstairs, did he have anything with him?
He had his glass in his bottle.
Okay. And did you have a conversation with him?
No, he just walked right through the kitchen.
Okay. Were you paying attention to what he was doing?
Yeah, I heard the fridge open again, and then he walked. We had screen sliding doors that leads out to our deck, and he walked outside.
Did you observe what he was doing at that point?
No, not really.
While he was out there, what did you do?
Well, I figured we weren't going to watch the Browns game together, so I ended up going back upstairs to my room.
When he went outside, you said he opened the fridge and grabbed a beer.
Yeah.
What did he do with the glass and the bourbon?
He took it outside with him.
And that was that the last time you had any interaction with your father inside the house?
Yeah.
So you said you went back upstairs. How long from the time he went outside until the time he went upstairs? How much time went by?
So what?
How much time went by from the moment he walked outside the screen door until he went upstairs?
I'm honestly not sure. Off the top of my head, 10 minutes, maybe.
Were you paying attention to time?
No, not really.
While you were upstairs, did you hear someone come to your house?
Yes, I did. I heard knocking.
Okay, describe the knocking.
It was loud. Bunch of knocks. So my bedroom window is right above our front door. So I kind of tried to glance out, and that's when I noticed there was a Menor police car at the end of our driveway.
Okay. Did you go downstairs and talk with the police?
No, I didn't.
At any time during this day, did you interact with the police?
No, I didn't.
So what did you hear after you heard the knocking?
A woman's voice that I assume was my mom who answered the door.
And then what happened?
I heard her yell for my dad's name.
Okay. And then did you hear or see your dad at that point?
No, I didn't.
Did you leave your room?
No, I didn't.
Did there come a time when you know your father answered the door?
Yes, yeah.
How do you know that?
It was all guys talking. I couldn't make out much. I heard the word accident, which I assume was one of the police officers, but that was about it.
After they were having a discussion, were you paying attention to what was going on out there?
I was trying to, but I couldn't make out much.
Did there come a time when you could make something out?
No, not really.
What about visually?
I saw him walking down the driveway.
Were you paying attention to what was happening at that point?
Yeah, I was trying to.
And what did you see your father and the police officers do?
They walked down the driveway, and that's kind of when I said, okay, he's probably getting arrested. So I just shut my window.
Did you know why he was getting arrested?
No, I didn't.
So at that point, were you aware that the officers were at your house for a period of time after that?
I'm sorry, what?
Were you aware that the officers were at your house for a period of time after that? After your dad was taken away?
No, I wasn't.
Did there come a time when you came out of your room?
Yes, yeah.
When you came out of your room, was there anyone else at the house besides your mother?
No.
Where was your mother when you came out of your room?
In the living room.
And at this point, what did you do?
I talked to her. I said, what happened? What's going on? And then she had let me know he got in an accident. And we just tried to make a game plan, really, see what the next steps were.
Okay. What was the next thing that you did?
I sat back down on the couch, and Browns game was on at that point.
Okay. Did you happen to go outside on your patio at any time that day?
Yes, I did.
Approximately how long after you came downstairs did you go out on the patio?
10, 15 minutes.
And when you went on the patio, why'd you go out there?
I saw trash out there.
Okay, describe the trash that you saw.
It was his bottle, his glass, and an empty Budweiser.
And where were those items?
We had a glass table out there. They were just sitting on the table.
And the bottle. What kind of bottle was it?
The Jim Beam.
Was the Jim Beam you described earlier?
Yes.
How do you know it was the same bottle?
It's the only one we had at the house.
How much bourbon was in that Jim Beam bottle at that time?
Nothing.
So it was empty?
Yeah.
Did you see anything that would appear to look like it spilled?
No, I didn't. Cap was on it.
Cap was on it?
Yeah.
The glass. How much was in the glass?
Nothing.
The beer bottle. How much was in the beer bottle?
It was like backwash.
Just like
I think he probably tossed his cigarette butt in there, yeah.
Inch and a half or two, something small?
Yeah.
And what did you do with those items?
I picked them all up, put the glass in the sink, and then threw the other 2 bottles away.
Did you tell your mom or anyone about that?
No, I didn't.
No. Who do you believe drank those items?
My father.
How do you know it's not your mother?
She's not that big of a drinker. Special occasions, maybe.
Does she drink Jim Beam?
No, she doesn't. Definitely not.
Your mother's drink of choice would be an IPA, correct? Yeah,
probably.
Are there any other observations that you saw that day that we haven't discussed that you think would be relevant to the court's determination today?
Nothing off the top of my head, no.
Thank you, Tim. No further questions.
Cross?
Hi, Tim.
Hi, how are
Pretty
you?
solid
All
story.
right, how are you?
You saw all the details.
You ever testified before?
No, I haven't.
All right, now you're here today because this is your dad, right?
Yes.
You have a good relationship with your dad?
Yeah.
You're pretty close to him?
Yeah.
You don't want to see anything bad happen to your dad, right?
No, obviously not.
Seems like you've got a pretty good memory of what happened back in 2024.
Yes.
You remember this pretty clearly?
Yes.
Everything you told us on your direct examination was accurate?
Yes.
Okay. Now, you said that you woke up around 11. Is that correct?
Yes.
And your plan was to watch the Browns game at 4.
Yes.
Right?
Yes.
You usually watch those games with your dad?
Yeah.
You don't miss Browns games?
Try not to.
Okay, those are a regular occurrence in your home?
Yeah.
You're going to know what time the Browns are on?
Yes.
You're going to be ready to watch them?
Yeah.
You wouldn't miss it just because you got the time wrong, right?
No.
Okay. Now, your dad came home sometime after 1:20. Does that sound right?
1:20?
1:20 p.m. Your dad came home sometime after that, right?
Yeah. Yeah.
Okay, so somewhere in the 1 o'clock hour, right?
No.
It would have been 1:20 p.m. or later that your dad came home?
I want to say it was about an hour before the Browns game started.
Okay, so you're thinking your dad got home at, if you're saying the Browns start at 4, he got home at 3?
3-ish, yeah.
Okay. And when he got home, you said he was already drinking by the time you got downstairs.
Yeah. Yeah, he was in the fridge.
You didn't see him pour anything into his glass that first time, right?
No, I didn't.
You just saw a bottle and saw him drinking?
Yeah.
Your dad told you that he was fine, right?
Yeah, he said he was okay.
But he told you he was on his motorcycle, right?
Yeah.
You heard his motorcycle come in?
Yeah.
You heard the noises that his motorcycle made?
It sounded normal.
What kind of car does your dad normally drive?
Ford F-150. It's a
That
truck.
Ford F-150 was in your driveway, right?
I believe so.
Do you know if your dad has a valid motorcycle license?
Not at the time. I don't believe so.
Okay, but you weren't concerned with him taking out his motorcycle?
Not really, no.
That was just a regular thing for you?
Yeah, he drives a lot.
You said you saw him bleeding from his head, right?
I noticed a wound. It wasn't gushing or anything.
Okay, but there was blood?
Yeah.
He said he was fine, right?
Yeah, he said he was okay.
And you said that you weren't going to poke the bear.
Yeah.
Did your dad get upset when you
No.
challenge him on things?
No, it's just, I mean, I know how I feel when I get upset. Sometimes I want to be alone. So I figured I'd leave him alone.
Does he get upset if he does something and he's wrong about it?
I don't think so, no.
But whatever was going on here, you weren't going to fight that, right?
Yeah.
Now, you said you heard the police come to your door.
Yes.
You never came downstairs.
No.
You didn't say, hey, my dad was drinking here, did you?
No, I didn't.
You didn't say, hey, there's a bottle of Jim Beam out back as well as an empty beer, did you?
Well, I didn't know it was there at the time when the police were there.
The police were at your house for quite a while, right?
Yeah.
Your dad was taken away, right? Is that a yes?
Yes.
And then they continued to stay at your house until a tow truck came to pull away his motorcycle, right?
Yeah.
And in all that time, you didn't think to ask
No.
what was going on?
No. I sit upstairs in my room.
You chose to stay out of it, right?
Yeah.
You chose to stay out of it until today, right?
Yeah.
This is the first time you're ever telling us what happened?
Yes.
You didn't call Menor Police after you knew your dad was arrested for driving under the influence and say, hey, actually, my dad was drinking at home. He wasn't drunk on his bike.
No, I did not.
You didn't show up to any previous court hearings to say, my dad was drinking at home. He wasn't drunk on his bike.
No, I did not.
You didn't go to Menor Police Department and drop off that Jim Beam and that beer bottle, did you?
No, I did not.
You didn't return my call last week when I tried to ask you what your testimony was going to be, did you?
I didn't see you called.
You didn't get a
But I
voicemail from
didn't.
me last week asking you to call me regarding your testimony?
I didn't see it, no.
Okay, you chose not to call me back and tell me this?
No, I did not.
Okay, so this is the first time that you're ever telling us that this is what happened.
Yes.
And you remember it really clearly.
Yeah.
Would you be surprised that the Browns played at 1 o'clock that week?
It was 4 o'clock.
Your Honor, we'd ask the court to take judicial notice that the Browns game was Browns versus Bengals at 1 o'clock at the Browns home stadium on October 20th of 2024.
Boom. Judicial notice.
Yes.
Objection to that.
How would I do that?
We can provide you with a printout from ESPN.com in order to do that. We just only have it digitally because this is the first we've heard the testimony.
Okay. Well, I'll consider that.
Okay.
I'll note your objection, Mr. Dean. I'll let you know whether I take judicial notice of that.
Thank you, Your Honor.
Did coverage start at 1 p.m.?
Do you think your dad was in the house from when you heard his bike pull into the garage to when you heard the police outside?
Probably about less than an hour.
Okay, but near an hour?
Yeah.
One moment.
Somebody do
I have
the
no further
research.
questions.
Somebody
Thank
do
you.
the research.
Redirect.
On the game.
Yes, Your Honor. How certain are you that the Browns game was at 4 o'clock that day?
I thought I was pretty certain.
Did you end up watching the game that day?
Yeah, I did.
Now, you were asked, how come you didn't go to the Mentor Police or anything like that? Did you know you were supposed to?
No.
Now, you're aware that this case was set, that your father was set for a trial for these charges on a separate case number last year, correct?
Yes, yeah.
And at that time, once I was retained as your father's attorney, were you made aware of that?
Yes.
Okay. And I interviewed you, correct?
Yes.
And is your story different today than it was when I initially talked to you over a year and a half ago?
No.
And did anyone from the Mentor Police look to investigate you or come talk to you?
No, nobody.
Okay. And if they would have asked your mother if you were there or if there was anyone else there and they wanted to speak to him, what do you think she would have done?
Can you repeat that?
If the Mentor Police had asked your mother if anyone else was there, do you think she would tell them you were there?
Yeah.
If she asked them, if the police asked her, will you come down and talk to us, would she have relayed that to you?
Yeah, she would have.
What would you have done?
I would have went down and talked to him.
Did you know that any of the things that she had asked you about why you didn't do them, did you know that you could do them?
I mean, yeah, I knew I could.
Okay. At the time your dad was taken away, what do you think he was taken away for?
Like I said, I heard one of the police officers say accident and can't leave the scene of an accident, so.
Okay. Did you know that it was a charge of operating a vehicle under the influence?
No, I did not.
At what point did you learn that that's what your father was being charged with?
After we had bailed him out of jail.
Do you know what time that was?
He ended up we tried in the morning and then he ended up getting out sometime in the afternoon, I believe.
You're talking the next day?
Yes.
So at what point did you learn that he was charged with operating a vehicle under the influence?
That Monday.
And at that point, did you feel the need to do anything at that point?
I figured he's going to lawyer up, and I didn't think I could change anything, so.
Okay. Did you even know that you could do those things?
No.
Nothing further on.
Recross?
No, thank you.
You may step down. Thank you. Next witness.
They haven't played at 4 p.m. since 2020 or before. It's always a 1 p.m. start. Browns v. Bengals. January 2026, September 7th, 2025, December 22nd, 2024, October 20th.
We had a witness scheduled that is not here, and I was unable to secure a subpoena service on him. But my client is going to testify and would like to testify in the way we expect the Minnesotans to do so.
All right, Mr.
All right.
Boyd, you understand that
Here we go.
you have a right to testify in this case if you want to?
Yes, sir.
You also understand you have the constitutional right to not testify if you do not want to?
Yes, sir.
And is it your decision that you wish to testify in this matter?
Yes, sir.
If you decided not to testify, then there could be no consideration given to that. That could not be held against you. Do you understand that?
Yes, sir.
But it is your desire to testify?
Yes, sir.
All right, step forward. Raise your right hand, please. You swear testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, have a seat.
All right. Never testify. That's what we learned. Never testify, right?
Dennis, could you please state your name and spell your last name for the court record, please?
Dennis Boyd, B-O-Y-D.
And you are the person who is charged in the indictment that we are currently having a trial on?
Yes, sir.
So you acknowledge that?
Yes.
Now, turning your attention to
Can you identify yourself in the
October
courtroom?
20th of 2024. What day of the week was that?
That was a Sunday.
When you woke up that morning, what was your plan for the day?
Just to watch the Browns game with my son.
And
4 o'clock one.
when you got up that day, did you make any other plans for the day?
Yeah, I got a phone call early in the morning.
Who did you get a phone call from?
A guy I used to work with heard another guy that we used to work with bought a wood chipper. I'm not a wood chipper, a stump grinder, I'm sorry.
Who called you in the morning?
Otis Moses is his name.
Okay, he's a
great
coworker
name.
or old coworker?
Yes, coworker.
What did he want?
He wanted to know if a guy by the name of Chris had a stump grinder. He bought a stump grinder, and I said yes. And he had some stumps to grind. We wanted to know if he'd be interested in grinding them.
Okay, and what was
Did he
your
have an
response?
axe to grind?
I said, I don't know, I have to call him.
Call who?
I'll have to call Chris.
Okay, did you call Chris?
Yeah, I called him.
Okay, and how'd that conversation go?
I just called him up and I asked him if he would be interested in going to Otis's to grind some stumps, and he said he would, but his stump grinder wasn't operating quite right.
Okay. What did he tell you at that point? What was the plan at that point?
He said if you wanted to come over and help him work on it, we could try to get it going, and if we get it going, we'll head on over and grind the stumps up.
Okay, did you relay that information to Otis?
Yes.
Okay, and based on those conversations, what did you do?
I just got ready and headed over to Chris's.
And that's Chris Bowers, correct?
Chris Bowers, yes, sir.
Okay. Do you know where Chris resides?
He lives over in Painesville.
Do you know his address?
No, I couldn't give you his home address.
Do you know how to get there and which house is his?
Yes.
What landmarks are close by his house?
He lives over by the Speedway, and there's a fire department over there.
By the Painesville Speedway?
Yes.
The Lake Dine and Dance?
Yes.
He's in that general area?
Yeah.
Okay. So how'd you get there?
Well, I took my motorcycle.
At this time, did you have insurance for your motorcycle?
I had it through September. So
Why
no.
only through September?
Pardon me?
Why only through September?
Because usually I wouldn't ride it in October, November, the winter months.
So you saved money on
Yeah, I
insurance?
saved money on it.
Okay, so you rode your motorcycle without insurance?
Yes.
Okay. Did you have a proper motorcycle license at that point?
No, I did not.
So you were operating that without the appropriate motorcycle endorsement?
Yes.
Did you have a temporary license?
Oh, I did, but it was expired.
So you had a driver's license with no motorcycle endorsement and your expired temporary permit?
Yes.
When did your temporary permit expire?
Well, it had been expired for quite a while. I can't give you exact month. I don't remember.
But you would continue to ride your motorcycle?
Pardon me?
You would continue to ride your motorcycle anyways?
Yeah, from time to time, yes.
So you go over to Chris's house. What do you guys do at Chris's? What did you and Chris do?
We just worked on the wood chip, the stump grinder, tore it apart, and then headed to the auto parts store.
Now, describe the wood chipper that you're talking about. How big is it? What's it look like?
Stump grinder? I would say it's at least 6 feet long, probably 4 or 5 feet wide. It's got a big wheel on the front of it. And carbide teeth are welded onto that. It's got a big engine. It sits on 4 tires, and it has controls on the back end.
Is it considered heavy machinery?
Yes.
Can it move itself forward and backwards?
Well, it has to be manually operated, but yes, it's got an engine on it.
Yeah, so if you put it forward, it will drive itself forward?
Right, yes.
And were you guys able to diagnose and fix the issues that the wood chipper was having?
Yes.
And what were those issues, and how'd you fix them?
We just tuned it up, basically, put new plugs, put air filter and fuel filter and new gas in it, and it's fired up pretty good.
So after you guys got it fired up pretty good, what was the plan?
I gave us a call and I told him, I said, hey, we got this thing going if you're still interested in us coming over.
Did he say yes?
Yeah, he said, come on over.
Okay. So what did you guys do with the wood chipper at that point?
Well, we had to get it back up on the trailer, so we loaded it back up on the trailer, hooked the dump truck up to the trailer, and we headed over.
Okay, and how did you guys, well, before I ask you that question, at this point being at Chris's house, did you guys have anything to drink?
No.
Okay. And how did each of you travel to Otis's house? Not the route you took, but how'd you get there?
Chris drove his dump truck and pulled the wood chipper. I mean, the stump grinder. I keep calling it a wood chipper. And I followed him on my motorcycle.
Speaking of you calling it a wood chipper, would that be because I referred it in size to a wood chipper when I was asking you to describe it to me?
Maybe.
Okay. Now with the wood chipper and you riding your motorcycle over there, where were you guys headed? Where is Otis's house?
He lives in Madison, over off of Meadow Ridge Road, I think it's called.
Meadow Ridge, you said?
Meadow Ridge, yeah.
Okay. And that's in Madison?
Pardon me?
Is that in Madison?
Madison, yes.
When you guys got to Otis's house, what happened?
We pulled in and he took us out back and showed us where the 2 stumps were, and we unloaded the machine and we got to work.
Now, while you guys, the entire time you were over at Otis's house with Chris, prior to leaving that house, did you have any alcoholic beverages?
No.
Why not?
Because I tell you, you don't want to be messing around drinking with this machine. You make a careless step and it could rip your leg off or kill you. It's very dangerous.
Okay. And how many stumps did you guys grind?
2.
Now, when you guys were done doing the stump grinding, what was the next step?
Do all the cleanup work.
Okay. And after the cleanup work was done, what did you guys do after that?
After we cleaned everything all up, we just loaded the machine back up on the trailer, put the chains on it, and that was that.
What was the plan for the three of you at that time?
Well, I was going home. Otis and Chris, I do believe, were headed to Otis's sister's place to grind a stump.
Did they ask you if you would accompany them?
Yeah, they asked, but I said no. I said I'm going home.
Okay. And at that point, do you know approximately what time it was?
I don't. I'm going to say 3-ish.
Okay. From that point at Otis' house on Middle Ridge, do you know his address by chance?
No, I can't give you his
but you know
mailing address or.
You know his house and where it is?
Yes.
Okay. So what route did you take to get from Otis' house to your house?
Straight down Middle Ridge to 20 to 2 over to Heisley.
By Heisley, you mean 44?
44, yes.
Okay, you would take 44 north at that point?
Yes.
Did you make any stops?
No.
While you're riding your motorcycle, are you able to have a drink holder or anything like that?
No, I don't have anything like that on my bike.
Did you have any alcoholic beverages on your ride home?
No.
So you're taking that route home, you're on Route 2, and you're getting off at 44 north, correct?
Yes.
Okay. Tell us about that drive on 44 north.
Well, I just made the right onto 44, and I was following a couple vehicles. Traffic was fairly light that day, I thought, and all of a sudden, I took my eyes off the road for a split second, and traffic came to a screeching halt right in front of me. And
why'd you take your eyes off the road for a second?
I don't know. I just glanced over to see what was going on over on the northbound lanes and southbound lanes rather, and
what were you looking at?
Just some construction going on. There's barrels that were out.
Okay. And when you looked over there, how long do you think you actually looked over there?
It didn't take, but I mean, a second or two maybe. I don't know. I just glanced over, just real quick.
When you brought your attention, can you hear me?
Yeah, I can hear you. I'm okay.
Can I keep my voice up? Would that help?
Yeah, thank you.
Okay. When you turn your attention back to the road, what was going on in front of you?
The traffic was at a dead stop in front of me.
And what did you do?
I hit the brake and cut the wheel as hard as I could, as fast as I could, and I ended up hitting the lady.
Okay. What part of your motorcycle hit that car?
It would have been the right-hand side.
Now, we saw the pictures of your bike before, and it had that. There's two right in front of where your feet are. There's two metal pipes on either side.
Yes.
The one on the right side appeared to be bent in.
Yes.
Is that where your motorcycle hit the vehicle? Or do you know?
It's hard for me to say what hit first. It happened so fast, but yeah.
What happened during the accident, as best you can recall?
All I saw when I glanced back was a big flash of light, really. And I remember kind of coming to. I wasn't sure if I lost consciousness or not, but I got up. I don't know how long I was down for, and I flew over the handlebars, is what I was told. Yeah.
Okay. When you were getting up from the ground, when you were on the ground and then you were getting up, what parts of your body hurt?
My head, neck, and shoulders. Basically my whole side. But what really hurt was my leg.
What do you think made contact with your leg?
I was assuming it was the vehicle.
Okay. And when you got up, what happened?
I was talking with the lady, and I asked her if she was okay, and she said, "Yeah, but you're not." And she said, "I'm going to call 911," or maybe she was on the phone with them.
Okay.
And I said, "You don't need to do that. I'm fine." And
what did you do at that point?
At that point, we had picked my bike up, and I kind of was staring at the bike a little bit, looking what damage done. I got on the bike and I took off.
Now, You know you're not supposed to leave the scene of an accident, correct?
Yes, I know that.
Did you identify yourself at that point?
He's admitting to
Pardon
everything
me?
but
Did you
alcohol.
identify yourself at that point?
No, I never said anything.
Why not?
She didn't, I guess I just didn't want to get in trouble.
Now, you didn't want to get in trouble for operating a vehicle under the influence?
No, I didn't want to get in trouble for operating a vehicle with no license and no insurance.
Now, you had a temporary before and it was long expired and you had never gotten your motorcycle endorsement that we talked about before, correct?
Correct, yeah, I failed the test.
Now, why would you be afraid of getting a citation for no motorcycle endorsement?
Because I had been in front of the municipal judge twice already for it.
What municipal court judge?
The Menor Municipal Court.
Judge Trevitz?
Yes.
Now, how many other citations had you had for that infraction?
Two other times.
Okay. Describe your first interaction when you resolved that case. You pled guilty, right?
Yes, I pled guilty for both of them.
What was the interaction with the court?
Well, the judge was understanding about it. I explained to him that I failed the test, and I went in. I had my temporaries by the time I went in to court. So he just, I think it was a fine.
Okay.
And then he said, he said, go get your motorcycle endorsement. I said, yes, sir, I will.
Okay.
Well, and then I got in an accident with a guy hit me. It wasn't my fault. And I went back in front of him for no motorcycle endorsement.
Based on that accident that you had, even though it wasn't your fault, you were cited with operating a vehicle without the motorcycle endorsement?
Yes.
Okay. And you went back to see the judge. How was that interaction?
I explained to him that I failed my test, and he said, listen, he basically told me, you got to get this motorcycle endorsement. And I said, I promised him I would.
Okay. And what was your takeaway from the interaction with the court at that point?
Don't come back in front of me here without another motorcycle endorsement.
Okay. And what was your belief as to the consequences of that?
Oh, I would I'd lose my license, my bike. It's hard to say what may have happened, but it wouldn't have been good. I know that.
Were you concerned about jail time?
Yes, jail time.
So when you were getting up and taking off, what was it that you were hoping to do?
Well, when I took off, I was hoping the police wouldn't find me. I was hoping to get out of this.
Okay. And what were the reasons?
Just for my
the insurance and
for my insurance and my motorcycle endorsement.
Now, when you picked up your bike, were you able to determine the level of damage from your quick review of the bike?
Yeah, I kind of checked it out real quick.
Okay. How long did that took? A couple minutes, couple seconds?
Yeah, just a few seconds, really.
Okay. And you got on your bike and drove away?
Yes.
Did you see anyone taking pictures of you?
No, I did not.
Were you aware that there were pictures of you at that moment?
No, I had no idea.
So the pictures that we saw today, you learned about that when we received discovery in this case?
Yes.
Or the information from the police department?
When the police were there, yes.
Oh, when they showed you at the house?
Yes.
Okay. Now, what route did you take to get home?
I got off at Lake Shore and made a left and went home.
Okay. You heard the officers say that it would only take about 5 minutes to get to your house. Do you think that's true?
Yeah, it's not that long. It's a couple miles, I'd say.
Okay, like just a few moments, minutes?
Yeah, it's not.
When you got home, what'd you do?
I got off, climbed off my bike. I opened the door and pulled my bike in the garage.
Okay, and what happened next?
Went in the house. I just went in the house and then.
But did you talk to your wife that day?
Oh yeah. I'm sorry. She did. Yeah, Debbie came in. She was out back. That's right. She came in. We talked for a few minutes.
Okay. And what did you tell her?
I told her I laid my bike down, and she asked me if I was okay, and I said, yeah, I'm fine, and that was really the extent of the conversation.
Okay, what did she do after you guys had that conversation?
She said, well, I'm going back outside to pull, she was pulling weeds,
Okay.
and she said, I'm going to be pulling weeds, and if you need anything, holler.
What'd you do?
I walked upstairs.
And where did you go when you entered the house?
I went right to the kitchen.
At that point, did you see your son?
No, I did not.
What was the first thing you did when you went to the kitchen?
I went right to the fridge and grabbed the bottle out of the fridge.
Bottle of what?
Pardon me?
Bottle of what?
There was a bottle of Jim Beam in there, bottle of bourbon.
And what did you proceed to do with the bottle of bourbon?
I threw it right back. I pulled the cap and I chugged down a couple swallows, and then turned around, grabbed the glass off of our bar, poured myself a glass.
And while you were drinking that first glass, did you see Tim? Or did you hear him?
I heard him. I heard him coming down the steps. I heard his door open and coming down the hall there.
Okay. At that point, how were you feeling?
I was in a lot of pain. My head was hurting, and I don't know if it was adrenaline or what it was, but I was shaking a little bit. I was in pain for sure, but wasn't feeling good.
Well, besides the drink you took from the bottle when you first took it out of the fridge, you poured yourself a glass. What did you do with that glass?
Oh, I slammed that right down.
Okay. What glass were you drinking from?
It's just a 12-ounce bar glass. We have a set of glasses there.
Okay. Did you mix the Jim Beam with anything?
No.
No ice, no mixers?
No, nothing.
It was already cold in the fridge,
You heard your son testify that he saw you have a drink and then he had a conversation with you. Do you recall that?
Yeah, he came down. He says, "Hey, what's up? And you all right?" And I said, "Yeah, I'll be fine." And that's when I spun around. I wasn't really paying much attention to him, to be totally honest with you.
Why not?
I was just kind of going over in my head what the heck just happened, how close to dying I just came, and he asked me if I was okay. I said, "Yeah, Timmy, I'm fine." Did you continue? There was nothing wrong with my son. I wasn't upset with him at all.
What were you upset with?
I was just upset with myself.
Okay. And what did you proceed to do based on the fact that you were feeling upset and physically in pain?
Drank. I decided I'd pour a couple more drinks and take it. That's about it, really.
Okay. So after you had that conversation with him, what did you do with the Jim Beam, the glass, and yourself?
Slammed down another drink, and I poured another one, and then I walked up to him in my bedroom.
Okay. Did you take the bottle and the glass with you?
Yes, I did.
Upstairs, what did you do?
I just sat on my bed and I was kind of reflecting on what the heck, how it all just happened, and I finished that drink, and then I went into our bathroom, which is a master bath, and kind of checked myself out. Got in the medicine cabinet, ate a handful of Advils, making sure that nothing was really that bad on me.
At that point, did you feel that you were injured?
I knew I was injured, but nothing that was super serious.
Okay, you thought it was something that you could just treat at home?
Sure, yeah.
So, after that, what did you do?
I took a shower.
Then when you got with the shower, what did you do next?
Pardon me, after my shower, I just threw a pair of shorts on, and then grabbed that bottle and glass. I poured myself a little drink, last drink, and I grabbed the beer on the way out. It wasn't my last drink. I grabbed the beer on the way out, and I went and had a cigarette.
So you're upstairs in your bedroom after the shower.
Yes.
At that point, you left your bedroom to come downstairs?
Yes.
Okay. And what did you bring with you?
I brought the bottle in my glass.
Okay. And you still had a little bit to finish?
Yeah.
And did you talk to Tim at that point?
No.
Did you know where he was?
No, I wasn't paying attention, to be honest with you.
Did you look in the living room to see that he was in there?
No, my back would have been towards him. I grabbed a beer out of the fridge and walked through our dining room right out the sliding glass door.
Were you outside by yourself?
Yes.
Did you interact with your wife at any other time?
Not until she called me. No, not until she called me and told me the police were there.
Okay. Now, when she called and told you the police were there, how'd you feel about that?
I was a little surprised. I was kind of shocked, to be honest with you.
Because you didn't think they would be able to locate you?
No, I didn't. I wasn't thinking straight at this point, but I never thought cameras or anything like that.
Now, when she told you the police were there, how did you feel about your level of impairment?
Pretty high. I mean, alcohol was kicking in pretty good.
Okay, was it making you feel better?
Yeah, I wasn't. Yeah, right. It was. I guess that's a way of putting it. Yeah.
When she told you the police were there, what did you do?
Sort of shoot. And I said, let me go get dressed. And I walked into the bedroom. I pulled my shorts off, threw a pair of jeans and a t-shirt on.
Is that why it took you a minute and a half or 2 minutes to come down and answer the door?
Yeah.
Okay. When you came out to see the officers, they asked you some questions and you were able to see the interaction on the video. And you've seen that before, correct?
Yes.
Were you truthful with the officer?
No.
Why not?
Because I was hoping, I had no idea that they had pictures. I had no idea they saw my bike in the garage. But I was just hoping they would say, okay, and leave.
Okay. How come you didn't tell them that you hadn't been drinking and that you would come home and started drinking?
Nobody asked, I guess.
Why'd you tell them you were at home drinking beer all day?
Because I just wanted them to think that I was home all day.
You wanted them to believe that you didn't drive your motorcycle?
Yes.
Because they had asked you that and you said you hadn't driven it, right?
Correct.
They showed you the picture and you still denied it, correct?
That's when I realized the jig was up, and I just denied everything from that point on.
Okay.
I realized the jig was up, and I stuck to it.
They could tell that you weren't being truthful.
Yes.
And you knew you weren't being truthful, correct?
Yes.
Okay. And at that point, they'd asked you to do field sobriety tests. And you said yes, correct? Remember that?
Could you repeat that, Tim?
When they took you down by taking you to their police cars, they were asking you to take field sobriety tests, and you agreed, right?
Yes. I started it, and I just refused it after that.
Why?
Because I knew I wasn't going to pass it.
Why wouldn't you pass it?
Because I just drank a whole lot of booze in a short amount of time.
Okay. Were you feeling the effects of the alcohol?
Yes.
As you were in the custody of the police officers over the course of time and at the hospital, how was the alcohol affecting you?
I don't really remember too much of the whole hospital. I can remember bits and pieces of it.
Do you remember traveling to the Mena Police Department?
Yes, I do.
Do you remember what happened at the Mena Police Department other than the video we just watched? The ambulance? I remember riding in the ambulance, yes. At what point did your recollection get foggy?
During the ambulance ride, I would say, I don't really remember getting to the hospital, if I was wheeled in or...
Why do you believe you don't recall that?
I don't know if it was my head injury or I drank too much, or the combination of both, I guess.
Think the alcohol was catching up to you?
Yes.
Okay. How come you never told the officers about your drinking when you were at home prior to them arriving?
I don't know. I just clammed up, I guess, until I don't know. I just shut up, I guess, and until I talked to a lawyer. I knew I was in trouble.
You knew you'd already lied to him and you didn't want to make it worse?
Yeah, exactly. Right.
Okay. Thank you, Dennis. No other questions?
Russ?
Thank you, Your Honor. Hi, Mr. Boyd.
Hello.
All right. You have a valid driver's license, don't you?
Yes.
And you had a Ford 150 sitting in your driveway?
Yes.
Your son said that's your car?
Yes.
You could have driven that
Yes,
morning out with your buddies, right?
Yes, I could have.
Could have been beneficial, in fact, when you're dealing with a stump grinder, right?
Well, I don't know if it beneficial would be, but I mean, I wasn't using my truck for anything.
But you chose to drive your motorcycle that morning, right?
Yes, I did.
You chose to go out there on the open roads without a helmet,
Yes.
right? And you chose to go out there knowing that you didn't have a valid motorcycle license, right?
Yes, I did.
And that's because you never passed the test?
Yes.
So you started your day off by doing something illegal, right?
Yes.
Now, you testified that stump grinders are pretty dangerous.
Yes,
right?
they are. Yes, they are very dangerous.
Don't want to drink and use a stump grinder?
Pardon me?
You don't want to drink and use a stump
No, you
grinder?
don't. No.
But you also have that motorcycle, right? A motorcycle's dangerous,
Yes.
right?
Yes.
If you use a stump grinder when you're drinking, you might get hurt, you said?
Yes.
You might lose a limb, right? Is that what you said on direct
Yes.
examination?
Yes.
You might sustain a serious injury,
Yes.
right? Now, if you're on a motorcycle and you've been drinking, you also might sustain a serious injury, right?
Yeah, sure.
You might get hurt, right?
Sure.
You might not be as attentive as you should be, right?
Yes.
You might be distracted, right?
Yeah, you could just keep going on and on. Yeah, it's if you're drinking it, everybody knows it's a bad idea.
Okay, and you might not have the reaction times that you need to stop, right?
Yeah, I guess you could. Yeah, you could say that. But there was no reaction time. The lady even said there was nothing he could do about it.
But Mr. Boyd, it might make it harder for you to react. You might be slower if you've been drinking while operating a motorcycle, right?
Ma'am, there was no reacting to this.
I'm not asking about this particular situation.
Oh, yeah, okay. I see. Yeah, I see. Yeah.
It makes your reaction time slower,
Okay.
right?
Yes, I'll agree with that.
And that's why it's dangerous to drink and operate a vehicle.
Sure.
Right? Because there's other people on the road that we need to keep safe.
Yes.
Now, you stated that you looked away from the road for a second or two.
Yeah, just a split second, yeah.
And then you crashed into the back of a Jeep,
Yeah,
right?
I looked back and traffic was at a stop, yes.
But the traffic that you hit was in front of you, right?
Pardon me, can you repeat that?
You just said you looked back and traffic was at a stop.
No, what I meant by that, I looked back on the road.
So you looked behind you and next thing you know...
No, I didn't look behind me, I looked forward. I took my eye off the road to the left and I looked back on the road.
Okay, you turned your attention to in front of you.
Yes.
And
In front
hit a
of me.
Jeep.
Yes.
You flew off your bike.
Yes.
You don't know if you lost consciousness,
Correct.
but you got pretty hurt, right?
Yeah, I was hurt, yes.
The other drivers came out and they said, "Can we help you? Are you okay?" Right?
Yes.
They were worried about you,
Yes.
right? But you said, "Don't call 911," right?
I said I don't need any help. You don't need to call 911, yes.
Okay,
That's
you
what I
heard
said.
Ms. Clapp testify that all you said was, "Don't call 911."
So, yeah, is that what she said? Is that how she testified it? Or did it?
Okay. You didn't give me your name?
Nobody asked me. I never thought to give it to him, no.
You never thought to give it to them because you didn't want to get caught,
Yes.
right?
Yeah, I didn't think about it.
You didn't tell them your name on purpose, Mr. Boyd.
There wasn't all that much thinking to do. I didn't really think about it.
But the thinking you did was to think to leave, right?
Yes.
It was to think, I can't get caught here, right?
Yes.
It was to think, I can't get caught now, right?
Correct.
It was the police can't find me in the state that I'm in here at 3:20 p.m. on Route 44.
No, not the state that I'm in. I wouldn't go that far. I wouldn't say that. I would say, well, without a license and a motorcycle endorsement, without insurance and a motorcycle endorsement.
So you decided to get on your bike and just drive away, right?
Yes.
And you truly thought that there would never be any repercussions from this?
Like I said, I didn't give it much thought. It wasn't like I sat there all day thinking about this.
But you made a split-second decision, right?
Yes, I did make it.
And that decision was made to protect yourself, right?
Yes, I guess so.
Wasn't to protect the person whose car you hit, right?
No.
Now, you told us that when you went back to your house, first you talked to your wife, right?
Yeah, yes, I did talk to
Out
her.
in the backyard while she was pulling weeds,
Yeah, she came into the garage when she heard me pull in.
and then you went inside to your kitchen,
Yes.
right? You said you went right to the bottle of Jim Beam and proceeded to chug a couple of swallows from the fridge.
Yes.
Then you grabbed a glass, right?
Yes.
Then you talked with your son.
No, then
Right.
I poured a drink, and then tilted it back, and that's when I heard Timmy coming down the steps behind me.
Okay, so then you talked to your son.
Then I talked
right?
to my son, yes.
Then you poured another drink, right?
Yes.
Then you went upstairs, right?
No, no, I drank that second one there in the kitchen.
But you poured another drink, right?
Yes,
and then
yes, I
took
did.
the bottle and the drink upstairs. That's what you testified to?
Yes.
And then you said you sat on your bed and contemplated what you had just done.
Yeah, I was just kind of reflecting over it, yes.
How long did you sit on your bed for?
Well, not until I finished that drink. Wasn't really paying attention to the time, to be honest with you.
Then you got in the shower, right?
Yes.
And the purpose of that shower was to clean the blood and road debris off of you?
And, well, sweat more than anything, wood chips, yeah, just clean up.
Okay. And you were bleeding pretty substantially from your head, right?
Not at that point, I don't think so. I was earlier.
Okay, there was blood on your face. You heard your son say he observed it?
Yeah.
But you wanted to wash that off, right?
Yeah, sure. I wanted to clean up, yeah. Why does anybody take a shower?
Okay. And then you said you went back downstairs,
Why does anybody take a shower?
Yes, ma'am.
continued to drink.
Yeah, when I walked outside, I continued to drink, yes.
Okay. And did you smoke a cigarette?
Yes, I did.
A whole cigarette?
Yes.
More than one?
I may have smoked two, I don't know.
How long does it take you to smoke a cigarette?
I don't know, a couple minutes.
Okay.
3 minutes, maybe? 4 minutes?
2 or 3 minutes?
Yeah, a few minutes.
Okay. Then eventually your wife says, Dennis, the police are here, right?
Yes, ma'am.
You heard your son testify that you drank 3/4 of a bottle of bourbon in all of that time, right?
Yeah, that's what I heard, yes.
Okay. Does that match your memory?
I didn't really pay attention to how much was in the bottle. I know there was at least a half a bottle in there.
Okay. Are you aware that from the time you collided with that Jeep to the time the Menor police were at your door, that was only 26 minutes?
Yes.
You're telling us that everything we just talked about happened in 26 minutes?
Was it? Yeah, I guess so. Yeah, I guess that's what I'm telling you.
Does that seem like a pretty short amount of time to do all of that?
Yeah, it does seem like a short amount of time, but it happened.
It happens. 3/4.
Now, when police came to your home, you had to change into a new outfit, right?
Yeah, no,
Because you were just in a pair of shorts.
Yes.
You came outside and they confronted you with what happened, right?
Yes, ma'am.
And they said, Dennis, you've been in an accident, right?
Yes.
And you denied that, right?
Yes.
They said, Dennis, have you been drinking, right?
Yes.
And you said, not much, right?
I said I was sipping on a beer, I do believe.
Well, we watched that body cam footage.
Yes.
The first time the officer asked
Oh,
if you'd
maybe,
been drinking,
yeah.
you said, not much.
Not much, yeah.
Right? Then, when the officer asked you, when's the last time you had had a beer, you said you were sipping on one when the police got there while you were watching the Browns game, right?
Yes.
So the Browns game was on when the police got there, right?
I don't know. I wasn't watching the Browns game. I was out on the deck.
You told the police you were watching the Browns game, though?
Yeah, yes.
And that was before 4 p.m.?
I don't know what time it was.
Do you remember the testimony that the police got there at
Yeah,
3:48?
I probably did tell them that I was watching the Browns game.
Okay.
I don't know what I told him.
The police asked you if you were injured, right?
Yes.
You didn't tell them that your leg hurt?
No.
You didn't tell them that your head hurt?
No, I didn't tell him anything.
You didn't tell them that you took a fistful of Advil and ate them before the police showed up?
No, I didn't tell him that.
And you didn't tell the police you chugged a bottle of bourbon, right?
Half a bottle, yes.
They were asking you how much you drank, right?
Yes.
And you didn't say half a bottle of bourbon.
No, I didn't tell him that.
The police, you knew they were suspecting you for OVI, operating a vehicle under the influence. And you didn't say, I drank bourbon at home, right?
No, I didn't want to admit to anything. I didn't want to admit to driving my motorcycle.
Well, police took you to do field sobriety tests, and you didn't say, I just chugged half a bottle of bourbon in the last 26 minutes, right?
No, I did not tell them that.
You were placed under arrest for OVI and didn't say, I chugged a bottle of bourbon in the last 26 minutes, did you?
No.
You said you didn't do the field sobriety tests because you knew you were going to fail, right?
Yes.
You didn't tell the police, I'm going to fail because I chugged half a bottle of bourbon in the last 26 minutes.
It's been pretty clear that he didn't tell them he drank a bottle of bourbon in the last 26 minutes.
Overruled. Let's move on from here, then.
Mr. Boyd, you didn't tell them when they placed you under arrest for OVI?
No, I didn't tell the police anything.
Mr. Boyd, you're aware that for an OVI, it requires that you drank and drove, right?
Yeah, I guess I'm aware of that.
And if you didn't drink and drive, then why didn't you tell the police that you didn't drink and drive?
Because it wouldn't have done me any good. You just open your mouth and you incriminate yourself. Not only that, but the police, you can ask, they weren't going to believe me anyhow.
But you told them you were drinking. Right?
I told them I was drinking at home. I wanted them to believe that I was at home the whole time.
So then why didn't you tell them the same thing that you're telling us today? If you were willing to admit you were drinking at home then, why is your story about drinking at home different here?
Because I don't know why. Didn't come up with I don't know, I just wasn't thinking right, I guess.
Because it's not the truth, right?
No, no. It is the truth. We had nothing to drink that day.
Oh, man.
Absolutely nothing. I was sober when I hit that lady.
Mr. Boyd.
Not one thing.
You were worried about getting a ticket for having no motorcycle endorsement, right?
Yes, ma'am.
And a ticket for not having insurance?
Yes.
You left the scene of a crash, so you didn't get a ticket?
Yes.
You hid your bike in the garage, so you didn't get a ticket?
That's where I park it, but I put it in the garage.
You denied being in a crash, so you didn't get a ticket?
Yes.
You told police you didn't know if someone else borrowed your bike, so that you didn't get a ticket?
I was intoxicated by the time the police got there.
But it was so you didn't get a ticket, right?
Stumbling and fumbling. Yes.
You denied that pictures were actually of you, so that you didn't get a ticket. Right?
Yes. Yeah.
You went home and chugged a whole half bottle of bourbon because you might get a ticket.
No, that's not right. That's not correct at all. I went home and chugged a half a bottle of bourbon because my head hurt, my back hurt. I wasn't thinking about the police coming to my house. I thought it was done and over with.
You didn't want anyone else to call 911, so you didn't get a ticket.
No, I wasn't going to the hospital. I wasn't hurt that bad.
But the police come when you call 911, right?
Why would somebody call 911 if you're not hurt?
911 is the number for all emergency rescue services, right, Mr. Boyd?
You're referring to my family members as not calling 911?
No, I'm referring to Miss
Clark. Oh, I'm sorry. Yeah, at the scene.
At the scene, right?
Yeah, at the scene. Yeah, that's why I did it. Yes, so I wouldn't get a ticket.
But Mr. Boyd, you also knew that you have a prior felony OVI, right?
Yes, I'm aware of that.
I have no further questions. Thank you.
You redirect?
Nothing further, Your Honor.
All right, you can step down.
Okay.
Any other witnesses?
Out.
Your Honor, what's the testimony of my client, the defendant you would rest?
Now they rest.
So let's come back. Well, how long are you going to be at Painesville Muni?
25 minutes, 30 minutes. If I can be back at, say, 1:30
35140.
Okay, and then we'll discuss your request that I take judicial notice of the Browns game, and you can respond to that, okay?
Thank you.
All right.
All right. Let's take judicial notice of the Browns game.
Stick around the courthouse or.
Let's take that judicial notice real quick. Well, we have a problem, folks. What we have here is failure to communicate. They've not come back. Let's see. 2 hours ago. Oh, it's this one right here. Here we go. Here we go. Found it.
All right, Tim Zabe, 23-931, 23-1255, violation of community control, violation 1. Failed to report May 1 and May 8.
This is
You
something
understand
else.
that charge?
This is a different one.
Yes, Your Honor.
Second, arrested by Painesville PD at May 9th, charge.
This is the wrong one. This is the wrong one. Where's the other dude?
Disorderly conduct.
They haven't come back.
Understand that charge?
Yes, Your Honor.
July 16th, charged with assault.
They haven't come back yet. Well, we'll do our poll. Meanwhile, we'll jump up to Thurston for a second.
Warrants, and then we're going to set a pretrial hearing for you.
Okay, thank you.
July 21st.
Oh, she's not happy.
At 8:30. You're going to get paperwork. You're going to get paperwork.
Right? I'll get
I'm
a
sorry?
text message.
Mr. Swenson, did you provide a good number for text message reminders?
Yeah.
I did, Your Honor. I put that in the chat.
All right. Yeah, we'll send you text message reminders. We'll mail you notice at the address you gave Mr. Swenson. That next court date's also going to be on the paperwork you get today.
Okay, okay. I just don't want to miss it.
Ms. Culbertson, so you do want your mail to go to Bremerton, or do you want it to go to the address?
Bremerton.
Okay. And okay. I provided that address to the court and then the phone number that she wants.
All right. But where just so we know, so where does your mother live?
She lives in Olympia at the 80th Avenue address.
Okay. But you use the Bremerton address for your mail?
Yeah.
Okay.
Because I don't always get my mail at their address, so I just get it for sure in Bremerton.
All right, we have a poll going right now.
All right, just so we've got it, that Maple View, your DOL address?
Maple View Drive, yes.
I turned off commands.
So that's the DOL address. All right, thank you, Ms. Culbertson. You're free to be taken back.
Thank you.
Your Honor, was she appointed to Pacific Point? I think I missed that.
Yes. Yeah,
Thank
Pacific
you.
Point. All right, there at the other Nisqually booth, I know it can be a little confusing with all the screens, and it's on mute there. If we can have Nisqually staff maybe unmute the gentleman there in the other booth. Yeah.
While we're waiting, Your Honor, numbers 2 and 3 on the calendar, David Erickson. I have 2 cases, one new, one old. The old case, according to my notes, would have closed due to age. The new case, City's wounded, is dismissed without prejudice. Thank you. Have that as well.
The update keeps failing, but that's why their commands aren't working too.
Nope. Sir, I think it sounds like we're unmuted now. Your name?
James Rice.
Mr. Rice. Okay. All right, Mr. Rice, looks like we're here for
matters, and unfortunately,
a warrant return on a missed compliance review hearing for a case you're on probation for malicious mischief. Also backed up to this, you're also on probation for a criminal trespass matter. Have you had a chance to speak with Mr. Swenson today?
No.
Would you like to?
Mr. Swenson's from Pacific Point Defense. Have you talked to an attorney today?
No.
We did, Mr. Rice, we did talk on the phone earlier.
Oh, okay.
Oh, wait. You? Okay.
All right, go ahead. I'm going to hear from Mr. Swenson next there, Mr. Rice.
All right.
Your Honor, we discussed the issue, which is treatment noncompliance. There's been no evaluation and no treatment. It's been difficult for Mr. Rice. He is lacking in resources. He's currently unhoused and doesn't have good contact information. I explained to him the importance of getting this evaluation done and where he can go to get that done. I am asking the court to give him another chance. We do have some additional time, additional jurisdiction here for him to get the evaluation done and get started on treatment before we're out of jurisdiction.
All right, thank you. All right, Mr. Rice, I'm going to hear next from the prosecutor who's here in the courtroom, Mr. Sharp.
Thank you, Your Honor. First off, the trespass case, that's case ending in 4793. It was set on as a backup today. City's not taking any action on that one, so I ask we just strike that here. We do have that malicious mischief case to address. However, City has previously moved to revoke probation based on that chemical dependency treatment requirement. There's no proof that's been complied with. He was sentenced back last July, so we're coming up pretty soon on a year of non-compliance. I point out that this isn't a simple substance possession case either. It's malicious mischief, damaging somebody else's property with a nexus to substance. So it is a community issue that he get that treatment done. City's asking for $1,000 bail. Point out that he's had prior warrants issued on both these cases. Additionally, he has 3.
All right. Sorry. We're trying to get back to this one because we've got. There I am. Got closing arguments now, but no verdict yet. Might come tomorrow. Is that possible? Skip forward a little bit until the judge shows up because ain't nobody got time for this. Even the court clerk who's just standing there. She doesn't want to stand forever. There we go.
Okay, Ms. Tuttle, you want to speak as to
judicial notice to the Browns game?
Again, your request to have me judicially notice that the Browns played at 1 o'clock on October 20th of 2024?
Yes, Your Honor. We would like the court to take judicial notice of that fact. We did send information from ESPN.com as well as NFL.com to the court by emailing it to Ms. Tomba. Evidence Rule 201 governs judicial notice and says that it must be a fact that is, one, not subject to reasonable dispute, in that it is prong to capable of accurate and ready determination by resort to sources whose accuracy cannot be reasonably questioned. Here, a sporting event through 2 major sources with documented historical data. They're in concert with one another. They agree that the game time was at 1 p.m. It's not a source that can be questioned. As far as the impact of that in the criminal case, ESPN. If this were a jury trial, the court would instruct the jury that it may but is not required to accept as conclusive any fact judicially noticed. So because we do have witness testimony that is contrary to the fact we're asking the court to take judicial notice of, the court as the finder of fact need not accept that as true, but we'd ask that the court take judicial notice in order to use that to determine the credibility of the witness and the frankness of his memory as to what happened here on the date in question.
All right, Mr. D.
That's an audio video.
That they would need a witness to testify about
box.
that because those aren't typically noted treatises or sources. They're entertainment websites, though I do know that they are accurate for the most part. I think they don't.
Well, isn't that the key, whether they're accurate or not?
Well, for the most part, I would say. I mean, for the fact that we don't have any evidence to the contrary. And I don't think that fact is necessarily germane to this case. The timetable seems to be what my clients recall is what they were going to end up doing. That it was 1 o'clock or 4 o'clock.
Well,
this happened before 4 o'clock.
Does it bear, whether it started at 1 or at 4, does that bear on the credibility of the witness?
I believe that that's something that it would be for the court to consider, but I don't think it's a major relevant fact relating to the underlying factual issues in this case. But I do believe that they would need to provide more certified sources for judicial notice.
Well, such as what?
an official Cleveland Brown website? Or an
That'll
NFL
take all
website?
3 seconds.
Well, Ms. Tuttle has provided me with ESPN.com. NFL.com is also a pro football reference website that says the same thing, a 1 o'clock start with a 3 hour and 19-minute conclusion. It's been made an important fact in this case from the standpoint of
credibility. If he says
Tim Boyd's testimony, they certain that game was at 4 o'clock, and that was the plan to sit down and watch that with his father, as opposed to 1 o'clock. So it does reflect on the credibility of Tim Boyd. So I will take judicial notice that that game started on October 20th, 2024, at 1 p.m. as opposed to 4 p.m., and I think Rule 201, and it fits well within subsection B of 201 that Ms. Tuttle has referenced, so I will take judicial notice of that start time of that game. Are we ready to proceed to closing arguments?
The state's prepared.
Your Honor, prior to starting closing arguments, I would renew my motion for Rule 29 for the record with the same argument.
All right. The motion is denied. Ms. Tuttle?
Ms. Bell will actually begin.
Ms. Bell?
And before I do that, I will just note for the record that we have hashed the evidence on the state's drive, and then we have hashed the evidence on the court's drive, and those hash values do match.
All right. Any issue with those?
Check the hash values.
Hash values, okay. Go ahead, Ms. Bell.
Thank you, Your Honor. The evidence presented in this case establishes beyond a reasonable doubt that the defendant, Dennis Boyd, committed each offense charged. The first being operating a motor vehicle under the influence, the second being operating a motor vehicle under the influence with refusal to submit to a chemical test, and then failure to stop after an accident. As we know, the case begins at approximately 3:20 on October 20th, 2024 in Menor Lake County, Ohio, when the defendant drove his motorcycle directly into the rear of Vanessa Clapp's SUV. Rather than remain at the scene, exchange information, or wait for law enforcement, the defendant did exactly the opposite. He told Ms. Clapp not to call 911, got back onto his motorcycle while bleeding from the head, and fled. This indicates consciousness of guilt. The evidence leaves no doubt that Dennis Boyd was the rider involved in that crash. The blood recovered from the roadway and the broken motorcycle mirror was analyzed by Kelly Reese at the Lake County Crime Lab and confirmed to belong to the defendant. Vanessa Clapp photographed the defendant before he left the scene. Police use that information to identify the motorcycle and trace it directly to the defendant's residence, and the defendant testified here today that that was him in that crash. Within less than 30 minutes of the crash, officers arrived at that residence. There they found the damaged motorcycle hidden inside the garage. They found the defendant freshly showered and changed into different clothing. Those are not the actions of an innocent person. Those are the actions of someone attempting to conceal evidence and distance himself from what had just occurred. When confronted, the defendant denied involvement despite the overwhelming evidence placing him at the crash scene. Again, his conduct demonstrated consciousness of guilt from the moment he fled the accident scene until the moment officers located him. The evidence of impairment is equally compelling. Officers observed the defendant smelling of alcohol and having bloodshot and glassy eyes. He refused standardized field sobriety testing and refused chemical testing after being advised of the consequences of the BMV 2255 form. And we saw that on Officer Hagen's body-worn camera. And then Patrolman Miller secured a search warrant for his blood. We heard from Marissa Solomon, the nurse who drew the blood. We heard about her experience, the blood draw kits that the hospital used, and how the procedure was followed. Then we heard from Tyler Meter from the Lake County Crime Lab, and he explained how those blood samples were stored, tested, and transported to Miami Valley for further testing, and how his results yielded that the blood was over 0.08. Now, the blood draw did happen 3 hours and 35 minutes after the crash, putting it outside that 3-hour statutory window. However, we heard testimony from Kylie Daniel of the Miami Valley Regional Crime Laboratory, and she explained the retrograde extrapolation analysis. Ms. Daniel explained how the defendant's blood alcohol concentration at the time he was operating the motor vehicle remained above the legal limit of 0.08. That scientific testimony was unrefuted. There was no evidence undermining the integrity of the blood sample, the testing procedures, or the scientific methodology employed. The scientific evidence confirms what the police officers observed and what the defendant's conduct demonstrated. And the conduct matters. Impaired drivers crash into stationary traffic. Impaired drivers don't call 911. Impaired drivers flee the scene. Impaired drivers refuse field sobriety test. Impaired drivers refuse chemical testing. Impaired drivers hide damaged vehicles, change clothes, deny involvement, and attempt to avoid accountability. Now, the Boyd family have told us a pretty fantastical story about what happened in that 26 minutes it took officers to get to the Boyd family residence. And we know that it takes about 5 minutes for the defendant from the scene of the crash to get back home. So in that 21 remaining minutes, the defendant and his son claim that the defendant was chugging Jim Beam straight from the refrigerator, pouring himself more glasses, having a beer, taking a shower, sitting on his bed and reflecting upon what he had just done, smoking a cigarette, which takes him a few minutes, taking a fistful of Advil. That is not reasonable. That is fabricated. That is not what happened. And it was the defendant's own words that he was hoping to get out of this and hoping that the police didn't find him, but the police investigated it and they found him. When all the evidence is viewed together, the crash itself, the defendant's flight, the photographic evidence, the DNA evidence, the observations of impairment, the refusals, the defendant's deceptive conduct, and the scientific testimony regarding his BAC, the conclusion is unavoidable. The state has proven beyond a reasonable doubt that Dennis Boyd operated a motorcycle under the influence of alcohol, and will ask that you find him guilty on all counts. Thank you.
Thank you, Mr. Deeb.
Thank you, Your Honor. Your Honor, on this day, with the game being at a different time, that was something that I had learned today. But going back to the date in question with the activities of Mr. Boyd, he was operating heavy machinery that day, and he would not do that if he were going to be operating a stump grinder. And stump grinders are heavy equipment, and they're quite dangerous. And there's safety precautions that need to be taken when you do that. He did arrive home. As he was driving, even the witness, Ms. Clapp, she testified that the woman slowed down for no reason and then abruptly just slammed on her brakes. Didn't come to a screeching halt, but came to a very abrupt halt where she had to slam on her brakes without a screeching stop to come to a complete stop, and a complete stop at that point. Mr. Boyd, while glancing just to look at some equipment over there and then glancing back in that brief moment, it just robbed him of the 0.2 seconds that you would need to even be able to possibly avoid this. But even with that, if he had glanced away, it would take a second to process that the vehicles in front of you are stopping for no reason. As you look at traffic, you see what's up there. If you see a crash or see stop traffic, you know the people in front of you are going to stop. This woman didn't have a reason to stop. She just did. And Ms. Clapp said he didn't have an opportunity to stop. She was there on scene. She's a public defender, so she's got experience. While she's not certified in anything, she had an opportunity to speak with him, didn't smell the odor. These are things that an attorney that in that field would know just because of doing so many cases. It's something you would think about, that there is, I don't see the odor, he didn't appear impaired, and he gave reasons for why he didn't want to be on scene. He had been to court twice with Judge Trebitz. Said the second time he was there with no motorcycle endorsement. He was very concerned about being back in front of him because there was incarceration, there was loss of his motorcycle he's concerned about, there's loss of his license. He's thinking about those things, and he did make a panicked decision without much thought on the scene. He had just hit in his head, he was in an accident. Well, he didn't feel he was that injured. It was very obvious from watching the video that the Menor Police Department and the Menor Fire Department were very concerned that they had an ambulance waiting because they knew that he needed to be addressed, and he did need staples at that point. When he denied everything, he came out, and when he was answering the questions of the officer, it's obvious that he hadn't thought about what he was going to say. The officer was just denying everything. He denied being out. I'd just been home drinking all day because he didn't want them to think he was out riding his motorcycle. Not because he was impaired at the time he was operating his motorcycle, but because he didn't have his endorsement, he didn't want to get in trouble or no insurance.
People leave the scene of an accident for any number of reasons. For being impaired. Being impaired does everything that the prosecutors say they do. But so does a number of other things. Someone being tired. Someone who's is going to be in trouble with their spouse. Their parents for having a vehicle. If they don't have insurance, people leave the scene of an accident all the time when they don't have insurance. Or for some other reason, if they have a warrant. There are a lot of reasons why people leave the scene of the crime, because they don't want to get in trouble, and they perceive, even in cases of failure to comply with an officer, where they leave when an officer gives them an order to stop, because they want to get away. Most people, it just compounds the problem. For this court is seen where people can just comply from the very beginning, not leave the scene of an accident, not run from an officer or come into contact with them, because they think, okay, I can get away with this. And they think about that in a split second. It ends up being one of the worst decisions, where they end up making things 15, 20, 30 times worse than it would have originally been had they just complied with the officers. Now, when people are upset, a lot of times they turn to alcohol. In this case, Tim testified he loved his bike. He was upset when he came home. I didn't want to poke the bear, which, yeah, if his father's upset, there's no point in him making him more upset and focusing on him. He just watched his dad. He took his statements at face value. He knew that it was something that he was going to keep an eye on, but, you know, my dad says he's okay. I'm just going to let it be for now, and we'll address it later if we need to. And he took his dad's word for it. But he did see his dad drinking alcohol. Dennis told you what he was doing. When people are upset for any number of reasons, they turn to alcohol to dull the pain, emotionally and physically. You see on TV, there's sort of, okay, drink this whiskey as an anesthetic or something along those lines. It denies everything. At that point, he just shuts down. He doesn't want to talk to him anymore. They start to do the field sobriety tests. He's already starting to feel the effects of the alcohol. And at that point, he just, okay, just going to get on cruise control and let them take me, because at that point, he didn't see the purpose behind arguing or fighting or speaking with them anymore. As far as Tim, the officers never inquired if there was any other people in the house. He was there. They had an opportunity to talk to him. He would have talked to him. Just at that point, he wasn't involved in it, and he wasn't going to be involved. And no one sought out his version of the events. He would have told them what happened. He would have told them what went on. Whether or not he went and told them everything afterwards, he didn't know that that was something he should have done or could have done or would have done, because this isn't something that is usual for him. So to say that he was operating the motorcycle under the influence is a stretch here, because the blood results that they receive at 5:53 or at 6:55 p.m. when the blood draw was taken, which was 3 hours and 35 minutes after the accident, he had a .177. We can see the video, and we see how he looks at 3:48 when he comes to the door from Officer Miller's body cam. Assuming that number to be correct, then we have no reason to disbelieve that that's accurate. It seems to be accurate, and I think we've all assumed that it is. That at that point, from that point on, he has not ingested another drink for 3 hours and 35 minutes. Now, at that point, in 3 hours and 35 minutes, he would have sobered up considerably. Yet he was getting worse, as they say when he was there. He was showing even more signs of impairment, showing that he was increasing at that point, which gives credibility to the fact that he was drinking at his home before then. And at that point, you see how he interacts with the officers. He's definitely, you can see that he's feeling the effects. He's even told you I was feeling the effects of the alcohol when the officers came, because he ingested so much so fast. And it would have been a crescendo that he's getting more drunk as he's with the officers, which goes to how he was not cooperative with them about doing certain things. He wanted to get a drink, wanted to take a leak. You know, the way he was talking to the officers on the scene, you could see that he was not absolutely hammered, which that .177 blood result, taking that back 3 hours and 35 minutes earlier, he would have been at God knows what level, but we see what he looked like from the videos. We see the body cam footage. At that point, he would have been just astronomically drunk if he had drank before the incident. He was operating the machinery, and he came directly home, and that was the opportunity that he had to do that.
That's assuming we believe he drank when he got home.
His reaction times were diminished if he were impaired at that point. But Also, people look away from the road for any number of reasons. In fact, we're required to look away from the road for certain reasons. You look on a side road as you're passing by. You look at driveways when you're going by. See, is someone pulling out? You know, you glance away for a split second. You look in your rearview mirror when you're driving a vehicle or a car. You look to your rearview mirror. You just look down for a second. Sometimes you look for 2 seconds because there's something there you want to see if there's a car coming up behind you. Ms. Clapp even testified that once she was coming to a stop and she realized that she wasn't going to hit that vehicle, she looked in her rearview mirror and she was focused on the motorcycle, and she said he didn't have time. It happened so fast, he didn't have time. And he almost was successful in avoiding her car. He just clipped the back corner, and there was nothing about any of the testimony to show that he was driving erratic. He was driving in a manner unreasonable for the conditions. He was driving behind her, and he just did not have an opportunity to stop based on the extreme abrupt stop that she was forced to make based on the vehicle in front of her. Based on the information, Your Honor, with the time involved, with the way the defendant looked, yes, he looks like he's impaired and under the influence when the officers are dealing with him. They say he has the odor of alcohol, which Ms. Clapp did not smell at all. And she said he appeared fine, that she didn't have any issues, didn't think that he was impaired at all. Not even a concern. If there was a concern, she would have mentioned that, or even a question about it, but she didn't. He was fine. So at this point, Your Honor, we believe that he did get impaired that day. He got impaired after he was operating his motor vehicle, and that the numbers that come from the actual blood draw at 6:55 p.m., if he were drinking all day, then the way the officers would have seen him, the way Ms. Clapp would have seen him, he would have been way too impaired to even operate a motor vehicle to have a number of .177, 3 hours and 35 minutes after 3:20. We believe that those numbers show that, yes, he was impaired at the time that they observed him and at the time that they took the test. However, it does not prove that he was operating a vehicle under the influence. So I believe that they cannot prove beyond a reasonable doubt that he was operating a vehicle under the influence. Unfortunately, we have to make the concession that he was responsible for an assured clear distance violation and leaving the scene of an accident without providing his information.
Yeah, driving without a license and no insurance.
In speaking with him, I told him that those are things that were really not going to be in question, and he's accepting of that. But operating a vehicle under the influence, he has not done. His prior, which he acknowledged, was in 2014, and there have been no issues whatsoever. In fact, on the 2 other prior incidents when he was cited with no motorcycle endorsement, there are no prior OBIs because they would have been felonies, and they would have been in the city of Menor. And Officer Miller and the other officers would have known that, and we would have the court record. And knowing that the city of Menor is not very lenient on multiple OBI offenders, if there was ever a question of that, then we would have had that knowledge. So he's driven his motorcycle on 2 other occasions, one of which he was hit. Based on the officer's observations, there was not a concern of alcohol, so he doesn't operate his vehicle or his motorcycle when he's under the influence. Compounding that with the operating heavy machinery, it gives credibility to the fact that on this occasion it was just a traffic accident, and he panicked, thinking, I can get away from this and save myself money, when in fact he compounded everything. While yes, it would have been beneficial to state the truth and tell him what was going on, and yeah, I came home, I was upset, and I drank a bunch, but he didn't have the opportunity to, or forethought to do that. He was really hoping that he wouldn't even come in contact with them, and with the head injury, it doesn't appear that that was affecting him, but it would necessarily affect him even to a slight degree. With the alcohol that he's admitted to drinking, we believe that that shows his thought process or lack thereof at the time. Your Honor, we believe that they have not proven beyond a reasonable doubt that at the time he was riding his motorcycle, he was operating that vehicle under the influence, nor any other jurisdiction between Madison and Menor would say that if they had seen him driving on the roadway, which he took major roads. So we ask the court to find him not guilty on the charge of operating a vehicle under the influence.
Thank you. Ms. Tuttle.
Thank you, Your Honor. Mr. Deeb discussed that there are safety precautions that need to be taken with heavy machinery. There are safety precautions that need to be taken with motorcycles. Those are heavy machinery in and of itself. You shouldn't drive a motorcycle without passing the test. You shouldn't drink and get on your motorcycle. People get hurt. The defendant didn't have the reaction time he should have had, and he was distracted while he was driving, and he drove directly into the back of another motor vehicle. And what he said when he was laying on the ground bleeding from his head was, "Don't call 911." That wasn't because he was scared to get a ticket. The defendant told us that he's dealt with his tickets before, that he's gone to the Mentor Municipal Court, he's pleaded guilty, and he's dealt with them. He was dealing with something bigger. He knew he was dealing with something more serious, and that's because he knew he was under the influence. The defendant and his son both testified today to some information stating a long string of events that the defendant performed in the time between when he got home and the time when the police were knocking on his door. That's the only time that we have unaccounted for here, is a maximum of 26 minutes. That call came in at 3:20 p.m., and at 3:46 p.m., Mentor police are knocking on his door. When I asked his son how long he thought that his dad was in the house doing all of these things, drinking half a bottle of liquor, going upstairs, going downstairs, going outside, downing a ton of liquid, he said he thought it was an hour. When I asked the defendant if he thought he did all of that in 26 minutes, he seemed surprised. He thought that was a pretty short amount of time, is what he said on the witness stand. But in reality, when we take the fact that the defendant also had to drive home from the scene of the accident, that took about 5 minutes, Mentor police testified. We're talking about really a 20-minute period here. It's not believable that the defendant consumed half a bottle of liquor, took a shower, smoked a cigarette or two, changed his clothes twice in 20 minutes. It didn't happen.
And a beer.
That's because the defendant was impaired at the time of the crash. He was already drunk when he got to his house. His blood was a .177 at the time of the blood draw at the hospital. Using our common sense, logic, and reason, which is what the law dictates here, that isn't the BAC of someone who chugged half a bottle of Jim Beam. That's the BAC of someone who drank, got on their motorcycle, got into a crash, and had their blood drawn 3.5 hours later. There's no testimony that supports Mr. Deeb's contention that the blood results would be a certain way based on the defendant's testimony. There was no expert presented by the defense. We can't consider that because there's no evidence as to how the defendant's story would look in his actual blood. What we do know is that if there were 4 unmetabolized drinks in his stomach at the time that he stopped drinking, his BAC would still be over a .08, and it would be well over a .08 in the testimony of Miss Daniel, who did a day or two's worth of mathematical calculations based on all of the variables that she knew and came up with this answer that's scientifically accepted and relied on in her field. Now, the defendant denied every single element of the crime, every single ounce of involvement in October of 2024. And today he's come here and he's taken partial responsibility. He said, well, that's me, but that's really about as far as he's willing to go. His story didn't make sense in 2024, and it doesn't make any sense now. If he was chugging a bottle of Jim Beam and not driving, he would have said that to police. But what he told the police was, I've been drinking beer all day. I'm sipping on one now, watching the Browns game. He told him a completely different substance, and he told him all day, rather than half a bottle of liquor in 20 minutes flat. He looked impaired. When the police arrived, he was slurring his words. He had glassy eyes. He was unstable on his feet. That's not something that just developed at the hospital. That's not something that just came to be 3.5 hours later. He was behaving impaired and looked impaired at the time that police were at his house, and the defendant told you he was impaired when he was at his house because he refused to take those field sobriety tests. He testified that I didn't take them because I would fail. And he knows that those field sobriety tests only matter if he was drunk when he was driving his vehicle. The defendant still did anything that he could to interfere with possible test results. He refused on the street. He refused in the hospital. He attempted to drink water for what that's worth to any sort of testing. He wanted to go to the bathroom when police told him not to. And he refused the blood draw even with a warrant. It took over 10 minutes, you heard the testimony, for them to get the blood draw even with a warrant for it. He wasn't cooperative and he wasn't compliant because he knew he was operating a vehicle under the influence at the time he caused that crash. He told us in his own words, he was hoping to get out of this and was hoping the police wouldn't find him because he knew he was in trouble. He knew that trouble was a felony OVI. At the end of the day, People don't leave a scene of the crime and then have a BAC of twice the legal limit by coincidence. It doesn't happen by accident. It's not a coincidence because the defendant was drunk when the police got to his home. And this crash happened because he was under the influence. When we look at the totality of the circumstances, the defendant's story is not reasonable. There's no other reasonable explanation for the facts and circumstances of October 20th, 2024 than the defendant was under the influence on that motorcycle, refused all chemical testing, and got into a crash and left the scene. We ask him to find him guilty on all 3 counts. Thank you.
All right, and we'll review the evidence that was submitted, and then I'll issue a decision after that.
All right. All right, so I don't think we actually get a verdict here. Like, I don't think they came back. Which means we get to end the day on that. You messing with us? We all want to know. We also didn't find out what happened to the moles. We didn't find out what sort of deterrent you use for moles. We didn't find out if the package ever arrived in the Thurston, Washington case. There's sometimes you just don't get the resolution you want. What a tease! It's just they haven't come back. It's reasonable to assume the judge came back as everyone was waiting. And it was just so short that they never went live. And if that's the case, we need you Ohioans to do a little digging, or maybe some of our mods. Will we start tomorrow with verdict music? We'll do some digging. We'll do some digging, see if we can find a verdict on this one. If it's been posted. We voted, so that's the truth. 77% of you said yes, he was as drunk as a skunk when he crashed his motorcycle. I will tell you that Browns game thing, that does make me doubt some of the story we've heard. So, all right. That's all we got. I'm sorry they haven't come back. It's time. It's 6 o'clock. We need to go home. You guys need to make dinner, have a bite to eat, hug the ones you love, all that stuff. Started this day with a bad decision. Yes. It was a welcome break. We might be picking up another case here soon. So it was nice to have a one day. Josh, you did well on this one, by the way. You did well. Good job. Sushi for dinner? I ordered caviar. It should arrive tomorrow. I didn't want to push it and have it arrive right on the day of the podcast. I will tell you, I am fairly certain that it's the most I will ever spend on a single item of food. Unless I'm buying like a cow for my freezer or something. Caviar is, they think highly of it. Now, about a third of the cost was just shipping. Because there's no way I'm spending that sort of money on caviar. I mean, you can spend thousands of dollars on caviar. You can spend hundreds of dollars on caviar. I did not. I found a budget one, local, in here in North Carolina. And I got the cheapest one they had available. And then had to pay $38 shipping. I wanted to keep the whole thing under $38, but anyway. We're going to do caviar testing, perhaps for the only time of my life during the podcast Thursday. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow. Tomorrow is Tuesday, and then Wednesday, I don't know, yeah. Podcast on Thursday. We'll see you then. Bye.